I'm alive to the fact that this court is on a constitutional duty. My Lord, the date for hearing was... I served that application from the Court of Appeal, difference to the Court of Appeal's directions. We cannot sit here and pretend as legal practitioners we do not know the practice of the Court of Appeal. The Court of Appeal is seized of these proceedings. This court is subordinate to the Court of Appeal. And I'm answering that issue as to no reason has been preferred to defer this judgment. The Court of Appeal being seized of those proceedings, which everybody here is fully aware. My friend has said, yes, he has been served. Everybody has been served. So we ought to give deference to that constitutional issue. The other issue raised is that, Your Lordship, there's nothing peculiar. There's nothing out of the ordinary from these consolidated petitions. Lanark Council, really, having looked at my petition, never having answered in that petition, Mutomi Thiankolu never filed a single sheet of paper in that petition, and he's appearing for the 10th respondent. Your Lordship, he cannot be heard to say that he has absolutely no reason to see what is peculiar. Your Lordship's you saw the peculiarity of that petition. Lordship, I'm not going to go. So that Your Lordship, the petitioner wants to be heard on merit because Article 25C says he should be heard and given that right to a fair trial. As I close, none of my learned friends here, when that petition comes up for hearing, should they ever remove from their pocket the res judicata card. None of you. My Lord, I say so because they are happy to have the judgment today. And I'm going to demonstrate there was no lawful impeachment. Constitutional threshold was never met, and I'm not delving into that. So none of them, my lords, none of them, no, Prof, please don't point a finger at me. None of them should be heard to say that my client's petition is res judicata. So that Your Lordship,
Mr. Pinanjay, we have given you enough time.
Yes, this is my last remark. This is my last remark. Since the Honorable the DR received this formal communication and was brought to the attention of this honorable court, I very believe this honorable court should have deferred to the Court of Appeal. And I said, we're not adjourning indefinitely. It's not open-ended. Even give me this afternoon, we'll be heard, and then you can render your judgment tomorrow. Thank you for hearing me.
Mr. Kinyanjui, this is the brief ruling on this matter. First of all, we want to note for record that the matter you are referring to is not before this court, either by way of a mention or a hearing or a judgment. Indeed, it is not before us, and we are not able to take notes on that matter. Secondly, because many people here may not know where you are coming from, you yourself sought to be deconsolidated in that matter. And we gave you the orders the way you wanted them. You took yourself away from these petitions. We have made a decision on that. You will not misrepresent facts. Listen, I'm making a ruling on this matter. The matter is not before us. The Court of Appeal has had or has cited that matter. If they wanted to stop us, we would drop our pens. give us a court order from the Court of Appeal, then we'll drop our pen. We don't have anything like that. Lastly, we gave directions the last time we were having this matter. We said that your matter will be mentioned after today's ruling. And for record, and this is the last comment we're making on this issue, your matter is coming for a mention on 18th of June, 2026. Parties before the court, are you ready to proceed?
Thank you very much, Your Lordship.
What time is it? I take it that parties are now ready to take judgment in the constitutional petition number E65 of 2024, consolidated with Nairobi petition number E550 of 2024, Nairobi petition number 570 of 2024, number E572 of 2024, Kerugoya petition number E013 of 2024, Kerugoya petition number E014 of 2024, Kerugoya petition number E015 of 2024, Nairobi petition number E522 of 2024, Nairobi petition E506 of 2024, Nairobi petition E509 of 2024, Nairobi petition number E525 of 2024, Nairobi petition number E528 of 2024, Nairobi petition number E537 of 2024, Nairobi petition number E541 of 2024, E567 of 2024, E576 of 2024, E586 of 2024, and E598 of 2024 between Honorable His Excellency Rigathi Gachagua petitioners Rigathi Gachagua, Thomas Kimotho Maingi, John Jerry Maina, David Munyi Madenge, Peter Gichobi Kamotho, Grace Mudhomi Mwangi, Clement Mchiri Murioki, Edwin Munene Karioki, Sharia Mtani na Shadrack Wambui, Father Eddie Waiguru, Anthony Mwithaga, Victor Gatia, Assumpta Wangui Mwiruri, Christine Mukami Njuguna, Peter Kimani Kioira, Alice Wamuhu Mbugwa, Mwangi Anyeki Mbugwa wa Mumbi, Kigo Kahari, Priscilla Wambui Gitari, Muchiri Ngatia, Maria Njeri, Eric Warui Mwaniki, Brian Hunja, Sarah Hubi, Margaret Wanjira, Samuel Njenga, Hebron Gakuru, Samuel Ngari, I accept, Council, that the parties are known. We can move ahead, and others versus the respondents. Speaker of National Assembly of Kenya, Speaker Senate of Kenya, Honorable Attorney General, and several others. This is the judgment.
For the sake of clarity, I believe the lead file in terms of the directions that this Honorable Court gave is E565.
Yes.
That is not quite what I heard.
Yeah, that is the lead file.
That is the position.
Yes.
Thank you.
This is the judgment. We have a 350 page judgment, and we'll try as much as possible to read it. Introduction and background. In the general election of 9th of August 2022, the first petitioner, hereinafter referred to as His Excellency Gachagua, was elected as the Deputy President of the Republic of Kenya alongside His Excellency William Ruto, whom we refer to as President. Their election was upheld by the Supreme Court, paving the way for their swearing in on 13th of September 2022, beginning what was expected to be a full constitutional term under Article 145, Sub-Article 1 and Article 148, Sub-Article 6. That expectation, however, was cut short following the successful impeachment proceedings against His Excellency Gachagua. The process leading to his removal commenced on 1st of October 2024, when Honorable Mwengi Mutuse, the 9th respondent and Member of Parliament for Kibwezi West constituency, we shall refer to him as Hon Mutuse, introduced an impeachment motion pursuant to Article 145 and Article 150 of the Constitution. The motion hereafter refers. The motion, referred to as impeachment motion, cited multiple grounds, including allegations of gross violation of the Constitution, incitement, and undermining government policy. The 11 grounds were as follows. Ground 1, gross violation of Article 10, Sub-Article 2A, B, and C, Article 27, Sub-Article 4, Article 73, Sub-Article 1A, and 2B, Article 75, Sub-Article 1C, and Article 129, Sub-Article 2 of the Constitution, and Article 147, Sub-Article 1, as read with Article 131, Sub-Article 2, C, and D of the Constitution. Ground 2, gross violation of Article 147, Sub-Article 1, and 152, Sub-Article 1 of the Constitution by undermining the President and the Cabinet and effective discharge of the national government's executive mandate. Ground 3, gross violation of Article 6, Sub-Article 2, Article 10, Sub-Article 2A, Article 174, Article 186, Sub-Article 1, Article 189, Sub-Article 1, and the fourth schedule to the Constitution by undermining devolution. 4, gross violation of Article 160, Sub-Article 1 of the Constitution on the institutional and decisional independence of judges. Article 5, Ground 5, gross violation of Article 3, Sub-Article 1 and Article 148, Sub-Article 5A of the Constitution, and fidelity to the oath of office and allegiance. Ground 6, serious reasons to believe that Rigathi Gachagua had committed crimes under Sections 13, Subsection 1A and Section 62 of the National Cohesion and Integration Act. Ground 7, serious reasons to believe that Rigathi Gachagua has committed crimes under Section 45, 46, 47, and 48 of the Anti-Corruption and Economic Crimes Act and Section 2, 3, 4, and 7 of the Proceeds of Crime and Money and Anti-Money Laundering Act. Ground 8, serious reasons to believe that Rigathi Gachagua has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Ground 9, gross misconduct under Article 150, Sub-Article 1B of the Constitution by publicly attacking and undermining the work of the National Security Intelligence Service and its officers. Ground 10, gross misconduct or insubordination by openly or publicly insubordinating the president, who is the head of state and government. Ground 11, gross misconduct by persistently bullying state and public officers. The impeachment motion was formally initiated before the second respondent, that is the National Assembly. In response, several constitutional petitions were filed in the High Court, challenging both the legality and constitutionality of the National Assembly's proceedings. These petitions, consolidated with Nairobi petitions, which I had mentioned earlier, were consolidated and are collectively referred to as the Cohort 1 petitions, with petition number E522 of 2024 designated as the lead file. 56, that was Cohort 1 petitions. Cohort 2 petitions, where these petitions belong, the lead file is 565 of 2024. On 8th of October 2024, the National Assembly passed the impeachment motion. Subsequently, the resolution was transmitted to the Senate. As the impeachment process unfolded, further applications were seeking conservatory release were filed in the High Court to restrain the Senate from proceeding with impeachment hearings. The Senate thereafter conducted its hearings and upheld 5 of the 11 charges against His Excellency Gachagua, as a result of which he effectively ceased to hold office as Deputy President of the Republic of Kenya. The Senate's decision was communicated to the public through a Gazette notice issued on 17th of October 2024. Following the impeachment, His Excellency President Ruto nominated Professor Kithure Kindiki, the second interested party, whom we shall refer to His Excellency Kindiki, to fill the vacancy in the office of the Deputy President. The National Assembly voted in favor of the nomination, and His Excellency Kindiki was sworn into the office on 1st of November 2024. As the Senate proceedings that culminated in the impeachment of His Excellency Gachagua were underway, and while the National Assembly was concurrently addressing the vacancy created in the office of the Deputy President, further petitions were filed in the High Court at Nairobi and Keregoya, including petition number 565 and several other petitions, being designated with petition number 565 of 2024 being designated as the lead file. Conservatory orders were initially issued restraining the swearing in of His Excellency Kindiki as Deputy President, but those orders were later lifted by this court in its ruling of 31st of October 2024, paving way for the swearing in as earlier stated. Thereafter, the pleadings were amended and Cohort 2 petitions proceeded for hearing, culminating in the present judgment. We will now proceed to summarize the parties' pleadings and submissions in the Cohort 2 petitions. Summary of pleadings and submissions. Submissions. His Excellency Gachagua is the first petitioner. His case is as follows. He anchored his case on the further amended petition dated 13th of August 2025, supported by his affidavits deposed to on 18th of October 2024 and 27th of October 2024. Speaking to the deficiencies in the process before the National Assembly, His Excellency Gachagua deposed that the impeachment motion lacked the particularization and specificity required under Article 145, Sub-Article 1 and Standing Order number 64, 1A. He took issue with the lack of credibility in respect of the charges against him in the National Assembly and the Senate. As regards the constitutional imperative of public participation, His Excellency contended that the National Assembly's process was deficient in that the notice was unreasonably short and that it lacked adequate designated venues. It was his case that the exercise was biased, with organizers framing it as meant for invited members of specific parties. He stated that the process utilized unverified feedback forms that resulted in fictitious data. In alleging bias exhibited by the Speaker and Deputy Speaker of the National Assembly, His Excellency deposed that they made partisan statements and also failed to recuse themselves despite having conflict of interest as they were signatories to the coalition agreement that formed a substantial part of the evidence. It was his case that the Senate violated Articles 145, Sub-Article 3 to Sub-Article 6 by skipping the appointment of a special committee to investigate the charges against him, thereby denying him a crucial layer of fair hearing. He stated that Senate imposed an unconstitutional 10-day deadline on the plenary proceedings and unlawfully permitted the National Assembly to introduce new evidence by ambush. He was emphatic that the Senate violated his right to a fair hearing and dignity guaranteed under Article 50 and Article 28, respectively, when he was denied an adjournment. In further support of this position, Dr. Daniel Kibuka Gikonyo, a consultant cardiologist and founder of the Karen Hospital, saw an affidavit on 28th of April 2026 to confirm the medical status of His Excellency Gachagua on the day he was scheduled to defend himself before the Senate. Speaking to the key medical events, it was his evidence that on 17th of October 2024, at approximately 3 p.m., His Excellency Gachagua arrived at Karen Hospital with severe chest pain. He deposed that given his age and underlying risk factors including hypertension, history of diabetes, stress, he conducted ECGs and blood tests and recommended a 48 to 72-hour admission to enable close monitoring, further evaluation, and appropriate medical management. It was his evidence that he supervised His Excellency Gachagua's care until discharge on 20th of October 2024. Far from the impeachment process, His Excellency Gachagua impugned the subsequent nomination and approval of His Excellency Kindiki. He asserted that the process was rushed and there was no public participation despite the dictates of Articles 10 and 118 of the Constitution. It was his case that the clearance from the Independent Electoral Boundaries Commission, or IEBC, was null and void since the commission lacked commissioners, and as such, the Secretariat was legally incompetent to clear the nominee. Further to the foregoing, it was His Excellency Gachagua's position that His Excellency Kindiki was disqualified under Chapter 6 due to gross human rights violation, including abductions, extrajudicial killings during the Finance Bill protest when he served as Interior Cabinet Secretary. Finally, His Excellency Gachagua averred that His Excellency Kindiki was not a member of the UDA party for the requisite 3 months preceding his nomination, and it was his case that the National Assembly unconstitutionally metamorphosed the process into an election rather than an approval under Article 149, Sub-Article 1. For these reasons, His Excellency Gachagua sought the following reliefs: a declaration that the respondents have contravened the provisions of Articles 10 and 18, Sub-Article 1, Articles 10 and Article 118, Sub-Article 1 of the Constitution by initiating a process leading to the removal from office by impeachment against the petitioner without first putting in place adequate legislative and procedural measures for effective public participation. In particular, the Senate's decision was not informed by any input from public engagement. 2, a declaration do issue that the impeachment motion lacks the particularization and specificity required under Articles 145, Sub-Article 1 of the Constitution and Standing Order 64(1)A of the Standing Orders of the National Assembly, and is thus incapable of invoking the jurisdiction of both the National Assembly and the Senate under Articles 145 and Article 150. 3, a declaration that the resolution passed on 18th of October 2024 by the National Assembly purporting to impeach the petitioner pursuant to the provisions of Articles 145 and 150 and the communication dated 8th of October 2024 by the Clerk of the National Assembly to the Clerk of the Senate titled, in quote, Resolution of the National Assembly on a special motion on the removal from office by impeachment of His Excellency Gachagua, Deputy President of the Republic of Kenya, close quote, are both founded on a process that is inconsistent and in violation of the Constitution of Kenya and are thus both void and invalid. 4th, a declaration that for the purposes of impeachment of the President or Deputy President of the Republic of Kenya, adequate public participation must be undertaken in all the 290 electoral constituencies in Kenya, the diaspora constituency, and the 1,450 electoral wards where the presidential election takes place. Fifth, he sought a declaration that the period of 12 days provided under Standing Orders number 64, sub-order 2 and 6 of the Standing Orders of the National Assembly is grossly insufficient time for the National Assembly to facilitate any meaningful and reasonable public participation during the process of impeachment of the President or Deputy President of the Republic of Kenya. Thus, the standing order is unconstitutional insofar as it has the effect of abridging the time for public participation. 6, he sought a declaration that the proceedings before whole house plenary of the Senate of Kenya under Article 145 of the Constitution of Kenya are not limited or time-bound to 10 days, as would be if a special committee is appointed under Article 145, sub-Article 4A. He also sought in seventh prayer a declaration that the petitioner has right to fair administrative action under Article 47, right to fair hearing under Article 50, sub-Article 1 of the Constitution were violated on account of the petitioner being denied an adjournment occasioned by illness, thus violating his right to appear in person before the Senate of Kenya to be heard and present his case. He also sought a declaration that the National Assembly and the Senate, in their evaluation of the impeachment proceedings before them, failed to properly assess each of the specified grounds and determine if they collectively or individually constituted a gross violation of the Constitution, warranting voting to uphold the impeachment charges against the petitioner. Hence, the resolution of 8th of October 2024 in the National Assembly and the vote upholding the impeachment charges that of the Senate passed on 17th of October 2024 do not meet the threshold for impeachment set out under Article 150 as read with Article 145 of the Constitution. Hence, the same be and are hereby set aside. An order of certiorari to remove into this honorable court and quash the decision and the resolution of the National Assembly and the Senate made on 8th of October 2024 and 17th of October 2024 respectively, resolving to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, Deputy President, Republic of Kenya. At the ninth prayer, the petitioner sought an order of certiorari to bring up into this court to be quashed the resolution of the Senate of Kenya made on 17th of October 2024 to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, Deputy President, Republic of Kenya, on the grounds expressed in Gazette Notice number 13/400. He also sought at prayer number 11 a declaration does issue that the IEBC could not clear Kithure Kindiki without the involvement or approval of commissioners under Article 88 and Article 250, sub-Article 1 of the Constitution as read with Section 4 and Section 11A of the IEBC Act. The purported clearance was therefore null and void. Further, the overnight clearance violated Article 10 of the Constitution on openness and transparency. At prayer number 12, His Excellency sought a declaration does issue that Kithure Kindiki is disqualified under Article 10 and 72 of the Constitution due to unresolved concerns from his tenure as Cabinet Secretary for the Interior and National Administration, during which Kenya endured gross violation of human rights. He also sought a declaration does issue that the National Assembly violated Articles 124 sub-Article 4 and Article 149 sub-Article 1, Section 6 of the Public Appointments Parliamentary Approval Act, Cap 7F, and Standing Order 45 in the method it adopted to approve Kithure Kindiki's nomination as Deputy President. He also sought a declaration that Kithure Kindiki was illegally appointed and procedurally cleared and unlawfully approved as nominee for Deputy President in violation of Articles 1 Article 10, Article 8, Article 118, Article 124, Article 137, Article 148, Article 149, and Article 250 of the Constitution, so that his appointment, clearance, and approval for that position is null and void. At prayer 15, he sought a declaration that the petitioner suffered harm and is therefore entitled to constitutional damages as compensation for the violations against him in terms of general damages, punitive and aggravated damages, security to be specified at the hearing, special damages under Gazette Notice number 10346 of 2023 for loss of 1, salary, 2, official transport and other prevailing transport policy for 35 months, medical cover and benefits detailed to be supplied, airtime, gratuity, and annual salary for 5 years. He calculated those sums and gave the figures. At prayer number 16, His Excellency sought pension and other benefits under the Retired Benefits Deputy President and Designated State Officers Act, Chapter 197B of the Laws of Kenya, being a monthly pension equal to 80% of the first petitioner's last monthly salary while in office. 2, a lump sum payment on retirement calculated as a sum equal to 1 year's salary paid for each term served in office. 3, 2 saloon vehicles of an engine capacity not exceeding 2,000 cc, which shall be replaceable once every 4 years. 4, 1 4-wheel drive vehicle of an engine capacity not exceeding 3,000 cc, which shall be replaceable once every 4 years. 5, a fuel allowance equal to 15% of the current monthly salary of the office holder. 6, full medical and hospital cover, providing for local and overseas treatment with a reputable insurance company for the first petitioner, the first petitioner's spouse, and the first petitioner's child who is below 18 years or is under 25 years of age and is undergoing a course of full-time education, and in the case of a female child, is not married or is not cohabiting with any person. 7, 2 drivers. 8, 1 personal assistant. 9, 1 accountant. 10, 1 secretary. 11, 2 housekeepers. 12, 2 senior support staff. 13, 2 cooks. 14, 2 gardeners. 15, 2 cleaners. 16, armed security guards, who shall be provided on the request of the first petitioner. 17, diplomatic passport for the first petitioner and his spouse. And 18, office and office equipment. 19, maintenance expense for the vehicles provided. 20, access to the VIP lounge 2 at all airports within Kenya. He also prayed for cost of this petition and such other reliefs as this court may deem just. In support of his claim, His Excellency Gachagua submitted, or rather in his submissions, he advanced his case further through written submissions dated 7th of October 2025, which were orally highlighted in court by his counsel, Paul Mute Senior Counsel, Elisha Ongoya Senior Counsel, and Mr. Ochiel Dudley, among others. The unifying premise of their submissions was that the impeachment proceedings were not purely political processes insulated from judicial scrutiny. Instead, they constituted constitutionally regulated proceedings subject to the supremacy of the Constitution, the doctrine of legality, and the supervisory jurisdiction of this court under Articles 23, 47, 50, and 165. Overall, they came up with the following issues for court's determination. 1, whether National Assembly motion met the constitutional threshold under Article 145. 2, whether the Senate violated Articles 145 sub-Article 3 to 6 by failing to appoint a special committee to investigate the charges. 3, whether the Senate, misled by its misinterpretation of Article 145, rushed the process and denied the petitioner a fair hearing. D, whether there was adequate public participation at both the National Assembly and the Senate. E, whether the speakers of the National Assembly and Senate were biased in reality or in perception. F, whether the overnight clearance and approval of a replacement of Deputy President evidence a predetermined process. G, whether Standing Order number 62 sub order 2 of the National Assembly is valid. And then lastly, what are the available reliefs? Collectively, the lawyers for His Excellency, the petitioner Rigathi Gachagua, collectively submitted that while Parliament undeniably possesses the authority to undertake impeachment, such authority is neither absolute nor immune from judicial review when allegations of constitutional violations, irrationality, or procedural impropriety arise. They characterize the proceedings as a politically engineered process disguised as constitutional compliance, submitting that Parliament specifically observed procedural forms while deliberately undermining constitutional substance, thereby necessitating judicial intervention to preserve the rule of law. Leading the charge on the constitutional standards of the process, learned senior counsel Elisha Ongoya anchored his arguments on constitutionalism and legitimacy within Kenya's presidential order. He submitted that the Constitution transformed governance from unrestrained political discretion to a system founded on constitutional limitation and accountability, which rendered all exercise of public power, including parliamentary impeachment, subordinate to the Constitution and amenable to judicial scrutiny. Describing the proceedings as an exercise in malicious compliance, he drew parallels to the historical trials of Socrates, Sir Thomas More, and Jesus Christ to demonstrate how processes can appear outwardly lawful while being fundamentally unjust and predetermined. He maintained that constitutional democracy depends on good faith, adherence to fairness, and constitutional morality, not merely technical compliance. In analyzing the text of Article 145 and Article 150, Counsel noted that the threshold language, gross violation, gross misconduct, and serious reasons prove impeachment is a mechanism reserved strictly for the gravest constitutional transgressions. To that end, Counsel drew the support from the cases of Mike Sonko, which we have, particulars we have given, Muya and versus Tribunal appointed to investigate the conduct of Justice Martin Muya. We have given citation. He used these cases to argue that grounds must be substantiated by cogent evidence to an intermediate standard higher than a balance of probabilities. Senior Counsel Ongoya further submitted that since impeachment directly interferes with the sovereign will of the electorate expressed through universal suffrage, courts could not abdicate their responsibility by treating it as a purely political immune process. It was his case that the grave consequences of removal brought the matter squarely within the High Court's supervisory jurisdiction, requiring it to interrogate whether Parliament met the heightened constitutional standards. Senior Counsel Paul Mute submitted on the democratic mandate and the political question doctrine. He was emphatic that impeachment in Kenya's presidential system is an extraordinary constitutional remedy of last resort. He distinguished Kenya's architecture from parliamentary systems where executive tenure relies on legislative confidence. It was his case that the deputy president derives direct democratic legitimacy from the electorate through universal suffrage and cannot be removed due to transient political dissatisfaction or partisan convenience. In view of the fact that impeachment effectively overturns the democratic will, it was Senior Counsel's position that the Constitution deliberately imposed strict procedures and substantive safeguards that courts are duty-bound to enforce. Learned Counsel drew support from the decision in Mike Sonko Mbuvi, which we have stated, to restate that the threshold for removal could not be reduced to political expediency. He further called to his aid the Court of Appeal decision in Martin Nyaga Wambora, we have given citation, to argue that judicial review of the proceedings affirmed constitutional supremacy rather than offend the concept of separation of powers. He firmly rejected the respondents' invocation of the political question doctrine, asserting that the Constitution creates no autonomous islands immune from accountability, and he maintained that all constitutional power remains subordinate to the judiciary's review. Learned Counsel Mr. Ochieng Dudley submitted on jurisdiction and the mandatory duty to adjudicate. At the outset, he pointed out an alleged internal contradiction in the respondent's case, simultaneously conceding the court's jurisdiction while urging it to abstain from exercising it. He submitted that constitutional adjudication could not be avoided simply because a dispute implicated political institutions or carried political consequences. He took the position that once allegations of procedural impropriety or rights infringements arose, the process ceased to be purely political. Drawing on the United States Supreme Court decision in Cohens versus Virginia, we've given citation, he argued that a court acts just as improperly when it declines constitutionally vested jurisdiction as when it arrogates jurisdiction it does not possess. It was his case that Article 165 imposes a mandatory obligation on the High Court to determine disputes whose constitutional violations are alleged as such. The judiciary would itself violate the Constitution by declining to hear politically sensitive questions. Mr. Ochieng submitted further that separation of powers does not establish institutional immunity and that judicial review ensures Parliament acts within its boundaries. Citing the Supreme Court advisory opinion in the matter of Kenya National Commission on Human Rights, Council concluded that constitutional interpretation in such disputes must be transformative, holistic, and purposive rather than mechanical. In the written submissions, His Excellency Gachagua specifically impugned ground 8 of the charges, noting that it relied on Section 132 of the Penal Code, a provision already declared unconstitutional in Robert Alai versus the Attorney General matter. On the right to a fair hearing, he maintained that the Senate violated his inalienable right by proceeding in his absence due to illness, contrary to Article 50, Sub-Article 2F and Article 25C. He drew support from Karaoke versus Attorney General, where it was argued that denying an adjournment impacting a citizen's constitutional rights warrants careful circumspection. He further submitted that the rushed manner of the proceedings mirrored the predetermined and unjust actions condemned in Olo versus Kisumu County Assembly Service Board and another, rendering the resulting decisions absolute nullities. Submitting on public participation and institutional incapacity, it was His Excellency Gachagua's case that both houses entirely failed the threshold. He referred to the decisions in Mohammed and 6 others versus County Assembly of Wajir and other cases which we have stated. To reinstate that engagement must be substantive, one that allows reasonable time and utilizes satisfactory mechanisms. In addition to the foregoing, His Excellency Gachagua, while drawing support from the Decision Independent Electoral and Boundaries Commission vs. Attorney General 2025, discredited the involvement of the IEBC, arguing that constitutional functions requiring commission approval could not be lawfully discharged by the Secretariat without a properly constituted commission. In their rejoinder submissions, the legal team also spoke to procedural illegality in plenary investigation. It was His Excellency Gachagua's submission that the Senate lacked a lawful resolution to appoint a plenary investigation. They submitted that the word may in Article 145, Sub-Article 3B, regarding the appointment of a special committee is a mandatory obligation, relying on a set of authorities including Sony Holdings versus Registrar of Trademarks and another. They submitted that courts routinely interpret may as mandatory to effect legislative intent, to effectuate legislative intent. Tracing the constitutional drafting history from the Guy and Bomas drafts to the Wako and Harmonas drafts, it was their case that it proved the framers consistently intended for a special committee to investigate charges prior to any plenary vote. In conclusion, His Excellency Gachagua drew inspiration from the Filipino Supreme Court in Sara Duterte versus House of Representatives. We have given citation to reiterate that impeachment processes remain strictly subject to the Bill of Rights to check grave abuses of discretion. Consequently, they urge the court to utilize its discretion as established in Imanyara and two others versus Attorney General to award damages for the constitutional violations to vindicate His Excellency Gachagua's right and deter future legislative infringements.
I will proceed from the second petitioner's case, that is Thomas Kimoto Maingi. Thomas Kimoto Maingi, the second petitioner in the consolidated petitions, filed a petition dated 25th September 2024 before the High Court at Kerugoya. The petitioner described himself as a former member of the National Intelligence Service, NIS, and contended that his constitutional rights had been violated by statements allegedly made by His Excellency Gachagua on 26th of June 2024 concerning the conduct of NIS during the Finance Bill 2024 protests. He averred that, having served in the NIS for over 20 years before retiring in May 2022, he was publicly associated with the intelligence service within his community, and that the remarks by His Excellency Gachagua portrayed NIS officers as incompetent and responsible for the unrest and loss of life witnessed during the protest. He asserted that the remarks exposed him to ridicule, hostility, threats, and psychological distress, forcing him to temporarily leave his home in Kirinyaga County and seek refuge in Embu County out of fear for his safety. Mr. Maingi further contended that the Attorney General, AG, failed in his constitutional duty as the principal legal advisor to government by failing to advise His Excellency Gachagua appropriately regarding the provisions of sections 24, 25, and 26 of the National Security Intelligence Service Act relating to complaints against the NIS. The petitioner alleged violations of Articles 10, 27, 28, 29, and 47 of the Constitution, claiming that the impugned statements amounted to discrimination, infringement of human dignity, psychological torture, and unfair administrative conduct. Consequently, the petitioner sought the following reliefs: that there be a declaration that the constitutional rights of the applicant as provided for under Articles 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. B, that the first respondent be ordered to issue an apology to the NIS members and staff for the utterances and or speech made on the 26th of June 2024. C, cost of the petition, and D, any other relief the court may deem. The second petitioner did not, however, file any written submissions. The third petitioner's case. Honorable Njeri Maina, the third petitioner in the consolidated petitions, filed the petition dated 2nd of October 2024. That was later amended on the 9th of October 2024 before the High Court at Kerugoya. She is the current woman representative in the National Assembly for Kirinyaga County. She stated that she brought the petition on her own behalf and on behalf of the residents of Kirinyaga County, and in public discretion as, and in public interest, Her petition also principally challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings commenced against His Excellency Gachagua. She contended that the public participation process undertaken by the National Assembly in relation to the impeachment motion was ineffective, inadequate, and constitutional, owing to the short notice periods and inaccessible venues. She took issue with the insufficient dissemination of information, defective response templates, lack of proper facilitation of members of the public, and the alleged failure by Parliament to comply with court orders directing constituency-level public participation. She further asserted that the impeachment process violated Articles 10, 47, 48, 145, and 150 of the Constitution and challenged the constitutionality of Standing Order number 64-2 of the National Assembly Standing Orders on the basis that it imposed an unconstitutional 7-day timeline for disposal of impeachment proceedings, thereby undermining meaningful public participation. Honorable Maina also questioned the legality of the Senate's decision to conduct the impeachment proceedings in plenary instead of through a special committee under Article 145, Sub-Article 3B of the Constitution, urging that investigation of impeachment charges could only lawfully be undertaken by a select committee of the Senate. In addition, she challenged the legality of the National Assembly as constituted, contending that it failed to comply with the constitutional 2/3 gender principle under Articles 27, 81B, 100 and 261 of the Constitution, and was therefore incapable of lawfully entertaining an impeachment motion. As such, Honorable Maina sought for the following reliefs. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th October 2024 regarding the special motion fell below the threshold of proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the modalities put in place by the first respondent in respect of the public participation forums held on 4th and 5th of October 2024, as ordered by this Honorable Court regarding the special motion, were in disregard of the court's orders and fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. C, a declaration that the impeachment process as against the first interested party undertaken by the first and the second respondents in view of modalities of public participation forums held on the 4th and 5th October 2024, failing well below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution, were unconstitutional and therefore void. D, a declaration that the appointment of a select committee by the Senate under Article 145(3)(b) of the Constitution is not discretionary in the impeachment of a president or deputy president in light of Article 259 of the Constitution. A declaration that any proceedings in regard to impeachment of the first interested party taken by the second and fourth petition respondents outside the select committee of Senate under Article 145, Sub-Article 3B of the Constitution are unconstitutional and void. F, a declaration that the first respondent is not legally constituted in light of the mandatory provisions of Article 27, 81B, 102, 61 of the Constitution on the 2/3 gender requirement. G, a declaration that the first respondent as currently constituted cannot entertain and deliberate the special motion for the removal of the first interested party by respondents. H, cost of the suit, and I, any other order or orders that this court may deem just. The third petitioner's submissions. Honorable Maina supplemented her positions by filing written submissions dated 9th of January 2026, and which she further orally highlighted in court. She identified the following issues for determination. One, whether the public participation exercise conducted by the National Assembly on the 4th of October 2024 met the constitutional threshold under Article 118 of the Constitution. B, whether the yes-no templates deployed by the National Assembly violated constitutional requirements for meaningful public participation. 3, whether the Senate violated Article 118 by not conducting public participation at the Senate stage. 4, whether the Senate violated Article 145, 3b by failing to appoint a special committee of 11 members. 5, whether Standing Order 64-2 prescribing a 12-day impeachment timeline is constitutional. 6, whether the impeachment process violated Article 50 on fair hearing protections. And 7, whether the impeachment proceedings were conducted by impartial officers as required by Article 50, sub-Article 1 of the Constitution. Honorable Maina submitted that on the 3rd of October 2024. Honorable Justice Mongo, a judge of the High Court sitting at Kariguya, ordered inter alia that public participation be undertaken at the constituency levels so as to accord the public an opportunity to engage and offer their representations. That these orders were duly served and were never appealed, stayed, varied or reviewed, and as such, they remain binding on the respondents, absolutely. Speaking to the obligation to obey court orders, Honorable Maina submitted that such obedience is foundational to the rule of law as was held in Law Society of Kenya and 3 others versus Inspector General of Police and 4 others reported in 2024 KEHC KLR. She submitted that this obligation extended even to cases where the person affected by an order believes it to be irregular or void, as was held in Refrigeration and Kitchen Utensils Limited versus Gulab Chand, Popatlal Shah, and others, the civil application number Nairobi 1339 of 1990. She further submitted that proper compliance required reasonable notice and not the same day or the next day notice. Physical accessibility at constituency level with open, identifiable venues in each of the 290 constituencies, facilitation of engagement, including civic sensitization, information, language diversity, disability access, and hearings as the primary mode, including oral and interactive engagement. Learned Counsel further submitted that the orders were not obeyed and only 200,000 participants countrywide who made up to 0.4% of the Kenyan population turned up for the exercise. Council decried the one-day notice published on a Saturday whose contents were vague as they referred to constituency offices without addresses and times. She also pointed out that no hearings were ever organized, no facilitation was provided, and that CDF offices were closed and the MPs absent. Honorable Maina submitted that she became aware of the purported exercise only past midday and that none of her counterparts within the Kirinyaga County were aware of the exercise. She further submitted that even the citizens who visited the constituency venues found them locked and no officials or staff were inside. It was submitted that the National Assembly faced a binary choice of obeying the Constitution through the court order or preserve Standing Order 64-2, which provided for 7 days deadline. They chose the latter, which Honorable Maina describes as contempt, dressed as obedience. That a legislative outcome obtained in defiance of a binding court order cannot stand in a constitutional democracy governed by the rule of law as discussed by Lord Denning in McFoy versus United States Company Limited, United Africa Company Limited, reported in 1961, 3 All England Reports 1169, where the learned judge held that, I quote, if an act is void, then it is in law nullity. You cannot put something on it and expect it to stay there. It will collapse, end of quote. Honorable Maina also took issue with the yes and no template as constitutional fraud as the National Assembly deployed a standardized template reducing 7 complex constitutional allegations into binary tick box questions. That citizens were asked whether they supported impeachment on each ground without being supplied with evidentiary material, explanatory memoranda, and His Excellency Gachagua's response, relying on the Supreme Court in British American Tobacco BAT versus Cabinet Secretary for Health 2019, which we'll hereinafter be referring to as the BAT case. She articulated attributes of meaningful participation to include clarity of the subject matter for the public to understand, structures, processes that are clear and simple, opportunity for balanced influence from public, commitment to the process such that views can influence outcomes, and inclusive and effective representation. She also listed integrity and transparency of the process and capacity to engage on the part of public, including sensitization of the subject matter. Honorable Maina admitted that the digital-only, English-only mechanism systematically excluded rural residents, the elderly, persons with disabilities, the non-English speakers, and the non-English speakers. She stated that there were no physical venues for explaining the template or receiving oral views, that were only in 10, that there were only 10 pictures of people attached as evidence of attendance for the 5th October exercise, and that they were contained and that they were conflated responses from 4th and 5th October without distinction, obscuring the impact of the court's orders. She identified that the template was not a procedural imperfection, but an endorsement mechanism designed to manufacture numerical support for a predetermined outcome and is therefore constitutionally void. It was her further submission that Article 118 imposes an independent obligation on each House of Parliament to facilitate public participation in its own business, that the Senate is not a subordinate appendage of the National Assembly, as was held in Speaker of Senate versus Attorney General, reported in 2013, where she stated that the Senate's role in impeachment is determinative under Article 145(7), as it performs a quasi-judicial function of the highest constitutional order. She held the position that the Senate could not constitutionally rely on the National Assembly's defective process, particularly where that process was conducted in defiance of court orders, that the Senate was aware of these defects as they were documented, litigated, and judicially acknowledged. Counsel submitted further that in Mwangaza versus Speaker of the Senate 2025, reported in 2025 Kinyalo reports, this court held that Senate must satisfy itself that public participation was adequate and satisfaction requires inquiry, assessment, and independent judgment, but the Senate undertook none. That the Senate conducted no public participation whatsoever, as no notices were issued, no invitations were extended, no hearings were conducted, and no submissions were received, and that this is not a case of inadequate participation, but a case of none at all. It was also her submission that Article 145, Subarticle 3B of the Constitution provides that the Senate may appoint a special committee comprising 11 members of its members to investigate the matter. On that, she submitted that the word may was a grant of power, not a license to bypass the Constitution, and that once the Senate had elected to proceed under Article 145, it must proceed within the architecture prescribed, which includes a special committee. She further stated that under Article 145, Subarticle 6, it provides that the Senate jurisdiction to vote is triggered only if a special committee reports that allegations have been substantiated and absent a committee report, the gateway to plenary determination was not opened. She also stated that the constitutional function of the special committee was structured investigation, not political debate, receiving, interrogating, and testing evidence, producing a reasoned report, and insulating investigation from the volatility of plenary politics. That Article 145, sub-Article 5 of the Constitution, guaranteed the Deputy President the right to appear and be represented before the special committee, and by bypassing the committee, the Senate extinguished an entire constitutional hearing stage guaranteed to the Deputy President, thus violating the non-derogable right to a fair hearing. Learned Counsel submitted that standing orders confirmed this distinction as Standing Order 79 on the Deputy President impeachment provided for a special committee, but no alternative. That Standing Order 80 of the Governor's impeachment procedure, impeachment expressly provides two alternatives, that is, a special committee or a plenary investigation. It was then posited that where the drafters intended to permit plenary investigation, they could have said so, and that the omission of the Deputy President must be respected. Learned Counsel drew parallels to Section 33(3)(b of the County Governments Act, which provides that the Senate may appoint a special committee in governor impeachments, and that the courts, including Wambora, have held that this confers discretion, and the Senate has lawfully proceeded in plenary. That those decisions underscore the opposite point, that where law expressly provides alternatives, discretion exists, but where the Constitution provides only one investigative pathway, the discretion does not extend to inventing another. She submitted that by proceeding to plenary determination without appointing a special committee, the Senate acted without jurisdiction, bypassed a constitutionally mandated investigative stage, and extinguished a guaranteed hearing right. She also submitted that Senate had collapsed constitutionally distinct phases into a single political exercise, and the impeachment proceedings were therefore unconstitutional, null, and void ab initio. It was a further submission that Standing Order 64(2) lay at the heart of the constitutional infirmity, as it imposed unreasonable timelines that rendered compliance with the Constitution impossible. Council invoked Article 2(4) of the Constitution, which provides that any law that is inconsistent with the Constitution is void to the extent of the inconsistency. She placed reliance on Orange Democratic Movement Party versus Speaker of the National Assembly, reported in 2024, where this court affirmed that standing orders cannot override the Constitution nor substitute the constitutional requirements of public participation as expounded by the courts. In that light, Parliament's invocation of good faith was faulted, it being argued that Standing Order 64(2) structurally precluded constitutional compliance. She submitted that where standing order made adherence to constitutional obligations impossible, such a standing order is itself unconstitutional. It was further submitted that Standing Order 64(2) embodied a deliberate parliamentary choice to prioritize political expediency over constitutional safeguards. By prescribing rigid timelines, it ensured that once an impeachment motion gained initial traction, the process would be driven to conclusion before public sentiment could evolve, before courts could intervene meaningfully, or before the affected office holder could mount an effective defense. Counsel argued that this was precisely what the Constitution sought to prevent, since impeachment is not a mere vote of no confidence, but a quasi-judicial constitutional process carrying grave consequences. On that basis, it was argued that this court should declare Standing Order 64(2) unconstitutional, null and void, to the extent that it prescribed timelines incompatible with constitutional requirements, and that any impeachment conducted under its terms is tainted with illegality from inception. On the question of whether His Excellency Gachagua was accorded a fair hearing, Honorable Maina submitted that he was hospitalized with chest pains on the eve of the Senate proceedings. Despite medical evidence of incapacity, the Senate proceeded with a hearing and voted, thereby violating the most basic tenet of the fair hearing rule, audi alterem partem, meaning no person shall be condemned unheard. Counsel further argued that the 12 days between service of the motion and the National Assembly vote were constitutionally inadequate, given that Article 50, Subarticle 2B, guaranteed the right to have sufficient time and facilities to prepare defense. His Excellency Gachagua, it was emphasized, faced 11 complex constitutional allegations, including gross violation of the Constitution, abuse of office, and corruption, for which 12 days was structurally insufficient. As the Supreme Court affirmed in Sonko case, which we referred above, impeachment proceedings attract the protections of Article 50, and where a fair hearing is denied, the process collapses. On the issue of bias and predetermination, learned counsel submitted that both speakers of parliament as presiding officers over the impeachment motion were constitutionally required to maintain impartiality, but acted contrary. It was argued that they assumed the role of initiators and proponents of the impeachment, thereby transforming into advocates for the motion rather than neutral arbiters. In particular, Speaker Moses Wetangula of the National Assembly was said to have participated in public statements endorsing the impeachment before presiding over the proceedings. Counsel emphasized that the test for bias is objective, where a reasonable, fair-minded observer would conclude that there exists a real possibility of bias, and submitted that the Speaker's public statements and advocacy for impeachment satisfied this threshold. Where the presiding officer is biased, she argued, the proceedings are fundamentally unfair, and the failure of the speakers to excuse themselves irredeemably tainted the process. For the above reasons, Honorable Maina urged the court to grant the relief sought in her petition. Next is the 4th to 8th petitioners' cases. The 4th to 8th petitioners in the consolidated petitions, that is Honorable David Munyi Madenge, Peter Gechobi Kamoto, Grace Modoni Mwangi, Clement Muchiri Muriuki, and Edwin Munene Kariuki, jointly filed a petition dated 18th of October 2024 before the High Court of Kenya at Kerugoya. They describe themselves as residents and leaders drawn from various constituencies within Kirinyaga County, and stated that they instituted the petition both in their personal capacities on behalf of their residents of their respective constituencies and in the wider public interest. The petitioners herein challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachagua, together with the subsequent nomination and approval process relating to Honorable Kindiki, relating to His Excellency Kindiki as Deputy President nominee. They contended that the public participation process conducted by the National Assembly on the 4th and 5th October was illusory, inaccessible, and unconstitutional. In particular, they pointed to the issuance of short and ineffective notices, lack of sensitization, inaccessible venues, absence of parliamentary officials at designated constituency sites, closure of the Kirinyaga Central CDF Hall, and the overall failure by both the National Assembly and the Senate to facilitate meaningful participation as required under Articles 10 and 118 of the Constitution. The petitioners further asserted that Senate unlawfully conducted impeachment proceedings in plenary instead of through a special committee under Article 145(3)(b) of the Constitution, and that the rash timelines imposed under Standing Order 64-2 of the National Assembly standing orders were unconstitutional as they curtailed effective public participation and the hearing and the fair hearing rights. They also alleged that the Senate violated His Excellency Gachagua's constitutional allegations. They also alleged that the Senate violated His Excellency Gachagua's non-derogable rights under Article 25C and 50 of the Constitution by refusing to adjourn proceedings on the 17th of October 2024, despite his hospitalization and medical emergency, thereby denying him an adequate opportunity to be heard. In addition, the petitioners challenged the legality of the nomination and approval process of His Excellency Kindiki as Deputy President nominee, contending that the process contravened Sections 3 and 6 of the Public Appointments Parliamentary Approval Act, Chapter 7 of the Laws of Kenya, for want of adequate notice and public participation. The petitioners then sought the following prayers. A declaration that the appointment of Professor Kithure Kindiki, the second interested party herein, as Deputy President of the Republic of Kenya is invalid, null and void. B, a declaration that the National Assembly as a distinct organ is required to undertake its own distinct, proper, effective and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to the impeachment of a president or a deputy president. C, a declaration that the Senate as a distinct organ was required to undertake on its own distinct, proper, effective and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to a resolution from the National Assembly to impeach a president or a deputy president. D, a declaration that the public participation as scheduled by the first and the second respondent on 4th of October regarding the special motion was not a proper and effective and meaningful public participation as envisaged in Articles 10 and 18 of the Constitution. E, a declaration that the extended public participation scheduled by the first and second respondents on 5th October 2024 was in disregard of the court orders issued by the High Court sitting at Kerugoya in constitutional petition number E014 of 2024, Honorable Jane Jerry Maina versus the National Assembly and 4 others, and was not a proper, effective and meaningful public participation as envisaged under Article 10 of the Constitution. F, a declaration that the impeachment process as against the first interested party was undertaken by the first and second respondents in view of the impugned, improper, ineffective and meaningful public participation held on the 4th and 5th October was unconstitutional and therefore void. G, a declaration that the failure by the third and the fourth respondents to undertake any public participation at all in regard to the impeachment proceedings in the Senate as against the first interested party renders the whole Senate impeachment process unlawful and void. H, an order of certiorari to bring up into this honorable court and quash the decision and or the resolution by the first and the third respondents made on the 8th of October 2024 and 17th of October 2024, respectively, resolving to remove the first interested party as Deputy President of Kenya by impeachment. I, a declaration that there exists no vacancy in the office of the Deputy President, allowing the fifth respondent to nominate anyone to fill such vacancy, and that any such nomination is unlawful and void. J, any other order or orders that this court shall deem just and expedient in the circumstances. K, cost of the suit. Next is the 4th to 8th petitioners' submissions. In their submissions led by counsel, Mr. Evans Ogada, together with Mr. George Sakimpa, the 4th to 8th petitioners identify the following issues for court's determination. A, whether the impeachment process complied with Articles 10, 118, 145, and 150 of the Constitution, whether the public participation conducted by the National Assembly and the Senate met the constitutional threshold of being meaningful, adequate, effective, and lawful. C, whether a standing order 64(2) of the National Assembly is unconstitutional for imposing rigid timelines that undermine constitutional safeguards. And D, whether Article 145 and applicable standing orders require that investigation into impeachment charges be conducted exclusively by a special committee of the Senate, not by the Senate sitting in plenary. They submitted that Article 10 binds all state organs, including Parliament, to the national values such as democracy, public participation, the rule of law, accountability, and good governance. That the impeachment process was conducted with severe haste and limited deliberation, undermining transparency, accountability, and public participation. They relied on the Supreme Court decision in Speak of the Senate versus AG and another reported in 2013, where it was held that Parliament was not exempt from constitutional discipline. They submitted further that Article 118 required Parliament to conduct business openly and facilitate public participation, and that this was not a formality, but a substantive constitutional obligation. They contended that the National Assembly gave the public less than 48 hours to consider complex, voluminous impeachment charges, which is a manifestly inadequate time frame, that no explanatory notes or responses from the Deputy President were provided, and that in some counties, like Kirinyaga, designated venues were inaccessible. They further asserted that the Senate conducted no independent public participation at all, as it relied on the National Assembly's deficient exercise, which cannot cure the constitutional breach. And they relied on authorities in Law Society of Kenya versus National Assembly of Kenya, 3 others, reported in 2025 KLR, National Assembly and another versus Okoit and 55 others, Civil Appeal number E003 of 2023, consolidated with others. This is the decision of the Court of Appeal. They also relied on the decision of Doctors for Life and and the decision in Legal Advice Center, and 2 others versus County Government of Mombasa. On the unconstitutionality of the National Assembly Standing Order 64(2), Learned Counsel argued that the provision imposes rigid and unreasonable timeline that make meaningful public participation impossible, and that while Article 124 empowered Parliament to make standing orders, such orders are subordinate to the Constitution and cannot defeat constitutional rights, and Article 24 voids any law inconsistent with the Constitution. The petitioners urged the court to declare Standing Order number 64(2) unconstitutional. As the matter in which the Senate proceedings were to be undertaken, Counsel submitted that Article 145(3) provided that the Senate must appoint a special committee to investigate impeachment charges, and that the use of the conjunctive "and" between sub-articles A and B makes the special committee process constitutionally inseparable from the investigative phase. That Articles 145, Sub-Article 4, Sub-Article 5, and Sub-Article 6 refer exclusively to the special committee, and that there is no mention of plenary investigation or under expresso inius est exclusio ulteriors, that excluded all other modes of investigation. The petitioners submitted further that the special committee ensued suppression of investigations and adjudicative functions, preventing bias and predetermination, and the Senate's decision to bypass the special committee and proceed in plenary fused investigation, hearing, and the judgment into a single political process, violating the hierarchical and sequential structure of Article 145. Learned Counsel placed reliance on Martin Nyaga, Wambora, and 3 others was the Speaker of the Senate. This is the Court of Appeal decision, where the Court of Appeal held that the removal of a governor, which mirrors Article 145, is hierarchical and sequential in nature. Council argued that the deputy president was denied a constitutionally prescribed procedural safeguard available to state officers facing removal, thereby violating Article 27 on equality and non-discrimination. They further submitted that Article 50, Sub-Article 1 guarantees the right to a fair hearing, which is expressly protected as non-derogable under Article 25C. Proceeding with impeachment proceedings while the deputy president was hospitalized and rejecting a reasonable request for adjournment amounted to a gross violation of natural justice. Council emphasized that fairness was the unassailable foundation of any removal process. In support, they cited Gachagua versus Speaker of the National Assembly and 3 others, High Court decision, where the High Court reaffirmed that the right to a fair hearing as non-derogable and that any violation renders the process null and void. Council concluded by submitting that the Constitution does not permit Parliament to sacrifice legality at the altar of expediency and urged this court to reaffirm constitutional supremacy and protect the sovereignty of the people of Kenya. The petitioners prayed for declarations and that the impeachment process violated Article 10, 118, 145, and 150. A declaration that Standing Order 64-2 is unconstitutional, a declaration that the Senate unlawfully bypassed the special committee, and orders quashing the impeachment resolution. We'll now proceed to the 9th petitioner's case. Sheria Mtaani na Shedrack Wamboi, a public benefit organization, filed the petition dated 18th of October 2024, together with a supporting affidavit sworn by Dorcas Mwai, an advocate of the High Court of Kenya, and a director thereof. The petitioner stated that it is established to assist members of the public in assessing justice, protecting constitutional rights, and promoting the rule of law, constitutionalism, accountability, and good governance. The petition challenged the constitutional and the legal validity of the impeachment proceedings, leading to the removal of His Excellency Gachagua from office as Deputy President, and further questioned the legality of the intended nomination and approval of His Excellency Kindiki as his replacement. It contended that the Senate proceedings conducted on the 17th of October 2024 violated His Excellency Gachagua's constitutional rights under Article 25C, 47, 50, and 45, Sub-Article 5 of the Constitution. That the Senate unreasonably declined to adjourn the impeachment proceedings despite being informed that His Excellency Gachagua had fallen ill and had been admitted at Karen Hospital, thereby denying him an opportunity to personally defend himself against the impeachment charges. It was further alleged that the Senate acted in breach of the constitutional requirements of fair hearing, procedural fairness, and natural justice by proceeding with the impeachment in the absence of His Excellency Gachagua, while allowing the proceedings to continue on the basis of strict constitutional timelines. It asserted that although the Constitution contemplated an expeditious impeachment process, the constitutional timelines could not override His Excellency Gachagua's non-derogable right to a fair hearing and adequate opportunity to defend himself. Sheria Mtaani na Shedrack Wamboi further complained that the proceedings before Senate were rushed, insensitive, and conducted in a manner that prioritized speed over substantive justice and constitutional safeguards. Additionally, the 9th petitioner challenged the legality of the subsequent process initiated by His Excellency the President to nominate His Excellency Kindiki as Deputy President under Article 149 of the Constitution. It was contended that the nomination violated Articles 82, 88, and 137 of the Constitution because IIBC was allegedly not properly constituted and therefore incapable of lawful verifying the constitutional qualifications of any nominee to the office of the Deputy President. Sheria Mtaani na Shedrack Wamboi also argued that His Excellency Kindiki's nomination contravened Article 137 of the Constitution on the basis that he remained a serving Cabinet Secretary for Interior and National Administration at the time of his nomination. For these reasons, the organization sought the following prayers. A declaration be and is hereby issued that the rights and fundamental freedoms of the interested party herein, to which his rights and fundamental freedoms under Articles 25, 50, 27, 47, 145 were grossly violated by the third respondent on the 17th of October 2024 for declining to grant him an adjournment on the Senate sitting deliberating on his removal from office by way of impeachment. B, a declaration does hereby issue that the decision by the third respondent to have the interested party removed from office by way of impeachment, to the extent that it was done in gross violation of Articles 25, C, 50, 27, 47, and 145.5 of the Constitution is, was unconstitutional to the extent of its unconstitutionality, and null and void ab initio. C, a declaration that any subsequent replacement of the interested party, if at all, to the office of the Deputy President of the Republic of Kenya was unconstitutional and therefore null and void ab initio. D, a judicial review order of certiorari does hereby issue to bring to its court, to this court, the decision of the third respondent as communicated via Gazette notice dated 17th of October 2024, communicating the removal from office of the Deputy President from the office by way of impeachment. E, a judicial review order of certiorari does hereby issue to bring to this court the decision of the President of the Republic of Kenya nominating His Excellency Kithure, His Excellency Kindiki as the Deputy President of the Republic of Kenya for the purpose of quashing and the said appointment, and that the said appointment failed the qualification for the Deputy President as provided for under Article 137(2) B and 3 of the Constitution. F, alternatively, this court be pleased to make a declaration that the appointment of the Deputy President by the President to fill in the vacancy arising from the removal of the interested party from office pursuant to Article 149 of the Constitution must be read together with Article 82 and 88 of the Constitution to give the IEBC its constitutional mandate to approve the name of the nominee as proposed under Article 149 of the Constitution. G, a declaration be made that the approval of Professor Kithure Kindiki or any other person as Deputy President of the Republic of Kenya is subject to Article 82 and 88 and 137 of the Constitution. Costs of the petition be provided, interest on one above at court rates till payment in full, and this court be pleased to make any further and other relief as it may deem fit in the circumstances. In respect of the 9th respondent submissions, led by Counsel Shadrach Wamoy, the 9th respondent identified 3 principal issues for court's determination. A, whether the nomination of a Deputy President can be legally finalized or approved in the absence of a fully constituted commissioners of the IEBC under Articles 82 and 88 of the Constitution. B, whether the Senate's refusal to grant His Excellency Gachagua an adjournment due to documented illness during the impeachment proceedings constituted a breach of the rights to a fair hearing and natural justice under Articles 25C, 47, and 50 of the Constitution. And C, whether the nomination of Honorable Kindiki while serving as a Cabinet Secretary is constitutionally infirm for violating eligibility criteria under Article 148 as read with Article 137. A learned counsel submitted that His Excellency Gachagua fell suddenly ill on the afternoon of the 17th of October 2024 when he was scheduled to defend himself before the Senate, and that the Senate rushed the proceedings and unreasonably declined to adjourn to allow him to recuperate. That the Senate proceeded with ex parte proceedings leading to his removal from office in his absence, which violated Articles 25C, 51, 47, and 145.5. The organization relied on the Supreme Court decision in Kidero and 4 others versus Waititu and 4 others, reported in 2014, which affirmed that fair hearing incorporates the audi alteram partem principle, and also referred to the Court of Appeal in Judicial Service Commission versus Mutapa and another reported in 2015, KLR, which held that rules of natural justice apply to all bodies exercising judicial, quasi-judicial, or administrative duties. It submitted that Senate has no prescribed time limitation for completing impeachment proceedings, and the rushing was unjustified. It was the organization's submissions that Article 148(1) requires that a person nominated as Deputy President must satisfy the requirements of Article 137 and 137(1)b, or 137, and that Article 137(1)b provides that a person is not eligible for nomination as President and by extension Deputy President if they hold any other state office, and that Article 260 defines state officer to include a cabinet secretary. It submitted that at the time of his nomination and parliamentary approval on 18th of October 2024, His Excellency Kindiki was serving as the cabinet secretary for Interior, and therefore he did not satisfy the constitutional eligibility criteria, rendering his nomination null and void ab initio. It was the organization's further submission that at the material time in October 2024, the IEBC was not fully constituted and it lacked the requisite number of commissioners, as the previous commissioners had resigned or retired. Articles 82 and 88 establishes a constitutional architecture requiring a lawful and fully constituted IEBC to oversee electoral and nomination processes, and that the Supreme Court in IEBC versus AG Advisory Opinion number 4 of 2024, reported in 2025, held that a clear distinction must be drawn between administrative continuity by the Secretariat and the exercise of constitutional authority vested in the Commission as a collegial entity. It submitted that the exercise of constitutional functions reserved for the Commission under Article 88, Sub-Article 4, cannot be lawfully discharged in the absence of a properly constituted Commission with the requisite quorum. It was further submitted that in the absence of commissioners, IEBC was constitutionally incapable from undertaking its mandated electoral processes, and that the approval of a deputy president nominee, the second highest constitutional office, is no less a substantive constitutional responsibility than the limitation of boundaries, and the same principle applies with equal force. The organization urged this court to apply Article 10 on the national values and principle of governance that brings all state organs, Article 20, Sub-Article 3b in the Dubia Pro Libertate doctrine, that where in doubt, the court ought to adopt the interpretation that most favors enforcement of a right or freedom enunciated in Jacqueline Okuta and another versus AG, High Court reported in 2017, and that it further submitted that the unconstitutional exercise of a legislative mandate cannot be shielded from judicial scrutiny, as was held in Commission for Implementation of Constitution versus National Assembly of Kenya and two others, 2013, KLR reported. In the end, the petitioner prayed that the petition be accordingly allowed. I now proceed to the 10th to 41st petitioner's case. That's yours. That's yours. Proceed.
Let me take the 10th to 41st petitioner's case. The 10th to 41st petitioners are a group of Kenyan citizens and one registered association, primarily from Central Kenya region. They filed the petition dated the 17th of October 2024. That was amended on the 18th of June 2025 and re-amended on the 16th of December 2025. They challenged the constitutional validity of the impeachment process and subsequent removal of H.E. Gachagua as Deputy President of Kenya, stating that the National Assembly and the Senate failed to comply with Article 152 of the Constitution, which requires them to modify the presidential impeachment procedure under Articles 144 and 145 for the Deputy President. They said that instead they applied the same rules under Standing Orders 64 and 65 for the National Assembly and Standing Orders 78 and 79 for the Senate without necessary modifications, ignoring that the Deputy President does not have the same powers, prestige, or legal immunities as the President. The petitioners aver that this failure rendered the entire impeachment process invalid, null and void ab initio, and violated the right to a fair hearing under Articles 25, 27, and 50. It was their further position that the impeachment was not a genuine parliamentary process, but was engineered, sponsored, and bulldozed by political and financial inducements to capture Parliament, turning it into a tool to remove the DP and settle political scores, thereby subverting the sovereign will of the people who elected the Deputy President in the August 2022 general election. They asserted that the President and the Deputy President were elected on a joint ticket and that the impeachment violated the rights of the petitioners and other voters from the Central Kenya region who voted for that joint mandate. The petitioners also highlighted and incorporated arguments from Nairobi High Court Constitutional Petition 356 of 2024. In that matter, it was alleged that both H.E. President Ruto and H.E. Gachagua had violated their oaths of office and the Constitution through various actions. Specifically, it was claimed that the President accepted foreign gifts valued at approximately Kenya shillings 240 million in the form of paid-for jet hire and fuel costs for a state visit to the United States, thereby exceeding the legal threshold permitted for such gifts. It was further alleged that the President entered into a secretive treaty with the United States to designate Kenya as a non-NATO ally without tabling the agreement before the National Assembly and Senate as required by constitutional oversight. Additional claims included intimidation and threats directed at members of parliament to bypass oversight, as well as inducement of political defections to artificially control the majority party coalition. The petitioners accused the President of using state violence to criminalize and suppress the Gen Z, otherwise read the Generation X good governance protests, as well as the July 2023 protests against oppressive taxation and the high cost of living, and that he distributed state appointments along acute ethnic lines. Additionally, H.E. Gachagua was faulted for publicly dividing Kenyan citizens into shareholders and non-shareholders in quotes, based on political alignments, whereas H.E. President Ruto is accused of spending hundreds of millions of public funds to conduct avoidable by-elections caused by appointing sitting MPs and senators to the cabinet. The petitioners further argued that the Kenya Kwanza Coalition Agreement binds H.E. President Ruto to nominate a replacement deputy president from the Gikuyu, Embu, or Meru communities, which is the same region as the impeached deputy president. They sought a declaration that the president's power to nominate a new deputy president was subject to certification by the IEBC, that the nominee meets qualifications under Articles 99 and 137, stating that the 14-day and 60-day timelines in Article 149 were meant to ensure public participation across all 90 constituencies. Consequently, the petitioners asked the court to declare the nomination and approval of H.E. Kindiki as the new deputy president as unlawful, null, and void. The petitioners thus sought the following reliefs from this court. 1. A declaration be issued to declare that the first petitioner was impeached by the National Assembly and removed by the Senate under a procedure that violated Articles 27, 50, and 150 sub-article 2 of the Constitution. 2. A declaration be issued to declare that the first and second respondents have violated the rights of the petitioners and other voters and residents of Central Kenya region by failing to govern together in accordance with their joint mandate secured during the presidential election held on the 9th of August 2022. 3. A declaration be issued to declare that the first petitioner was impeached by the Parliament under the respective standing orders of the National Assembly and the Senate that offends Article 150 sub-article 2 of the Constitution. 4. A declaration be issued to declare that the impeachment of the first petitioner was null and void ab initio on account of the violation of Articles 25, 27, and 50 of the Constitution, read together with Articles 144, 145, and 150 of the Constitution. 5. A declaration be issued to declare that the second and third to 14th respondents have conspired and schemed to remove the second respondent from office through impeachment in violation of Articles 1, 27, and 38 of the Constitution. 6. A declaration be issued to declare that the second respondent violated Articles 110, 118 and 150 of the Constitution in passing a resolution on 8th October 2024 to remove the second respondent from office. 7. An order of certiorari be issued to quash the resolution of the second respondent passed on 8th October 2024 to approve the motion of impeachment of the first petitioner tabled on 1st October 2024 by the 9th respondent. 8. A declaration be issued to declare that the 6th respondent's power under Article 149 of the Constitution to nominate a person to occupy the office of the Deputy President is subject to certification by the Independent Electoral and Boundaries Commission under Articles 99 and 137 of the Constitution. 9. A declaration be issued to declare that the 14 days period prescribed under Article 149 for the President to nominate a person to occupy the office of Deputy President is to ensure compliance with Articles 10, 38, 99, and 137 of the Constitution. 10. A declaration be issued to declare that the 60 days period prescribed under Article 149(1) of the Constitution for the National Assembly to vote on the President's nomination to fill the vacancy in the office of the Deputy President is to ensure compliance with the requirement of public participation in all the 290 constituencies in accordance with Article 1, 10, 27, 38, 118, and 136 of the Constitution. 11. That by dint of Articles 1, 10, 27, and 38 of the Constitution, the first respondent is bound by the Kenya Kwanza Coalition Agreement dated the 5th of April 2022 to nominate a qualified person from either of the Gikuyu, Embu, and Meru communities to fill the vacancy in the office of the Deputy President occasioned by the impeachment of the second respondent. 12. A declaration be issued to declare that the 6th respondent's nomination and of approval, therefore, by the National Assembly of H.E. Honorable Kithure Kindiki, the second interested party herein, as Deputy President is unlawful, null and void ab initio. 13. The Honorable Court be pleased to issue an order of certiorari to quash the nomination by the National Assembly of Honorable Kithure Kindiki as a Deputy President via Gazette notice published in a special issue of the Kenya Gazette dated 18th October 2024. And 14, a declaration be issued to declare that by dint of Articles 1, 10, 27, 38, 91, and 132 of the Constitution, the citizens of Kenya from the Gikuyu, Embu, and Meru communities have a right secured by the results of the presidential election held on 9th August 2022 to have one of them to occupy the office of the Deputy President during the tenure of the first respondent as the President of Kenya. 15, a declaration be issued to declare that Standing Orders number 64 and 65 of the National Assembly Standing Orders violates Article 152 of the Constitution. 16, an order of certiorari be issued to quash Standing Orders 64 and 65 of the National Assembly Standing Orders to the extent that they apply to the Deputy President. 17, a declaration be issued to declare the Standing Orders number 78 and 79 of the Senate adopted on the 16th of June 2024 violates Article 152 of the Constitution. 18, an order of certiorari be issued to quash Standing Orders number 78 and 79 of the Senate as adopted on 16th June 2024 to the extent that they apply to the Deputy President. 19, an order of mandamus be issued to compel the National Assembly and the Senate, that is the second and fourth respondents herein, to promulgate a procedure for removal of the Deputy President by impeachment envisaged by Article 152 of the Constitution. 20, that a declaration be issued to declare that the first petitioner was impeached through a procedure that amounted to political persecution and vendetta prescribed by Articles 1, 3, 38, and 50 of the Constitution. 21, that a declaration be issued to declare that the sixth respondent engineered, sponsored, and bulldozed the impeachment of the first petitioners in a manner that amounts to abuse of power in violation of Articles 1, 3, 38, 50, and 131(2) of the Constitution. 22, cost of the petition be borne by the first and fifth respondents. The 10th and 41st petitioners' submissions. In these submissions, the petitioners reiterated that the impeachment proceedings did not stem from legitimate constitutional violations. Instead, they arose directly from a severe political fallout and a politics of betrayal, in quotes, between H.E. President Ruto and H.E. Gachagua. They submitted that the impeachment motion was originally assigned to Sirisia MP, Honorable John Waluke, but however, due to his tainted image from a high-profile corruption case, Honorable Mutuse was brought in as a substitute mover to table the motion on the 1st of October 2024. The petitioners listed the following issues for the court's determination. A, whether the impeachment of H.E. Gachagua was a political witch hunt or a genuine procedure. B, whether H.E. Gachagua was impeached by the National Assembly and the Senate under a procedure that violated Articles 27, 50, and 152 of the Constitution. C, whether H.E. Gachagua was lawfully found guilty of Ground 1 of the Articles of Impeachment. D, whether the Standing Orders number 64 and 65 of the National Assembly and Standing Orders number 78 and 79 of the Senate, under which H.E. Gachagua was impeached, violate Article 152 of the Constitution. E, whether the Senate's failure to establish a special committee under Article 145(6) of the Constitution rendered the removal of H.E. Gachagua as null and void ab initio. Issue F, whether H.E. Gachagua was subjected to a lawful and fair trial by the Senate. G, whether the first to 11th respondents conspired or schemed to remove H.E. Gachagua from office in violation of Articles 1, Article 27, and 38 of the Constitution. On the weaponization of impeachment for political settlements, the petitioners maintained that the impeachment was completely manufactured by a political fallout rather than the genuine existence of any lawful grounds under Article 151B of the Constitution. That it was fundamentally unconstitutional for the executive and parliament to use the sacred device of impeachment as an administrative tool to resolve purely political disputes and vendetta. They submitted that the impeachment proceedings inside both the National Assembly and the Senate were weaponized and conducted in absolute violation of substantive and procedural provisions guaranteed under the Constitution, as well as the standing orders of both chambers. They specifically maintained that the current rules governing the process, that is, Standing Orders 64 and 65 of the National Assembly and Standing Orders 78 and 79 of the Senate, violate Article 150 sub-Article 2 of the Constitution and must be quashed. The petitioners equally submitted that HE President Ruto's power to nominate a replacement under Article 149 was strictly subject to certification by IEBC under Articles 99 and 137, and because the 14-day and 16-day constitutional windows under Article 149 are designed to guarantee rigorous public participation across all 290 constituencies, the rushed nomination and approval of H.E. Kindiki was unlawful. It was null and void ab initio. That rushing this process directly violated the political rights of the petitioners under Article 38. A fortiori, the petitioners argued that this court has an obligation to step in and quash the impeachment to halt an ongoing executive scheme to re-establish an imperial presidency in Kenya, and they warned that Parliament has become subservient and sycophantic to the executive, acting like the single-party rubber stamp parliaments of the late 1980s, which present an existential threat, to Kenya's constitutional democracy. They restated the prayers that sought to declare the impeachment null, void, and an act of political persecution that violated Articles 25, 27, 50, and 150 of the Constitution, and orders of certiorari quashing the National Assembly's 8th October 2024 resolution approving the impeachment motion, and Gazette Notice 13401, which appointed H.E. Kindiki as Deputy President. They also sought to quash the National Assembly Standing Orders 64 and 65 and Senate Standing Orders 78 and 79 to the extent that they apply to the removal of a Deputy President and orders to compel both chambers of Parliament to promulgate a legally compliant, constitutionally envisaged procedure for removing a deputy president under Article 150 sub-Article 2. The petitioners relied on various local authorities, including the Sonko case earlier mentioned, as well as Jirongo versus Soy Developers Limited. They also relied on foreign authorities, including Kriegler versus the Law Society of Alberta, Republic R versus Budry, R versus Campbell, R versus Reagan, all of which citations you will find in the judgment, all from the Supreme Court of Canada. Further reliance was placed on books, articles, speeches, and reports, as well as interview statement by Senator Edwin Sifuna on the Senate floor as per the Hansard of 9th October 2024 and an interview statement by H.E. Gachagua on Inoro TV. In the end, the petitioners prayed that their petition be allowed as prayed. Moving on to the 43rd petitioner's case, Mr. Morara Omoke filed a petition dated 9th October 2024 before the High Court of Kenya at Eldoret, together with a supporting affidavit sworn on the same date in his capacity as a Kenyan citizen and patriot, acting in defense of constitutionalism, the rule of law, and democratic governance. The petition challenged the constitutionality and legality of the impeachment proceedings commenced against H.E. Gachagua by the National Assembly and Senate. He contended that the impeachment process was politically motivated, defective, unconstitutional, and undertaken in violation of the sovereign will of the people expressed during the 2022 general election. His case centered on the alleged violations of Article 1, 10, 38, 47, 48, 50, 73, 75, 94, 118, 145, and 150 of the Constitution, that the impeachment motion tabled by the Honorable Motuse had not been preceded by adequate public participation, and that the MPs who appended their signatures in support of the motion failed to consult their constituents before supporting the impeachment process. He further alleged that the process of collecting signatures in support of the impeachment motion was tainted by bribery, undue influence, intimidation, and forgery of signatures belonging to some MPs. He contended that the subsequent public participation exercise conducted on 4th and 5th October 2024 was merely cosmetic and incapable of constituting meaningful public participation because it was hurried, poorly coordinated, inadequately publicized, and conducted through only one center per county and constituency. He also complained that the public participation forms contained only the allegations against H.E. Gachagua and omitted his responses, thereby condemning him unheard and violating the principles of fairness and natural justice. He also alleged bias and conflict of interest on the part of the Speaker and Deputy Speaker of the National Assembly. He contended that both office holders publicly supported the impeachment process before the motion was tabled and debated in Parliament, thereby compromising their constitutional obligation to act as neutral and impartial arbiters during the proceedings. He asserted that the impeachment motion was politically motivated and arose from internal disputes within the UDA party, yet the parties involved had failed to exhaust internal party dispute resolution mechanisms under the party constitution before initiating impeachment proceedings. He also argued that there existed no comprehensive statutory framework governing impeachment proceedings and the collection of signatures for impeachment motions, thereby rendering the process legally deficient and constitutionally uncertain. Mr. Omoke then sought the following orders. A declaration that the impeachment motion moved by the third respondent does not meet the threshold set out in Article 145 as read with Article 150 of the Constitution. B, a declaration that the impeachment of Geoffrey Rigathi Gachagua was unconstitutional. C, a declaration that the Speaker and Deputy Speaker of the National Assembly were biased and ought to have disqualified themselves from the impeachment process. D, a declaration that the impeachment motion violated the interested parties' rights under Article 32, 33, 38, 47, 48, 50, 73, and 75 of the Constitution of Kenya 2010. E, a declaration that the impeachment motion against the interested party was tabled in a manner that violates Article 110, 94, and 118 of the Constitution, as no public participation was conducted by Honorable Mutuse Ekomas Mwengi and by the members who appended their signatures prior to moving the impeachment motion in the National Assembly. F, a declaration that the impeachment motion, which was a result of a dispute in the United Democratic Alliance Party, was tabled before the National Assembly without exhaustion of internal remedies, contrary to the exhaustion doctrine and Article 159 of the Constitution of Kenya. G, a declaration that in the absence of an enabling legislation operationalizing the provisions of Article 150 of the Constitution of Kenya, there is no legislative and administrative framework within which the impeachment of the DP was anchored, and H, that each party bears its own costs. In his submissions, Mr. Omoke focused on two main issues, namely, whether the impeachment of H.E. Gachagua was unconstitutional and whether the lack of legislation to operationalize Article 150 of the Constitution vitiates the impeachment. He wholly adopted H.E. Gachagua's submissions dated 7th October 2025, submitting that the constitutionality of the impeachment transcends him and must be evaluated with a view to advancing constitutionalism and the rule of law. He maintained that public participation was inadequate and a sham, as the mover of the motion and the 291 MPs who appended their signatures in support of the impeachment motion did not conduct any public participation in their constituencies before signing, contrary to Articles 1, 10, 94, and 118 of the Constitution. That public participation was an afterthought, and when questions arose on 1st October 2024 about whether public participation should be conducted, the Speaker directed that it be held on 4th October 2024. The advertisement appeared on 2nd October 2024, which Mr. Omoke submitted was not a genuine intention to conduct any real public participation from the outset, that the public participation form provided by the National Assembly contained only the allegations against H.E. Gachagua and conveniently left out his response, denying the public the ability to effectively weigh the grossness of the alleged violations. He submitted that public hearings occurred for only 9 hours from 8 a.m. to 5 p.m. on a normal workday, which was a Friday, meaning most Kenyans could not attend. That venues were changed on the eve of the exercise. For example, in Embu, it changed from IFAD Hall to Talent Academy, and in Nairobi, it changed from KICC to Bomas of Kenya. He submitted that in Kiambu constituency, only about 2,000 people attended in a county with over 1 million registered voters, that there was no proper coordination, and he described the situation as utter pandemonium akin to the Tower of Babel. He contended that in some areas, especially in Mount Kenya, public participation forms were faulty. There were incidents of pre-filled forms, and a vehicle ferrying pre-filled forms was torched in Nyeri County. That the National Assembly extended the exercise to the following day on the 5th of October 2024, but no proper notification was made and MPs kept away from the exercise. He added that in some constituencies like West Mugirango, the MP never opened the constituency office, and that the one center per county and one center per constituency is too deficient, as public participation should have been conducted at least at each polling station or at minimum each ward. Mr. Omoke submitted that the National Assembly neither processed, nor considered the feedback collected, and the entire exercise was a mere sham to hoodwink innocent Kenyans. He accused Deputy Speaker Gladys Bose-Sholei of being biased in that on 23rd September 2024, while speaking at a function in Uasin Gishu County, she swore to spearhead the impeachment motion and put the Deputy President on notice, stating in quotes, "Mimi mwenyewe nitakupeleka nyumbani." In brackets, "I will personally take you home." that she also hinted at some of the grounds of impeachment before the motion was even tabled. He further argued that Speaker Moses Masika Wetangula on 29 September 2024, while attending a church function at Wamonyo Catholic Church in Machakos County, publicly took a stand on the impeachment motion before it was tabled. Using the biblical description in Mark 9:38-50, stated that H.E. Gachagua, being a part of the body that leads to sin, should be cut off. These utterances he submitted violated Articles 47, 50, and 150 of the Constitution, and that neither the Speaker nor the Deputy Speaker should have presided over the impeachment motion. Mr. Omoke submitted that the Constitution sets a high threshold for impeachment as the measure is a grossness of alleged violations, and that grudges and squabbles cannot be the basis for removal. He contended that extraneous grounds were introduced on the floor on 8 October 2024, as it was alleged that H.E. Gachagua had referred to Honorable Florence Jemataya Sergon, the countrywoman rep of Baringo, as a harlot. That Honorable Karoli Omondi, MP Suba North, referred to conversations he had with H.E. Gachagua without providing any proof. Honorable Patrick Makau, MP Mavoko, also made references to conversations without providing any proof. On the vote that 281 MPs supported the motion, 44 opposed, and there was one absentee, Mr. Omoke submitted that MPs abdicated their obligation to weigh the grounds against the intermediate standard of proof set by the Supreme Court in Odinga and 5 others versus IEBC and 3 others. That the impeachment overturned the decision of 7,176,141 Kenyans who voted for the joint ticket on 9th August 2022, a decision upheld by the Supreme Court, and that the motion was an egregious overthrow of the decision of the majority with that of a few. It was Mr. Omoke's further submission that no statutory legislation exists on the process of impeachment of the President and Deputy President from start to completion, as no legal framework exists on the collection of signatures in support of an impeachment motion. Therefore, there is no framework upon which the impeachment of the Deputy President was anchored. He submitted that in D and others, that is the Attorney General, this court was persuaded by Mr. Omoke, who was a petitioner therein, that the lack of legislation on signature collection and verification and on the conduct of referenda initiated the BBI process. He submitted that the same principle applies here, and that legislation is so central to the fairness of the process that the court ought to, at minimum, issue a structural edict requiring enactment of this legislation. He submitted that areas requiring legislation include initiation of the impeachment process, how Parliament is to process impeachment, particularly public participation, and the actual impeachment trial, the replacement of an impeached deputy president, provision for judicial intervention before an impeached president or deputy president is replaced, including grant of conservatory orders to preserve the rights of the impeached official, and expeditious hearing of petitions arising from an impeachment. Mr. Omoke saw no reason why the court could not have maintained the conservatory orders in favor of H.E. Gachagua and had the petitions within a week or 2. That the discharge of the orders, followed by an immediate declaration of a public holiday for the swearing in of a new deputy president, left a mind-boggling question on the efficacy of Article 50 of the Constitution. For these reasons, Mr. Omoke prayed for a declaration that the impeachment of H.E. Gachagua was unconstitutional, and that a declaration that the absence of legislation operationalizing Article 150 of the Constitution rendered the impeachment process of the Deputy President flawed. We look at the 44th to 48th petitioner's case. Abuli Namenya, Kennedy Kareithi Gachagua, Dennis Okumu, Simon Mushangi, and Peter Maina Kanene jointly filed the petition dated 30th September 2024 before the High Court of Kenya at Nairobi. They describe themselves as Kenyan citizens committed to constitutionalism, the rule of law, and defense of the Constitution, and that they also instituted the petition in the public interest to challenge the proposed impeachment of H.E. Gachagua as Deputy President of the Republic of Kenya. As per their petition and the supporting affidavit sworn by Omuli Namenya, the petitioners challenged the constitutionality of the impeachment process on the basis that Parliament had failed to establish a proper legal and procedural framework governing public participation in impeachment processes under Article 118 and 124 of the Constitution. The petitioners contended that neither the National Assembly standing orders nor the Senate standing orders provided mechanisms, procedures, threshold, timelines, verification methods, venues, or modalities for meaningful public participation in impeachment proceedings, thereby rendering contemplated impeachment process unconstitutional. They further argued that public participation was a mandatory constitutional prerequisite which ought to precede any impeachment process, and asserted that the 7-day timelines prescribed under Standing Orders 64 and 73 for disposal of impeachment proceedings were inadequate and unconstitutional, as they undermined effective public participation and violated the rights to fair administrative action and fair hearing under Articles 47 and 50 of the Constitution. The petitioners additionally alleged that the impeachment process was politically motivated and tainted by bias and lack of impartiality on the part of parliamentary leadership, citing public pronouncements by parliamentary leaders in support of the impeachment motion. They advanced a historical argument concerning the office of the Vice President and Deputy President in Kenya, contending that successive Deputy Presidents had historically been subjected to political hostility, dismissals, and frustration, which informed the constitutional design of 2010, requiring the President and Deputy President to be elected jointly. The petitioners then sought the following prayers: a declaration that the impeachment process of a deputy president is a sui generis in nature, and that public participation forms a fundamental background that plays a significant role in attaining the right to a fair trial enshrined under Article 50 of the Constitution. B, a declaration that public participation is the only avenue or means through which the people can exercise their sovereignty contemplated under Article 1 of the Constitution in determining whether an office created under the Constitution ought to be abolished, or whether accountability mechanisms created under this Constitution ought to be put in motion or otherwise, and that the lack of elaborate procedure or certainty as to when the same should commence or conducted will ordinarily amount to usurpation of the people's power and subsequently amount to a violation of the Constitution. C, a declaration that the Article 118, Sub-Article 2, that clearly provides for mandatory public participation and Article 124, creating the requisite parliamentary standing orders, neither the National Assembly nor the Senate had enacted an Act of Parliament providing for the procedure on how the impeachment of either the President or Deputy President is to be undertaken, nor has the National Assembly Standing Order 64 or 65 or the Senate Standing Order number 74 provided for the procedure governing the crucial element of public participation relating to the impeachment of a deputy president. D, a declaration that the National Assembly Standing Order 64 and 65 or the Senate Standing Order number 74 are unconstitutional as they were never subjected to the mandatory public participation during their enactment. E, a declaration that the standing orders must with certainty and clarity provide that the public participation contemplated under Article 118 should be a conditional precedent that must precede all other processes relating, connected, or incidental to the impeachment of the Deputy President. F, a declaration that Article 27 requires that all Kenyans must be subjected to the principle of equality and equal protection of the law, while Article 47 requires that a person must be subjected to an administrative process that is procedurally fair, expedited, reasonable, and lawful, irrespective of one's status in society, and that the respondents herein have violated the same by commencing an impeachment process that is constitutionally tainted with illegalities. G, a declaration that public participation in an impeachment process is a fundamental infrastructure that facilitates the enjoyment of Article 50 and that the absence of the same will amount to the respondents herein violating, denying, threatening, or infringing the interested party's right to a fair trial during his impeachment. H, a declaration that time is an important resource for any judicial or quasi-judicial tribunal contemplated under the Constitution, and that the 7 days period for impeachment provided for under Standing Order 64-2B of the National Assembly Standing Orders and the Senate Standing Order 73-1 amounts to conducting a sham trial in, and the same will amount to a violation of Article 50. I, a declaration that Standing Order 64-2B of the National Assembly Standing Orders and the Senate Standing Order number 73-1 does not provide for the sufficient and adequate time for carrying out a qualitative, quantitative, meritorious, accurate, and secure public participation, the hearing and determination of the impeachment trial before Parliament that will result into a fair, just, impartial, and judicious determination of the impeachment trial as contemplated under Article 47 and 50 of the Constitution. J, a declaration that for purposes of authenticating and verifying the results of the participants taking part in the public participation, confirming all the requisite legal thresholds like that of citizenship, the total number of participants, public participation ought to be undertaken by an impartial state organ separate from Parliament. Looking at the 44th to 48th petitioners' submissions, led by Learned Counsel Mr. Njiro Ndegwa, the petitioners focused on the constitutional architecture governing impeachment of a deputy president, submitting that the process was fundamentally flawed because impeachment is a measure of last resort, not a primary accountability tool, and that the Senate failed to apply the mandatory modification rule under Article 152, which requires that Articles 144 and 145 be applied, in quote, with necessary modifications to the Deputy President. Mr. Ndegwa submitted that the proceedings violated fair hearing rights under Article 50, including the refusal to adjourn when the Deputy President fell ill, that the process was infected with bias, irrelevant considerations, and procedural violations of the Standing Order 75, 78, and 80, and that the cumulative defects render the entire impeachment null and void. The petitioners adopted and relied on H.E. Gachagua's submissions and the Wambora principles on quasi-judicial impeachment proceedings and identified the following issues for determination: whether the impeachment of the Deputy President met the constitutional threshold of a measure of last resort in light of the availability of alternative constitutional and statutory mechanisms, whether the constitutional framework governing the impeachment of a Deputy President under Article 150, Sub-Article 2 was properly invoked, applied, and distinguished from the regime governing the impeachment of a President under Article 145, whether the Senate complied with the mandatory requirement to apply Articles 144 and 145 with necessary modifications as contemplated under Article 152 and Standing Order 79. Whether the failure to apply the modification rule undermined the constitutional principles of sovereignty of the people, national values, and political rights, including the legitimate expectation of tenure. Whether the impeachment process satisfied the constitutional and jurisprudential standards applicable to quasi-judicial proceedings as articulated in the Wambora decisions. Whether the Senate's failure to comply with constitutional requirements renders the impeachment process null and void. Whether the impeachment process violated the Deputy President's right to equality and equal protection of the law under Article 27. Whether Parliament, in conducting the impeachment proceedings, acted as an impartial and unbiased quasi-judicial body as required by law. Whether the debates and proceedings in both the Senate and the National Assembly were confined to the substantiation of the charges or were contaminated by irrelevant, extraneous, and prejudicial considerations. Whether the refusal to grant an adjournment upon the Deputy President falling ill violated his right to a fair hearing under Article 50, including the right to be present and to be adequately present, to adequately present his defense. Whether the Senate misapplied Standing Order 78 by proceeding under a plenary hearing without affording procedural safeguards and by improperly treating the proceedings as time-bound. Whether the impeachment proceedings violated the Deputy President's right to adequate time and facilities to prepare a defense under Article 50, Sub-Article 2A, and the right to be heard under Standing Order 80. Whether the Senate acted in violation of its own standing orders, including Standing Orders 75, 78, and 80, and the legal effect of such violations. Whether sufficient time existed within the constitutional and procedural framework to accommodate adjournment and ensure a fair hearing, and whether failure to utilize such time rendered the process unconstitutional. Whether the continuation of proceedings in light of the Deputy President's illness violated his fundamental rights to life, dignity, health, and access to justice under Articles 26, 28, 48, and the state obligations under Articles 10, 19, 20, and 21. And finally, what reliefs are available where a constitutional process is found to be procedurally and substantively defective. Learned counsel submitted that impeachment is not intended to be a primary or convenient mechanism for addressing alleged misconduct, but rather an extraordinary remedy reserved for the clearest and most compelling cases where no other lawful avenue exists. They argued that the Constitution establishes a graduated hierarchy of accountability, beginning with civil liability, criminal prosecution, and administrative action, and only thereafter impeachment. It was emphasized that Article 143 expressly removes immunity from civil and criminal proceedings for the Deputy President, unlike the President. According to Mr. Ndegwa, this signals that allegations against a Deputy President should, in the first instance, be addressed through ordinary legal processes. Parliament, however, bypassed these mechanisms and resorted to impeachment as a first recourse, which counsel contended offends the principles of proportionality, rationality, and legality. They further submitted that no evidence exists that Parliament considered whether the allegations could have been addressed through criminal investigation or civil proceedings before invoking impeachment. Counsel also drew attention to Article 152, which provides that Articles 144 and 145 apply to the Deputy President with the necessary modification. Counsel argued that this phrase is not ornamental, but a deliberate constitutional command requiring contextual adaptation of the presidential impeachment framework to the distinct office of the Deputy President. In their view, the requirement imposes an active obligation on the Senate to interrogate, adjust, and tailor the procedure rather than merely transplant it without reflection. Standing Order 79, they submitted, operationalizes this obligation by requiring the Senate to consciously and expressly apply the modification principle. Mr. Ndegwa submitted that nowhere in the Senate Hansard is the Speaker recorded as guiding the House on the necessity, the scope or content of the required modifications as the Senate proceeded, as though Article 145 applied mutatis mutandis and in toto without any modification. He stated that this failure is not merely procedural but a substantive and jurisdictional issue which renders the entire process unconstitutionally defective ab initio. The petitioner submitted that this modification requirement ensures that impeachment is not invoked where alternative legal mechanisms such as the courts, EACC, or DCI are adequate. It was their case that the failure to modify denied the Deputy President the procedural safeguards that would have arisen from a properly tailored process, including consideration of alternative accountability mechanisms, flexibility in procedure to ensure fairness, and enhanced scrutiny of the necessary and proportionality of the impeachment. It was their submission that the office of Deputy President derives its legitimacy from the sovereign will of the people expressed at the ballot under Article 1, and impeachment without proper modification undermines this sovereign will and defeats the legitimate expectation of tenure for both the office holder and the electorate. That Article 38 guarantees citizens the right to elect leaders and to have them serve their full term, subject only to lawful and constitutionally compliant removal process, and that the failure to modify the process resulted in an unjustified interruption of the people's sovereign mandate. Mr. Ndegwa submitted that the Deputy President fell ill during the proceedings while actively engaged in his defense, and that this is not disputed and is recorded in the Senate Hansard. that the Senate refused to grant an adjournment, proceeding instead to a conclusion in his absence, and he submitted that this violated Article 52 on the right to adequate time and facilities to prepare a defense, and Article 52F on the right to be present when being tried, and Standing Order 80 on the right to be heard within Senate proceedings, that a hearing conducted in the absence of the principal defense participant due to verified illness cannot satisfy the conditional threshold of fairness. He stated that the Senate had sufficient procedural latitude under Standing Order 75 2B to adjourn without violating any constitutional timeline, but the refusal was not dictated by lack of time, but by a failure to exercise discretion fairly. The petitioner submitted that under Article 26 on the right to life, the state must refrain from actions that undermine physical well-being or exacerbate medical vulnerability, and that proceeding with impeachment during illness reduce the deputy president to a procedural object rather than a rights-bearing participant. They stated that Article 48 on the access to justice extends to all adjudicative processes, including parliamentary impeachment, and that meaningful participation requires reasonable accommodation and denial of adjournment rendered access to justice illusory. They also submitted that the test for bias is objective, and whether a reasonable and informed observer would apprehend bias, and that senators acknowledged imperfections in the case but still voted to impeach, which demonstrated bias. They urged the court to address the impeachment process as a whole, not in fragments, noting that the petitioners have demonstrated cumulative defects, including failure to apply the modification rule under 152, absence of impartiality and presence of bias, reliance on irrelevant and extraneous considerations, violations of fair hearing rights, misconstruction of the constitutional and procedural framework, and breach of Standing Order 75, 78, and 80. They submitted that individually, each defect is serious, and collectively, they reveal a process that is constitutionally unsound from inception to conclusion. That Article 165 3D Roman 2 vests the High Court with jurisdiction to determine whether anything done under constitutional authority is inconsistent with or in contravention of the Constitution. They contended that this court is not being invited to interfere with parliamentary politics, but is being invited to perform its core constitutional function as guardian of legality and fundamental rights, and where Parliament acts within constitutional bounds, the court defers, but where it acts outside those bounds, the court must intervene, not as an intruder, but as a constitutional necessity. As such, the petitioners urged the court to find that impeachment was not a measure of last resort when ordinary legal mechanisms were available and bypassed, that the Senate failed to apply the mandatory modification rule under Article 152, rendering the process unconstitutional ab initio, that the refusal to adjourn during illness violated Articles 50, 26, 28, and 48, that the proceedings were infected with bias and irrelevant considerations, and that the cumulative defects render the impeachment null, void, and of no legal effect. They then prayed that their petition be allowed in entirety.
I will then take over from the 51st petitioner's case. Karen Wambui Mwangi, the 51st petitioner, in the consolidated petition, filed a petition dated 26th of September 2024, before the High Court of Kenya at Milimani as a public-spirited Kenyan citizen and a defender of the Constitution. Ms. Mwangi contended that the impeachment process was unconstitutional, unlawful, and politically motivated. She relied on public statements allegedly made by Honorable Didmas Baraza and Honorable Gladys Posholei in September 2024, indicating that the impeachment of H.E. Gachagua had already been predetermined, and further referred to a motion by Honorable Danson Mungatana expressing displeasure with the conduct of His Excellency Gachagua. Ms. Mwangi asserted that the allegations leveled against his H.E. Gachagua were vague and supported by evidence and lacking in specificity and peculiarity, contrary to the constitutional requirements of fair hearing and due process under Articles 47 and 50 of the Constitution. She further alleged that the intended impeachment process mounted to a political witch hunt designed to settle political scores rather than a lawful constitutional process, and contended that the respondents had violated the national values and principles under Article 10, including the rule of law, transparency, accountability, equality, and protection of human rights. She maintained that His Excellency Gachagua had not been accorded adequate notice of the charges against him, sufficient particulars of the allegations, nor an opportunity to adduce and challenge evidence in violation of Articles 25C, 35, 47, and 50 of the Constitution. As such, she sought for the following orders. A declaration that within the purview of Articles 25C, 35, 47, and 50 of the Constitution of Kenya, a person facing impeachment proceedings under Article 150 is entitled to be informed substantially with peculiarity and specificity and supported with evidence the grounds of impeachment before the commencement of the impeachment proceedings by the National Assembly and Senate. B, conservatory orders do issue against the respondents, restraining them from a collection of signatures in support of a motion to impeach His Excellency Rigathi Gachagua, lodging any motion and or carrying on proceedings seeking to impeach the Deputy President of the Republic of Kenya, the interested party herein. See, an order of compensation enshrined and provided for under Article 23A of the Constitution of Kenya, made up of damages as shall be assessed and quantified by the petitioner, general damages, cost of the petition, and any other relief. The 51st petitioner neither filed any written submission nor attended the physical highlighting of submissions. In respect to the 54th petitioner's case, Emmanuel Elijah Otieno was the 54th petitioner in the consolidated petitions. He is an advocate of the High Court of Kenya who filed the petition dated 18th of October 2024, together with a supporting affidavit also challenging the constitutionality and legality of the impeachment and removal from office of His Excellency Gachagua as Deputy President. He stated that instituted proceedings in the public interest pursuant to Articles 3 and 258 of the Constitution, and contended that impeachment process undertaken by the National Assembly and the Senate was procedural, unfair, politically motivated, unconstitutional, and inconsistent with the constitutional principles governing impeachment under Articles 145 and 50 of the Constitution. He maintained that impeachment was a constitutional mechanism intended to promote accountability and good governance, and not a tool for settling political disputes or managing political differences among leaders. He challenged the legality of public participation process and the fairness of the proceedings before the National Assembly and the Senate, and the substantive threshold applied in removing His Excellency Gachagua from office. He contended that the National Assembly failed to conduct meaningful and constitutional compliant public participation as required under Articles 10 and 118 of the Constitution and Section 5 of the Fair Administrative Actions Act. Mr. Otieno stated that the public participation exercise was hurried, inadequate, both quantitatively and qualitatively, and incapable of reflecting the sovereign will of the electorate, given that only about 223,000 persons participated, despite His Excellency Gachagua having been elected together with His Excellency President Ruto by over 7 million voters. He further asserted that the public participation template prepared by National Assembly was biased because it only contained the allegations against His Excellency Gachagua and failed to include his responses, thereby portraying him to the public as guilt before he had been heard. Mr. Otieno additionally stated that the Speaker, Deputy Speaker, and members of National Assembly demonstrated bias from the outset, failed to accord His Excellency Gachagua a fair hearing, and debated the impeachment motion before proper public participation and before considering His Excellency Gachagua's defense. He maintained that no impeachable offense meeting the constitutional threshold of gross violation, gross misconduct, or commission of crimes under national or international law had been substantiated either before the National Assembly or the Senate. He further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged violations of Articles 25C, 47 and 50 of the Constitution relating to the rights of fair hearing and fair administrative action. He sought the following prayers: A declaration be and is hereby issued that the public participation organized and conducted by the first respondent did not meet the requirements of Articles 118, 1B of the Constitution quantitatively and qualitatively. B, a declaration be and is hereby issued that the first respondent violated seventh respondent right to a fair administrative action under Articles 47 of the Constitution and Section 4 of the Fair Administrative Actions Act. C, a declaration be and is hereby issued that the first respondent violated the right of the seventh respondent under Article 50, Sub-Article 1 of the Constitution 2010. D, a declaration be and is hereby issued that the resolution of the first respondent to impeach the seventh respondent was invalid and null and void. And E, respondent shall bear the cost of the petition. Likewise, the 54th petitioner neither filed any submissions nor attended the physical highlighting of the submissions. Next is consideration of the 55th and 56th petitioner's case. Stephen Mbugua Wanjiru and Gladys Nyambura Gituha jointly filed a petition dated 20th of October 2024 together with the supporting affidavit sworn by Wambugu Wanjohi. They stated that they were public interest litigants and defenders of constitutionalism. They challenged the legality, constitutionality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachagua as Deputy President of the Republic of Kenya, as well as the subsequent nomination and approval process relating to His Excellency Kindiki as the Deputy President nominee. The petitioners contended that the impeachment process before both the National Assembly and the Senate were marred by procedural irregularities, bias, denial of fair hearing, and unconstitutional conduct, that the Speaker and the Deputy Speaker of the National Assembly had publicly pronounced themselves in favor of the impeachment before presiding over the proceedings, thereby violating the constitutional principles of impartiality, neutrality, and natural justice. The petitioners further challenged the adequacy and constitutionality of the public participation exercise conducted on the 4th and 5th October 2024, asserting that the notice period was too short to permit meaningful participation, that the questionnaires used by the National Assembly only presented the accusations against His Excellency Gachagua without his responses, and that the Parliament failed to avail documentary and electronic evidence to the public to facilitate informed participation. He further asserted that the Senate proceedings contending he further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and that by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged that Sorry, I had repeated that bit, but I'll proceed from paragraph 133. They additionally alleged that public participation process was chaotic, disorderly, and marred by violence and characterized by low turnout in several constituencies and undertaken on days when many Kenyans were engaged in religious worship, thereby undermining the constitutional threshold for meaningful participation under Articles 10 and 118 of the Constitution. The petitioners also challenged the conduct of the Senate proceedings. They contended that the Senate acted in violation of Articles 25C, 47 and 50 of the Constitution by refusing to adjourn the impeachment hearing despite His Excellency Gachagua's illness and hospitalization, and thereby denying him an adequate opportunity to personally defend himself. Further, the petitioners alleged bias and conflict of interest arising from participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Omolo, Senior Counsel, in the Senate proceedings, stating that their roles compromise the fairness and impartiality of the impeachment process. The petitioners maintained that the impeachment proceedings before both houses of parliament were characterized by constitutional violations, procedural inconsistencies, and disregard for due process. The petitioners also challenged the subsequent nomination and approval of His Excellency Kindiki as Deputy President, contending that the nomination was tainted by the same constitutional and procedural violations that affected the impeachment process and was therefore null and void. As such, they sought the following prayers: a declaration that the grounds of impeachment laid in the special motion dated 24th of September 2024 did not meet the constitutional and legal threshold for impeachment of a deputy president. That a declaration do issue that public participation exercise conducted on the 4th and 5th of October was flawed and incapable of meeting the constitutional standards required for such processes, and the outcomes of this flawed participation do not reflect the will of the people and cannot be considered a legitimate basis for advancing the impeachment motion. See, a declaration that the impeachment process against the Deputy President initiated by the National Assembly and subsequently conducted by the Senate was tainted by substantive and procedural constitutional violations, rendering unconstitutional, illegal, null, and void. D, an order nullifying the impeachment of the Deputy President as the process was marred by procedural irregularities, bias, conflict of interest, and a violation of the right to a fair hearing as guaranteed under Article 50 of the Constitution. A, an order directing the immediate reinstatement of the Deputy President to his duly elected office, having been unconditionally and constitutionally and unlawful removed through an impugned process. F, an injunction restraining the President, the National Assembly, and any other state organs from proceeding with or effecting the appointment of any other person to the office of the Deputy President pending the hearing and determination of this petition. G, an order revoking the nomination and subsequent approval of Professor Kithure Kindiki as Deputy President by the National Assembly, as it stems from an unconstitutional process and is procedurally flawed and in violation of the Constitution. H, a mandatory injunction directing the National Assembly and the Senate to comply with the Articles 10 and 118 of the Constitution by ensuring meaningful and effective public participation in any future impeachment processes or similar proceedings of national importance. I, declaration that the participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Omolo, Senior Counsel, in the impeachment proceedings violated the principles of impartiality and fair hearing and constituted a conflict of interest that compromised the integrity of the impeachment proceedings. J, an order awarding the petitioner cost of this petition, and K, any other orders or reliefs. The 55th and 56th petitioners did not file any written submissions, and they also did not turn up at the hearing. The 57th petitioner was Edwin Gekonge, and he filed the amended petition dated 23rd of October 2024 before the High Court of Kenya at Mombasa, together with their supporting affidavit on of the same date. He stated that he is a law-abiding citizen, human rights defender, and a public-spirited litigant acting in his own interest and in the interest of citizens of the Republic of Kenya. The petition challenged the constitutionality of the impeachment proceedings undertaken against His Excellency Gachagua as Deputy President, as well as the subsequent nomination and approval of His Excellency Kindiki as the Deputy President. He stated that the impeachment proceedings before the National Assembly and Senate violated Articles 10, 32, 47, 48, 50, 145, and 150 of the Constitution. He stated that the public participation process conducted on the 4th and 5th October 2024 fell below the constitutional threshold of effective, meaningful, and inclusive public participation. The petitioner asserted that the notice period for the public participation exercise was too short, that the exercise was limited to county offices instead of constituency level, and that the extension of the exercise to 5th of October 2024 was ineffective because the notice was issued on the very day of participation and coincided with a Sabbath day of worship for the Seventh-day Adventists, thereby excluding members of the faith from meaningful participation. He further alleged that the exercise was marred by confusion, violence, inadequate information, early closure of centers, and generally low participation, thus violating Articles 10 and 118 of the Constitution. He also challenged the legality of the Senate proceedings on the ground that His Excellency Gachagua was denied a fair hearing contrary to Article 50 of the Constitution. He contended that although the first petitioner had fallen ill and was unable to continue participating in the proceedings, the Senate declined to adjourn the hearing and proceeded to vote on the impeachment charges in his absence. Mr. Gachagua stated that Article 145 of the Constitution did not prescribe rigid timelines that could override the constitutional right to a fair hearing, and that the Senate failed to apply the necessary constitutional modifications contemplated under Article 150 in impeachment proceedings relating to a deputy president. He further maintained that the evidence presented before the Senate did not attain the constitutional threshold required to establish gross violation of the Constitution, gross misconduct, and serious reasons to believe that His Excellency Gachagua committed crimes under national law. Mr. Gachagua also challenged the legality and constitutionality of the nomination and approval of His Excellency Kindiki as Deputy President, stating that the constitutional timelines under Article 149 contemplated meaningful public participation and adequate vetting before approval of a Deputy President nominee. He contended that His Excellency Kindiki remained a state officer serving as Cabinet Secretary at the time of nomination and had not formally resigned, thereby rendering him constitutionally disqualified under Article 137 and Sections 23 and 24 of the Elections Act. The petitioner further challenged the role of IEBC, contending that the commission was not properly constituted and therefore incapable of lawfully confirming the qualifications of the nominee. Mr. Gachagua sought the following orders. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th and 5th October 2024 regarding the special motion fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the public participation process on the 5th of October 2024 was unconstitutional for failure to provide sufficient notice and in violation of the freedom of religion under Article 32. C, a declaration that the impeachment process against the first interested party undertaken by the first and the second respondents was unconstitutional and did not meet the requirements set under Articles 145 and 150 of the Constitution of Kenya. D, a declaration that the impeachment process as against the first interested party undertaken by the first and the third respondents was unconstitutional as it violated Article 50 of the Constitution of Kenya in terms of providing a fair hearing. E, a declaration that the impeachment proceedings of the first interested party taken by the first and third respondent was unconstitutional, void for failing to meet the evidential threshold of the impeachment of a deputy president under Article 150, subarticle 1B. F, a declaration that the nomination of Abraham Kithure Kindiki by the President of Kenya is unconstitutional, null and void, and in contravention of Article 137(1) of the Constitution. G, a declaration that the approval of the nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional for failure to comply with Articles 10 and 118 of the Constitution. H, a declaration that the approval of the nomination of a deputy president by the National Assembly under Article 149 of the Constitution must include public participation in every constituency. A declaration that the approval and nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional, as Abraham Kithure Kindiki had not resigned as a state officer. J, a declaration that the independent, that IEBC, at the time of nomination of Abraham Kithure Kindiki, was not properly constituted to approve or confirm the qualification of Abraham Kithure Kindiki under Article 137(1) of the Constitution. K, a declaration that IEBC had violated Article 149 of the Constitution by confirming that Abraham Kithure Kindiki was qualified to stand as a member of Parliament as per Article 137(1) of the Constitution. L, any other orders as the court may deem just. Mr. Gikonge likewise did not file any submissions. In respect of the 50th, the 52nd and the 53rd petitioners, that is John Njomo, Clarence Eboso, and Wanjiru Mwangi, their petitions were withdrawn from the consolidated proceedings on the 7th November 2024, as well as on the 16th of May 2025. On the 7th interested parties case and submission, that is Kituo cha Sheria, it appeared as the 7th interested party in these proceedings and filed a replying affidavit sworn on the 15th of April 2026 by Dr. Wambua Kituku, who is its executive director, as well as written submissions of even debt. Kituo identified 4 issues for court's determination, being whether the National Assembly process met the constitutional threshold for meaningful public participation and Articles 1 and 10, 110 and 118 of the Constitution. Secondly, whether impeachment proceedings were quasi-judicial to the extent that they meet constitutional and statutory procedural fairness standards. Thirdly, whether the court could review the procedural regularity of impeachment proceedings consistently with the doctrine of separation of powers. And lastly, whether the refusal to adjourn and the decision to proceed with in absentia violated the first respondent's petitioner's right to fair administrative action and fair hearing under Articles 10, 27, 28, 47, and 50 of the Constitution. Kituo cha Sheria averred that Article 118 of the Constitution mandated Parliament to facilitate public participation and involvement in legislation and all other business of the Assembly and its committees. They further argued that the removal of a deputy president from office was one of the most significant constitutional functions assigned to the National Assembly and the Senate, and directly affected the sovereign will of the people. It was their understanding that public participation in such a constitutional process had to be both quantitative to mean that a sufficient number of citizens had to be reached and accorded an opportunity to participate, and qualitative to mean that the participation had to be meaningful and capable of influencing the decision-making process. Kituo further averred that the one-day public participation notice given by the Speaker of National Assembly and the National Assembly itself was inadequate to reach a substantial portion of the Kenyan population, particularly ordinary citizens who relied on accessible and localized communication channels. They deposed that the said notice did not necessarily reasonably reach rural communities, citizens without access to national media, citizens relying on vernacular radio stations, and those who depended on local public fora for information. It stated that National Assembly reduced 290 potential local hearings to only 47 hubs for public engagement forums, including venues such as Kiambu Social Hall, Gatundu, Nakuru SK Shule, and Tomoya College, thereby drastically limiting accessibility and diluting representation. Kituo cha Sheria averred that the National Assembly and the Senate did not take adequate steps to ensure that sufficient citizens were made aware of the intended impeachment process. In particular, they had failed to disseminate information through churches, mosques, temples, public barazas, community meetings, vernacular radio stations, and county-level public participation forums. They further averred that the alleged public participation conducted by the National Assembly and the Senate lacked adequate structures for public engagement, including ICT-based platforms for the submission of views, decentralized citizens forums, structured mechanisms for receiving memoranda from citizens across counties, and organized town hall meetings. As a result, members of public were largely reduced to observers of the proceedings rather than participants in the process. They deposed that in the impeachment proceedings conducted by the Senate, by the Speaker of the Senate and the Senate on the 16th and 17th of October, His Excellency Gachagua was denied an opportunity to appear and be heard, to be present when being tried, and to challenge the evidence. That during the proceedings on the material day, it was communicated to the Speaker of the Senate, and the Senate, that is Excellency Gachagua, was present but subsequently fell ill. He was then rushed to hospital for urgent medical attention, and his legal counsel duly communicated his admission to hospital to the Speaker. Notwithstanding the request for adjournment on this ground, the Senate declined the request and proceeded to hear the case in the absence of His Excellency Gachagua and his counsel. The Senate subsequently decided to remove His Excellency Gachagua from office by impeachment for gross misconduct and on grounds of violation of the Constitution. Kituo stated in the proceedings of that the proceedings of the removal from office of the deputy president before the Senate involved the reception of evidence, evaluation of contested facts, and the making of determinations that directly affected the fundamental rights of His Excellency. Those proceedings, therefore, ought to have been procedurally fair and to have accorded him an opportunity to be present during the trial, to be cross-examined, to be re-examined, and to fully clarify any allegations made. However, the Senate, in disregard of the quasi-judicial nature of the proceedings, reached its determination without affording His Excellency those rights. Kituo cha Sheria contended that declining an adjournment request when His Excellency suffered severe and involuntary pain constituting a medical emergency was inhumane and unreasonable. They further averred that the one-day public it was further averred that the Senate, as a state organ, was bound to follow the Constitution and to observe, respect, protect, promote, and fulfill His Excellency Gachagua's rights. That upholding the impeachment as conducted set a dangerous precedent by normalizing procedural shortcuts in constitutional processes and weakened safeguards meant to protect constitutionalism and the respect for the rule of law. The absence of cross-examination in the present case was, in his view, a novel and serious procedural omission that contravened national values and principles of governance, including good governance, integrity, transparency, accountability, fairness, human dignity, equality, social justice, inclusiveness, equality, human rights, non-discrimination, and protection. They expressed their belief that the court had a solemn duty in interpreting the Constitution to adopt a purposive and progressive approach that advanced good governance, constitutionalism, accountability, and the public interest. They further averred that the determination of the petition would provide critical guidance on the constitutional standards applicable to future impeachments of holders of the offices of the Deputy President and the President, and that it must therefore reinforce rather than dilute the public participation threshold and fair hearing protections. Kituo submitted that the standard for public participation envisaged under Article 118 was meaningful participation and not tokenism, and that it had to be assessed on reasonableness and meaningfulness and meaningful opportunity, considering the nature and the impact of the decision. It was submitted that the removal of a deputy president from office was not an ordinary procedural matter, but constitutional event with profound democratic implications. That Article 118 had to be read together with Articles 1 and 10 of the Constitution, and that sovereign power belonged to the people, and Parliament merely exercised that power in a delegated capacity. When Parliament embarked on a process that might remove from office a deputy president who was directly elected by the people, it was obliged to ensure that the people themselves were accorded a meaningful opportunity to be heard. It was further submitted that in such a context, public participation became a constitutional condition precedent to valid impeachment processes. The organization submitted that public participation in a constitutional democracy had to satisfy both quantitative and qualitative standards, and that this dual requirement was particularly important where the process concerned the removal of a nationally elected office holder. In support, they relied on the Mwangaza versus Speaker of National Assembly case, in which the court stated that public participation was a constitutional requirement, and Articles 10(2)(a) and 190, Article 1(b) of the Constitution mandating inclusive and meaningful citizen engagement in government decision making, including legislative processes such as impeachment. It was further submitted, relying on the case of Wambora, that the Constitution did not intend a scenario where an otherwise popular deputy president could be removed due to political rivalry, malice, vendetta, institutional tough wars, and partisan hostility within government, and that public participation acted as a constitutional safeguard against the abuse of impeachment powers. On the inadequacy of the notice period, the interested party submitted that the one-day Gazette notice and a national radio announcement coupled with two-day public engagement period was grossly inadequate to facilitate meaningful public participation, as such short time could not reasonably reach most Kenyans, particularly ordinary citizens who relied on accessible and localized information channels. On the over-centralization of venues, they submitted that the Speaker of National Assembly and the National Assembly failed to utilize several well-established participatory mechanisms ordinarily available to them, including ICT platforms for structured public input, county-based citizen engagement forums, public notice boards, and accessible announcements, town hall meetings, engagement through representation of the people, and decentralized partisan platforms across counties. Instead, the National Assembly adopted a centralized and restrictive mode whereby all 290 constituencies were grouped into only 47 participation centers, one per county. This arrangement overloaded single venues, diluted constitutional high-level representation, and transformed public hearings into mass gatherings where individualized contributions were particularly impossible. The structural barriers disproportionately undermined meaningful engagement, especially for marginalized communities, people with disabilities, workers unable to leave employment on short notice, those without transportation, and citizens living far from county headquarters. It was submitted that a process of this gravity required decentralized, not consolidation of engagement forums. On the rigid and non-deliberative format of engagement, they submitted that the National Assembly employed a highly structured and restrictive model of engagement in which parliamentary clerks read out the charges, provided a general explanation of the processes, attendees were given limited time to offer their views, and those views were recorded in a pre-designed format for compilation. That format did not allow robust deliberation, did not permit cross-examination of claims, and did not facilitate informed submissions on the constitutionality or factual basis of the impeachment. It was submitted that public participation had to be interactive and not merely a formalistic exercise. On the inadequacy of the online submission mechanism, they submitted that the National Assembly's website provided template forms where citizens could tick boxes indicating support or opposition to the impeachment, but those forms offered only binary choices, allowed no uploading or supporting documentation, and permitted no opportunity for dialogue or nuanced analysis. This reduced public participation to checkbox voting rather than substantive constitutional engagement. They acknowledged in their submissions that the standard required was not perfection, but reasonableness. However, reasonableness is in a matter of this magnitude required the Speaker of the National Assembly and the National Assembly to have actively mobilized public awareness through non-public convergency points such as churches, mosques, temples, public barazas, national radio stations, vernacular broadcasting stations, and other accessible civil forums. The failure to which those avenues significantly restricted the reach of the notice and consequently diminished participation. The process was submitted to have been conducted on an extremely short notice, centralized into two venues and structured in a rigid and non-deliberative manner, and procedurally shallow through form-based engagements, all of which demonstrated a failure to meet constitutional standards and calling into question the validity of the impeachment of His Excellency Gachagua. It was further submitted that the removal of a deputy president from office was not merely an internal matter of parliament, but a matter of national constitutional significance affecting the democratic will of the electorate, the integrity of the executive structure, the political stability of the Republic of Kenya, and the sovereignty of the people, and that accordingly the electorate had to be accorded an opportunity to participate in a process that sought to overturn their democratic choice. Kituo cha Sheria submitted that even where Parliament acted within its constitutional mandate, when it undertook a process that received and evaluated evidence and reached determinations adverse to rights, reputations, and the tenure of office, it was obliged to meet minimum content on procedural fairness. It was submitted that the Senate proceedings bore all the hallmarks of a quasi-judicial trial, from pleadings, evidence, contested facts, adverse finding, to a grave sanction in the form of removal from office, and that Articles 47 and 50 of the Constitution and the Fair Administrative Actions Act 2015 therefore applied with full force. Impeachment of a national executive was not a mere political debate, but a structured constitutional trial with legal standards burdened with reputational, civil, and democratic consequences, which made the rights to be present, to cross-examine, and to be re-examined all the more imperative. It was submitted that Article 50, read together with Article 25C of the Constitution, and that scored that fair trial rights were non-derogable in substance, relying on Stephen Odede versus Court Maxwell, in which the court confirmed that the right to a fair hearing and right and fair trial ought not to be unduly impeded, and that a trial body had to be circumspect in purporting to limit and take away such crucial right, since Article 25C specifically provided that there was never to be any derogation from the right to a fair hearing. It was further submitted that while impeachment was sui generis, the logic of adversarial testing of allegations applied with equal, if not greater force. His Excellency Gachagua fell ill, was admitted for urgent medical care, and his counsel sought an adjournment, which was refused. The Senate proceeded in absentia without counsel, received and assessed evidence, and removed him from office, thereby extinguishing his ability to be present, to be cross-examined, and to be re-examined, and to participate meaningfully. It was submitted that a fair process entailed reasonable accommodation, including adjournment, where good cause was shown and no prejudice will be suffered that could not be compensated by way of cost or by way of time. Kituo cha Sheria relied on Githiga and 5 others versus Kiruti Factory Company Limited, in which the Supreme Court confirmed that the right to a fair trial indicated that the right to a fair hearing indicated that an individual shall not be penalized by a decision affecting his rights or legitimate expectation unless he had been given prior notice of the case against him, a fair opportunity to answer, and the opportunity to present his case. It was submitted that this was precisely what was not accorded to His Excellency Gachagua. It was further submitted that if the Senate could adjourn an entire sitting over quorum issues as per Standing Order 40, then refusing to adjourn to accommodate a hospitalized party where fairness and due process rights were under Articles 47 and 50 were at stake was unreasonable, disproportionate, and constitutionally infirm. They argued that the right to be heard required a real and effective opportunity to participate, not a mere formality, and included the right to attend and to answer the case one first, as well as the right to correct and contradict the allegations made against one. Further, that an adjournment was a recognized incident of a fair hearing where unavoidable circumstances prevented attendance or effective participation, and accordingly, the denial of a reasonable adjournment amounted to a denial of the right to be heard. The Senate could have proceeded in His Excellency Gachagua's absence if his conduct had made it impossible to continue the hearing, or if, after due notice, his notice was unjustified. In the present case, they submitted that that absence was explained as a medical emergency, and counsel had sought an adjournment. Proceeding to receive and evaluate adverse material in those circumstances, His Excellency Gachagua's ability to participate meaningfully was impugned. It was further submitted that in impeachment, the public interest was best served by accuracy and fairness, not speed for its own sake, and that where adverse oral evidence was received and weighed, cross-examination was then crucial for testing credibility, the denial of which hollowed out fairness and tainted the decision. It was submitted that expedition could not cannibalize fairness, and that Articles 10, 47, and 50 demanded reasonable accommodation, especially where a short adjournment would have cured the prejudice occasioned by a medical emergency. Kituo cha Sheria submitted that courts had emphasized committee and institutional respect, and that impeachment was principally a political and constitutional accountability process, but that Parliament had not been insulated from judicial scrutiny where constitutional requirements were breached. Relying on the Mwangaza case, Kituo cha Sheria recalled the court's pronouncement that impeachment was an invaluable safeguard against impunity and an abuse of office that had to be jealously protected and must not be allowed to become an avenue for fighting political proxy wars or resurrecting ballot box contestations. The court further stated that the court further stated therein that watering down impeachment, lowering its bar too low, or allowing it to become a facade, masking hidden political interests, ran the risk of Kenyans losing confidence in the process, and that the intervention of courts came far down the impeachment path, making it the duty of the primary duty bearers to ensure that impeachment remained a constitutionally envisaged. Kituo cha Sheria submitted that constitutional review was therefore available to term procedural impropriety in the exercise of public power, even in political charged arenas. Further reliance on the relying on the Wambora case, Kituo cha Sheria recalled the Court of Appeals statement that the process of removal lay entirely in the County Assembly, wherein it was initiated, and the Senate, wherein it was concluded, but that the court might only come in when necessary to confirm that the process had been properly followed as laid down in the Constitution and the statute. Accordingly, they submitted that the question before the court was not how the Senate should have voted, but whether it had obeyed the Constitution in getting there. It was submitted that Article 10 of the Constitution bound all state organs whenever they applied or interpreted the Constitution or enacted, applied, or interpreted any law or made or implemented public policy decisions and required good governance, integrity, transparency, accountability, human dignity, equality, social justice, inclusiveness, equality, human rights, and non-discrimination. An impeachment that shut out the subject's presence, cross-examination and re-examination, especially in a medical emergency, subverted human dignity, equality of arms, and accountability, and was thus unconstitutionally infirm. Kituo cha Sheria was not asking the court to supervise the National Assembly and the Senate debate or to substitute their judgment, but only to ensure that in reaching their determination, the constitutional procedures were observed. They sought a declaration that the impeachment proceedings conducted on the 16th October 2024 by the Senate were procedurally unfair, unconstitutional, and ultra-vires. A declaration that the Senate, acting as a quasi-judicial body, violated Articles 47 and 50 of the Constitution by denying cross-examination, re-examination, and a reasonable adjournment in the alternative. A reasonable adjournment. In the alternative, if the court was minded to preserve the proceedings, an order of remit directing the de novo hearing before the Senate in strict conformity with constitutional and statutory fair hearing requirements, including presence, representation, examination, disclosure, and reasonable determination, and such other orders as the court may deem fit to vindicate the Constitution and the public interest in a lawful, rational, and fair impeachment process. Kituo cha Sheria concluded its submissions by urging the Constitution that the Constitution erected procedural safeguards precisely because impeachment was a constitutional earthquake, where the Senate refused a short adjournment despite His Excellency Gachagua's hospitalization, proceeded in absentia, and delivered the ultimate sanction without the presence, cross-examination, and re-examination of the accused. The process failed the constitutional test. It was submitted that this court ought to intervene not to rewrite politics, but to enforce procedure, and in so doing, preserve Kenyans' commitment to the rule of law, constitutionality, accountability, and human dignity. We'll now proceed to responses and submissions to the consolidated petitions. We'll start with the second and the seventh respondents' cases. The National Assembly and the clerk to the National Assembly were the second and the seventh respondent in the consolidated petitions. They jointly responded to the petitions through replying affidavits sworn by its clerk, Samuel Joroge, on the 9th of October 2024 and the 21st of October 2024, and the grounds of opposition dated 4th of October 2024. They asserted that the impeachment process was entirely constitutional, lawful, and procedural fair, and that all actions were taken, all actions taken complied with Articles 145, 150, and 118 of the Constitution, as well as the National Assembly standing orders, as well and the court directives. They further posited that the impeachment of the Deputy President followed Article 150, Sub-Article 2 of the Constitution, which applies Articles 144 and 145 of the for the President with necessary modification, and that Standing Order 65-2 of the National Assembly explicitly states that Standing Order 64 applies to the Deputy President with necessary modifications as well. They deposed that the Speaker validly confirmed that the motion met the required legal form and the signature threshold of at least 117 MPs, or 1/3 of all members. That public participation was adequate, inclusive, and compliant with court orders, as the National Assembly placed advertisements in all three national dailies on the 2nd, 3rd, and 4th of October 2024. Public hearings were held on the 4th of October 2024 across the country, and that public and the public will submit views by way of email, post, hand delivery. A dedicated template in English and Kiswahili was provided, and they were also able to visit the constituency offices. The respondents contended that upon being served with a court order on the 3rd of October 2024, they extended public participation to the constituency level until 5th of October 2025, and that a public participation report was published. They asserted that the process was real and not illusory, that public participation was not part of the Deputy President defense, as it was meant to gather general public views to inform the Assembly, and that holding it first preserved the integrity and the independence of public input, preventing it from being influenced by the Deputy President's defense or parliamentary debate. The respondents maintained that the Deputy President still received his full right to be heard during the debate on the 8th of October 2024, where he appeared in person with his legal team. The respondents further claimed that one of the petitioners, Honorable Jane Jerry Maina, closed her Kirinyaga County Women Representative Office during public participation exercise, despite parliamentary officers being deployed there. Further, they reliably learned that the closure was directed by the woman representative herself, since she was vehemently opposed to the impeachment. The respondents averred that she cannot then benefit from her own actions that obstructed the public participation exercise. The respondents deposed further that after debate on the 8th of October 2024, the motion was put to a vote and 282 members voted in support of the impeachment and 44 voted against, which exceeded the required two-thirds majority under Article 145(2) of the Constitution. That on the 9th of October 2024, the Speaker of the National Assembly formally notified the Speaker of the Senate of the resolution by transmittal. The respondents denied any constitutional or otherwise wrongdoing and prayed that the constituted petitions against the National Assembly and the clerk be dismissed with course. In respect to their submissions, the National Assembly and its clerk's onslaught on the constitutional petition was led by learned counsel Mr. Eric Gumbo, Mr. Paul Nyamodi, and Honorable Gitonga Murugara. They identify the following issues for this court's determination. A, what is the extent of this court's jurisdiction to hear and determine the constituted petitions relating to the impeachment of His Excellency Gachagua? B, whether the sub judice rule under Standing Orders 89 and 103 of the National Assembly and the Senate Standing Orders bars parliamentary proceedings on impeachment where judicial proceedings are pending. C, whether the impeachment proceedings before the National Assembly were valid. D, whether the petitioners have demonstrated any valid grounds for challenging the impeachment proceedings conducted before the Senate. E, whether the impeachment unconstitutionally subverted the sovereign will of the electorate expressed in the 2022 general elections, contrary to Articles 1, 2, and 38 of the Constitution. F, whether the nomination, approval, and appointment of Honorable Kindiki as the Deputy President was invalid, and whether the petitioners are entitled to any of the reliefs sought. The National Assembly and clerk submitted that the impeachment of His Excellency Gachagua as Deputy President was constitutionally valid, procedurally proper, and politically necessary to uphold accountability and the rule of law. They also defended the subsequent nomination, approval, and appointment of Honorable Kindiki as Deputy President as fully compliant with the Constitution. Their positions remained that an impeachment is a political process, not a judicial one, and that the Constitution vests sovereign power in the people exercised through their elected members under Article 1, that the Constitution mandates public participation of strict timelines and bicameral supermajority representation requirements of the two-thirds in both houses, making the impeachment framework rigorous and transparent. They submitted that the comparative analysis with the United States, Philippines, Brazil, South Korea, and Nigeria shows that Kenya's process aligns with global presidential systems where impeachment is a constitutional safeguard against abuse of office. On the High Court's jurisdiction under Article 165 of impeachment proceedings, they submitted that such power is only residual and supervisory, not appellate, that impeachment is a political process entrusted to Parliament, and courts should not interrogate the substantive merits of impeachment charges. They added that the court's role is limited to ensuring procedural compliance and protection of individual constitutional rights, and citing the cases in Wambora and Sonko. They asserted that the courts must show deference to Parliament in matters where the Constitution grants Parliament discretion. Learned Counsel also cited the decision in the Supreme Court of Philippines in Re Sara Duterte, which similarly held that courts will not encroach on co-equal branches on political questions. It was their further submission that Standing Order 89 of the National Assembly and 103 of the Senate do not absolutely bar discussion on matters pending in court, and a matter is sub judice only if discussion is likely to prejudice fair determination of active proceedings. They stated that the petitioners did not raise any sub judice objection during the parliamentary proceedings, and they cannot raise it now. The National Assembly and clerk submitted that the Constitution itself imposes tight timelines under Article 145, that is 2 days to notify Senate, 7 days to convene a Senate, and 10 days for the committee investigation. They contended that impeachment is urgent, as prolonged proceedings will cause political uncertainty and undermine governance. The standing order were a legitimate excess of parliamentaries' power under Article 124 to regulate its internal affairs, and that timelines are constitutionally anchored and not subject to judicial invalidation, as was held in Mbarak Issa Kombo's case. It was their further submission that public participation was adequate, as the National Assembly issued notices in the Kenya Gazette, national newspapers, news website, and social media on the 2nd, 3rd, and 4th of October 2024. Public hearings were held at county and constituency levels, including compliance with Justice Mwongo's order on constituency level participation, and 223,083 citizens submitted views, which they stated was an unprecedented level of civic engagement. Further, that the public views template was provided in English and Kiswahili. Submissions were received orally, in writing, and electronically. They also submitted that the constitutional standard is reasonableness, not perfection, and that the Supreme Court and Cabinet Secretary for National Treasury and Planning and 4 others versus Okoita and 52 others held that timelines must be considered when assessing public participation adequacy. They submitted that His Excellency Gachagua's response was not required to be circulated simultaneously, as the public role is to express views, not adjudicate, and that allegations of violence, intimidation, and poor organization were unsubstantiated, and that isolated incidents do not vitiate an entire process. They also submitted that public participation report was submitted in Parliament and recorded in the Hansard, which is a valid parliamentary record. They stated that the impeachment motion was properly particularized and set out 11 detailed grounds with specific particulars, and that these grounds met the threshold set in the Wambora's case of being serious, substantial, weighty, with clear nexus and precise constitutional provisions. That the motion was supported by 282 MPs, which was well above the 2/3 requirement of 233 MPs, and that the Deputy President was accorded a fair hearing, as he received prior notice of the charges. He filed his written response and appeared in person with counsel, and he was given 2 hours to address the National Assembly. The National Assembly and the clerk also submitted that His Excellency Gachagua's defense was considered and debated before the vote, and that the 2/3 gender principle does not invalidate Parliament, as Articles 97 and 98 on the composition of Parliament have been fully complied with. On the 2/3 gender principle under Article 81B, it was submitted that this was an aspirational provision to be achieved progressively, not a condition not condition precedent to Parliament's validity. And that Article 261 provides a mechanism for addressing legislative delays, and that no advice from the Chief Justice or action by the President has occurred to dissolve Parliament. They contended that accepting the petitioner's argument would void all legislation and action since 2013 and will be an absurd and constitutionally impermissible outcome. On the allegation of bias against the Deputy Speaker, they submitted that allegations were unproven, and further that the Deputy Speaker only performed administrative and procedural functions and that she did not vote. Further, no recusal motion was raised during the proceedings. They stated that the test for bias is objective, as stated in the Supreme Court in Rawal and others, and that the threshold had not been met in this matter. Counsel added their voice to the position that the Senate handled the impeachment hearings by hearing the charges in plenary, since Article 145, Subarticle 3A, mandates the Senate to convene and hear such charges. That Article 145, Subarticle 3B, uses the word may, and therefore the appointment of a special committee was discretionary and not mandatory. And the semicolon and in Article 145, Subarticle 3, do not convert the discretionary power into a mandatory obligation. They reiterated that the Senate motion to appoint a special committee on the 9th of October failed as it was not seconded, and the Senate then properly proceeded in plenary. They relied on the Supreme Court Court and Sonko case that confirmed that for governors, the Senate may proceed in plenary or by committee, and that the same applies to the Deputy President. It was also their submission that the 10-day timeline for plenary proceedings was constitutional, as where the Constitution is silent, the Senate may regulate its own procedures under Article 124, Subarticle 1, and the 10-day deadline was a reasonable exercise of procedural autonomy to ensure expedition. Counsel submitted that impeachment must be concluded without undue delay, and the timeline reinforced accountability and good governance. It was their father's position that His Excellency Gachagua received a fair hearing in the Senate, as he was represented by counsel throughout. He was cross-examined at the National Assembly, and he cross-examined National Assembly witnesses, and he filed witness affidavits on the 12th and 13th of October 2024. They contended that the Senate did not refuse an adjournment, and reasonably, a senior counsel Muite was given from 2:30 p.m. to 5 p.m. to contact His Excellency Gachagua, that no medical evidence of either a doctor's report or prescription was provided to the Senate, and that the Senate offered to adjourn until Saturday, 19th, October 2024, within the constitutional time frame. But this motion failed on a vote. The National Assembly and the clerk submitted further that the decision to proceed in absentia did not violate fair hearing, as His Excellency Gachagua had already filed his evidence and opted out after cross-examining the National Assembly's witnesses. That no new evidence was introduced. All material before the Senate had already been placed before the National Assembly and forwarded to the Speaker, and time allocation was not disproportionate, as both parties were accorded equal time. The National Assembly submitted that it also could not call all its witnesses due to time constraints, and that this was a consequence of expedition and not bias. They further submitted that the Senate had no independent duty to conduct public participation, which under Articles 10 and 118 applies primarily to legislative functions. The Senate, when hearing impeachment, acts as a quasi-judicial capacity, not a legislative one, and that public participation occurs at the National Assembly during the initiation stage, not at the Senate at the trial stage. Counsel submitted that comparative practice in South Africa, USA, and in the USA, Nigeria, and Brazil confirms that the upper house role is adjudicatory, not participatory, and that the court in Mwangaza versus Speaker of the Senate held that public participation in gubernatorial impeachment occurs at the county assembly level, and the same applies in equal measure in this matter. The respondents contended that allegations of bias against the Senate Speaker remained unproven, as a Speaker's role is presiding and procedural, and he has no deliberative vote. That mere coalition membership does not establish bias, and that the petitioners have not pointed to any specific or act or omission showing a real possibility of bias. They restated that the test for bias is objective, and the petitioners failed to meet it, as well as in respect of the Senate Speaker. It was the submission of the National Assembly and the clerk that the participation of Honorable Orengo and Honorable Amolo as counsel did not invalidate the proceedings, in that Article 77(1) restricts gainful employment that is inherently incompatible with state office, and that presenting a party in proceedings is not such an employment. That any alleged illegality would affect the advocates personally and not the validity of the impeachment process, and that no actual bias or procedural fairness has been shown. They further submitted that the Senate applied the correct standard of proof for impeachment, which is above a balance of probabilities but below beyond reasonable doubt, as set out by the Supreme Court in the Sonko and Wambora cases. The Senate found 5 charges substantiated, including gross constitutional violations, attacks on judicial independence, ethnic incitement, gross misconduct, and that the evidence was substantial and credible, including His Excellency Gachagua's own public admissions. Learned Counsel submitted and urged that the court should not undertake a merit review of the Senate findings. Counsel reiterated that impeachment does not subvert the sovereign will of the people, as it is not an affront to democracy, but an affirmation of accountability. That the Constitution provides for removal of elected officials for gross misconduct, constitutional violations, and crimes, and that the joint ticket of the President and the Deputy President does not create legal inseparability, as they are separate constitutional offices with distinct and accountability mechanisms, and Counsel gave comparative analysis of the U.S. Vice President resignations while President Nixon remained, and Brazil's President Rousseff's impeachment while Vice President Temer assumed office when they submitted that removal of deputy does not require removal of the principal. They contended that Article 150 of the applies Article 145 with necessary modifications, and that this acknowledges that distinct offices are not a merger. On the validity of His Excellency Kindiki's nomination, approval, and appointment, the National Assembly and the clerk submitted that a lawful vacancy arose by operation of law under Article 145(7), as the impeachment was valid. They stated that IBC clearance was not constitutionally required for a deputy president nomination under Article 149, and that the president merely sought information of the voter registration status and MP qualifications from IBC as a matter of prudence. Counsel submitted that IBC Secretariat acted within administrative mandate by providing information which is not commission-led constitutional function. Counsel referred this court to the Supreme Court advisory opinion in IBC versus AG 2025, where it drew a distinction between commission-led functions such as boundary delimitation and secretariat administrative functions, including the day-to-day operations. They submitted that providing information falls within the latter. It was their submission that His Excellency Kindiki met constitutional qualifications for appointment, as he is a Kenyan citizen by birth, qualified to be an MP and nominated by a political party, UDA, thus satisfying Article 137 as read with Article 148, and that his party membership was properly documented with the register of political parties. They contended that allegations of misconduct during His Excellency Kindiki's tenure as Cabinet Secretary were mere allegations, and that no judicial or quasi-judicial finding of culpability exists, and that the court in International Center for Policy and Conflict and 5 others versus AG, reported 2013, held that unproven allegations cannot disqualify a candidate. That holding a cabinet secretary position did not disqualify him under Article 77, as this provision prohibits gainful employment that creates a conflict of interest, but does not bar a state officer from seeking elective office. The council submitted that disqualification for holding state office is governed by Article 137, Subarticle 2B, that requires resignation 6 months before a general election, but it is not applicable to a midterm vacancy, which process under Article 149 is sui generis. The National Assembly submitted that the voting process complied with Article 149(1), which requires the National Assembly to vote on the nomination, which is an electoral determination by plenary, not an approval process requiring committee vetting. That the Speaker correctly distinguished between appointive officers subject to committee approval and the elective process of Deputy President under Article 149(1). It was argued that the Public Appointments and Public Appointments in brackets Parliamentary Approval Act and the Standing Order 45(3) do not apply to this sui generis constitutional process, and that the Supreme Court entrusted a Society for Human Rights Alliance versus Matemo and 3 others held that where the Constitution provides a specific procedure, statute cannot add to or amend it. It was also their position that no public participation was required for the nomination under Article 149, Subarticle 1, does not prescribe public participation, and that the nomination and approval is an executive-led elective process, not legislative business, under Article 118. That it will be incongruous to require more process for a midterm vacancy than a general election, where the ticket is approved by popular vote without prior public hearings. For the aforementioned reasons, the National Assembly and the clerk urged the court to dismiss all relief sought in the with the council submitting that no constitutional violations had been proved. The impeachment was procedurally regular and substantively justified. Damages are not automatic, as no breach had been established, and awarding damages would punish Parliament for performing its constitutional duty. That pension and retirement benefits are for honorable retirement, not for removal by impeachment, and that quashing the resolution and nullifying His Excellency Kindiki's appointment will create a leadership vacuum and constitutional chaos. Council thus urged this court to dismiss the constitutional petitions with cost to them, find that the impeachment of His Excellency Gachagua was lawful, constitutional and procedurally proper, and that the nomination, approval, and appointment of His Excellency Kindiki as Deputy President was valid and constitutional, and that the court should decline to grant any of the relief sought by the petitioners. On the 3rd and 4th respondents' cases, the Speaker of the Senate and the Senate, who are the 3rd and the 4th respondents respectively, challenged the consolidated petitions through the affidavit sworn by Jeremiah Nyegenye, who is the clerk of the Senate and secretary to the Parliamentary Service Commission. The affidavit was deposed on the 21st of October 2024. From the outset, it was their case that under Articles 93(1), 96, Subarticle 4, and 145 and 150 of the Constitution, the Senate is mandated by with the role of considering the impeachment of a deputy president. They asserted that process is guided by the National Assembly's Standing Order 64 and 5, which dictates the procedure for introducing and supporting an impeachment motion. To that end, it deposed that on the 1st of October 2024, Honorable Mutuse introduced a motion in the National Assembly seeking the removal of His Excellency Gachagua on the basis of 11 grounds, including gross violations of the Constitution, undermining, devolution, attacking independence of judges, committing economic crimes, and public subordinating publicly subordinating the president. It was their position that the National Assembly conducted extensive public participation from 2nd to 5th of October 2024 and formally approved the motion on the 8th of October 2024. Following the approval, the Speaker of the National Assembly notified the Speaker of the Senate of the resolution in a letter received on the 9th of October 2024, which included the motion, electronic evidence, relevant Hansard reports, public participation, advertisement and reports, and court orders. He asserted that the Senate Speaker convened a sitting on the 9th of October 2024 through Gazette Notice number 13170, during which a motion to establish a special committee to investigate the matter was defeated. As such, the proceedings had to be held in plenary, and it was deposed that the Speaker designated 16th and 17th of October 2024 for the plenary hearings formalized in Gazette Notice number 13178. Speaking to the fairness in the process, the clerk deposed that on the 9th of October 2024, the Senate served an invitation to His Excellency Gachagua and the National Assembly to appear to submit witness details and evidence. It was the case that on the 14th of October 2024, His Excellency Gachagua indicated his presentation by Mrs. Swanya and company advocates and filed his response to the allegations alongside supporting evidence. They stated that the plenary hearings commenced on the 16th and 17th October 2024, and after the National Assembly concluded its case on the 17th of October 2024 at 1:15 p.m. His Excellency Gachagua, lead counsel Mr. Paul Muite, senior counsel, informed the Senate at 2:30 p.m. that his client was missing and had been taken ill. It was pointed out that after suspending the proceedings until 5 p.m., counsel requested an adjournment to 22nd October. He stated that a substantive, subsequent procedural motion to sit on Saturday, 19 October 2024, to meet the constitutional deadlines was defeated, prompting His Excellency Gachagua's counsel to exit the proceedings. They maintained that the Senate, across the judicial body, exercised discretion in granting adjournments, and His Excellency Gachagua's counsel failed to provide cogent material evidence of his illness. As regards the constitutional timelines, it was their case that impeachment could not be posed without violating the Constitution. They refuted the claim that the trial occurred in absentia since His Excellency Gachagua had actively participated through his advocates' opening statements, cross-examination, and the National Assembly's witness and filing of the respective witness affidavits. In challenging the claim that the public participation was not conducted, the Senate and the Speaker stated that an order of the High Court in Kerugoya did not mandate the Senate to conduct public participation, as the Senate functions exclusively as a trial chamber akin to a court. In conclusion, it was disposed that the Senate voted on the impeachment charges, where 5 charges comprising ground 1 on gross violation of the Constitution, ground 4 on undermining the independence of judges, ground 5 fidelity to the oath of office, ground 6 on crimes under national cohesion, and ground 9 on gross misconduct and ground 9 on gross misconduct concerning NAS were substantiated by the required majority. The clerk deposed that the Senate resolved to impeach His Excellency Gachagua, a decision officially gazetted on 17th of October through Gazette Notice number 13400. On the foregoing, this court was urged to find that the impeachment power is inherently political and vests solely in Parliament, which triggered the political question doctrine, thereby inviting this court to exercise judicial restraint. Ultimately, the Speaker of the Senate and the Senate prayed that the petitions be dismissed with cause. The third and fourth respondents filed submissions dated for the 24th of April 2026, and they were highlighted by their legal team led by Professor Tom of Gender Senior Counsel, Mr. Edwin Mukele, Ms. Mercy Thanji, Ms. Opola, and Honorable Hilary Sigei. They maintained that the entire impeachment process meticulously complied with all constitutional timelines, including standing orders and the principles of natural justice. On the question whether His Excellency Gachagua was accorded a fair and reasonable opportunity to be heard, they submitted that the hearing aligned with the due process and the Audi Alteram Partem rule to define the threshold of a fair trial. They relied on the Black's Law Dictionary, 7th edition, at page number 725, and the Halsbury's Laws of England, 5th edition, 2010, volume 61, at paragraph 639. The dictionary defines the right to be heard as follows, and I quote: the rule that no person is to be condemned unless that person has been given prior notice of the allegations against him and a fair opportunity to be heard is a fundamental principle of justice. This rule has been refined and adapted to govern the proceedings of bodies other than judicial tribunals, and a duty to act in conformity with the rule has been imposed by the common law on administrative bodies not required by statute or contract to conduct themselves in a manner analogous to a court. End of quote. To bolster their case, the Senate and the Speaker referred to the President in Evans'
Eje Nensoko TV, Oboroso Bumugusi.
To present their case, comment, or call witnesses. As regards the sufficiency of written evidence and constructive waiver, they stated that His Excellency Gachagua fully participated in the initial phases of the trial by filing comprehensive responses, witness statements, and documentary of video exhibits, which legally constituted his defense in chief under Rule 6 of the second schedule to the Senate standing orders. They submitted that an oral hearing is not an absolute prerequisite for natural justice, and they fortified their position through the decision in Economic Freedom Fighters and 3 others versus Speaker of National Assembly. This is a South African case, and the Kenya Revenue Authority and Menginya versus Menginya Salim Magara's case. They also relate to Swalwarjan versus Race Relations Board Limited. This is a foreign case, as well as R versus Immigration Appeal Tribunal. They also referred to the case of Jacob Ochanda versus Kenya Hospital Association Limited to demonstrate that a hearing can be fairly conducted through written representations. The Speaker and the Senate faulted His Excellency Gachagua, stating that because he chose to walk out of the proceedings after the Senate had voted down an adjournment, it was deliberate boycott. They implored the court to find that voluntary absence constituted a constructive waiver of the right to be heard orally. Support to that end was drawn from various authorities, among them Regina versus Jones, R versus Governor of Brixton Prison, and the Ghanaian Supreme Court case in the Republic versus High Court of Accra. They affirmed that the Senate acted within its lawful discretion when it denied His Excellency Gachagua's request to adjourn the proceedings due to his sudden hospitalization. In reference to the decision of the Supreme Court in Sonko and the Mate, the Senate and the Speaker emphasized that courts must be slow to interfere with the internal affairs and the procedural discretion of Parliament. Further support was drawn from the decision of the Supreme Court in the famous cycle agencies case and 4 others versus Mansukulal, Ramji Kuria, where it was observed that an adjournment requires sufficient cause based on proper materials. They argued that without formal medical proof of total incapacitation, the Senate was not required to stop its proceedings. To further credence to the foregoing position, they found support from the decision in Serem versus Republic, Court of Appeal decision, and Okaka and another versus Odundo, High Court decision. And it was their case that the strict approach was dictated by the mandatory 14-day timeline to dispose of special motions under Senate Standing Order number 74-2A. On the question whether investigation of charges met the requisite standard of proof, the Senate asserted that it thoroughly investigated and voted on each individual charge according to the established intermediate standard of proof, which is above a balance of probability but below reasonable doubt threshold. It was their case that the standard was set by the Supreme Court in the Sonko case, which declared that proving even a single charge is legally sufficient to sustain an impeachment. Consequently, they submitted that the court must decline to reevaluate the evidence or substitute its own finding for the political question decided by the Senate under Article 96, Sub-Article 4 and Article 145, Sub-Article 3 of the Constitution. On the question challenging His Excellency Gachagua's claim that the Senate acted unprocedurally by failing to form an 11-member special committee under Article 143, Sub-Article 3B, the Speaker and the Senate submitted that the word may in the Constitution and Rule 2 of Part 1 of the second schedule to the Senate standing orders grant the Senate absolute discretion to choose between a committee or full plenary. They submitted that such interpretation is anchored in the Supreme Court case in the matter of the Speaker of Senate rendering or referencing the matter of interim independent electoral commission and the Court of Appeal decision of Cooperative Bank of Kenya Limited and versus Banking Insurance Finance Union, which is a Court of Appeal decision. They contrasted Article 135, Sub-Article 3B with Article 152, Sub-Article 7 of the Constitution, which uses the mandatory phrase, shall appoint, when dealing with the dismissal of Cabinet Secretary. It was their case that since a motion to form a special committee was moved but failed to be seconded under Standing Order 70, the Senate properly proceeded in plenary, meticulously satisfying the oversight parameters affirmed in the by the Supreme Court decision in the Sonko case. As regards the contentious issue of public participation, they contended that there was no legal basis for the Senate to conduct a secondary round of public participation because the National Assembly had already completed a rigorous national public participation drive between the 2nd and the 5th of October 2024 through extensive media notices and public feedback templates. They submitted that to demand a repetitive exercise from the Senate would be an imprudent waste of state resources. Separately, the Speaker and the Senate submitted that during an impeachment trial under Article 145 3A, the Senate acts exclusively as a quasi-judicial body evaluating specific charges rather than performing a standard legislative function, exempting it from public participation requirements of Articles 10 and 118. They dismissed the argument that Parliament was illegally constituted due to a threshold failure to implement the two-thirds gender rule. They further submitted that although the former Chief Justice David Maraga issued a dissolution advisory to the 4th President, the 12th Parliament dissolved by operation of law and the 13th Parliament was lawfully established following the general elections of the 9th August 2022. Seeking to rely on Article 261, Sub-Article 5 running to 7, the Senate and the Speaker submitted that the ground that the gender rule mechanism is intended to compel future compliance and not to retroactively invalidate state operations. They warned that declaring Parliament unlawful would cause an absurd constitutional crisis, invalidating national budgets, legislation, and public appointments, which violates the governance promotion mandate of Article 259 of the Constitution. They urge the court to practice judicial restraint as the gender dispute is actively pending before a 5-judge bench in Conchela and others as the Chief Justice and President of the Supreme Court in Kenya and others. The Speaker and the Senate rejected the allegation that the Senate was mandated to conduct an approval hearing for filling the subsequent vacancy of the office of the Deputy President. They pointed out that Article 149, Sub-Article 1 of the Constitution, expressly grants the exclusive mandate to vote on and approve a nominated Deputy President to the National Assembly, entirely omitting the Senate. It was their case that by applying the statutory construction principle established in the case of Federation of Women Lawyers Kenya, FIDA versus AG, the Initiative of Strategic Litigation in Africa, statutes could be interpreted to override the explicit, statutes could not be interpreted to override the explicit text of the Constitution. On the strength of the foregoing submissions, the Speaker and the Senate urged the court to dismiss all the consolidated petitions with costs.
I will take over from the fifth respondent's case. The Attorney General, that is the fifth respondent, challenged the petitions through grounds of opposition dated the 7th of November 2024. She argued that the court should not elevate Parliament's factual assessments since its role is strictly to ensure that reasonable inferences were drawn from the available evidence. It was her case that the removal proceedings against H.E. Gachagua were purely legislative, neither entirely administrative nor judicial, and therefore were not subject to standard administrative or judicial review as suggested under Article 47(3)(a) of the Constitution. Further, the Attorney General asserted that the court could not substitute the legislature's discretionary decision with its own, as doing so would constitute a usurpation of the constitutional functions of an independent branch of government. She maintained that the proceedings before the legislature were lawful, efficient, expeditious, and procedurally fair, since the adopted procedure successfully balanced the need to protect H.E. Gachagua's constitutional rights, safeguard the process from abuse, and prevented unnecessary disruptions to public administration. Regarding public participation, the AG clarified that the Constitution did not permit members of the public to vote on an impeachment motion, as that discretion was expressly reserved for legislators who constitutionally represent the sovereign will of the people. It was explained that the National Assembly's role in the impeachment process was strictly preliminary and did not bind the Senate, which acted as a distinct state organ responsible for substantive proceedings and the ultimate decision. It described the consolidated petitions as disguised appeals regarding the merits of Parliament's decision and argued that the judiciary lacked an appellate mandate over the impeachment of a deputy president, since it is ill-equipped and constitutionally not designed to review or reevaluate the socio-economic and political utilitarian calculations made by elected officials. Finally, the Attorney General defended the subsequent nomination and voting into office of His Excellency Kindiki, and it was her case that the replacement process under Article 149(1) of the Constitution was sui generis, qualifying neither as an election nor an appointment, which meant that the provisions of Article 137 did not apply. The Attorney General concluded that there were no procedural infractions that affected the outcome, that the transition process was conducted within constitutional timelines by the proper constitutional repositories, and that the consolidated petitions lacked merit. The fifth respondent submissions are dated 4th March 2026. They were orally highlighted by a team of counsel led by Professor Githu Muigai, Senior Counsel, alongside the Solicitor General, Mr. Shadrach Mose, Mr. Emmanuel Bita, now a judge of the High Court, and Mr. Charles Mutinda. The Attorney General submitted that accountable governance was a core part of the Constitution, which established removal from office through impeachment as one of the tools of governance amongst the many avenues of exercising oversight and facilitating accountability. He relied on the Supreme Court decision in Sonko, where the Apex Court stated that its purpose was to ensure integrity in leadership and prevent abuse of public office. It was the Attorney General's submission that the removal of proceedings for a deputy president was textually committed by the Constitution to the National Assembly and Senate, and that both institutions were vested with exclusive power to remove the deputy president, subject only to procedural requirements set out in the Constitution and in the standing orders, that both houses were free to determine the procedures for receiving and considering the evidence necessary to discharge their duty to conduct impeachment hearing. With regard to the constitutional basis for impeachment, the Attorney General cited Articles 150, 144, and 145 of the Constitution, which she submitted established a sequential two-stage process. In the first stage, a member of the National Assembly initiated the process by filing a notice of motions supported by at least a third of all the members, which motion, if passed by at least 2/3 of all the members, was then transmitted to the Senate for substantive hearing. On the substance of the charges, the Attorney General submitted that the charges against H.E. Gachagua were substantiated to the prescribed standard to warrant his impeachment. She identified the specific charges upon which H.E. Gachagua was found culpable. On the standard of proof applicable to impeachment proceedings, the Attorney General relied on Sonko and the Court of Appeal decision in Wambora, both of which we have already referred to, which had held that the standard was above a balance of probability but below reasonable doubt, and that the allegations must be serious, substantial, and weighty, and must disclose with a degree of precision the constitutional provisions alleged to have been grossly violated. The Attorney General submitted that this court should not sit on appeal over Parliament's evaluation of facts and should not substantiate the discretion of the members of the legislature with its own. The Attorney General further relied on the advisory opinions of the Supreme Court in the Speaker of Senate and another, as well as the matter of the IEBC 2011 Supreme Court decision for the proposition that governmental powers were distributed among different organs, each exercising distinct functions under the Constitution, and that courts were required to respect the institutional mandate of a Parliament. The doctrine of presumption of regularity was equally invoked, encapsulated the doctrine of presumption of regularity, and it was submitted that government action enjoyed a presumption of legality and that the burden lay on the challengers to demonstrate unlawfulness. The Attorney General relied on the Supreme Court's decision in Odinga and another versus IEBC, our court and another, as well as it's the same decision, Odinga and another versus the IEBC, including our court and another, the Attorney General and another as interested parties and amicus. On a comparative method, comparative jurisprudence, the Attorney General submitted that both the United States and the Philippines recognize the political nature of impeachment proceedings, and the power is vested in the legislature, thereby warranting judicial deference to the merits of legislative decisions. The Attorney General relied on the case of Nixon versus the United States, where the United States Supreme Court held that challenges to Senate impeachment procedures were non-justiciable under the political question doctrine, as well as the Duterte decision that we have already cited. On the part of the petitions relating to the nomination and approval of H.E. Kindiki, the Attorney General submitted that the provisions of Article 149 envisaged a sui generis procedure for the nomination and assumption into office of a deputy president. It was the Attorney General's submission that the process under Article 149(1) was neither an election in the traditional sense nor an appointment, as the text of the Constitution employed neither of those terms. In support of the sui generis nature of the process, the Attorney General drew on comparative constitutional provisions from the USA, Ghana, and Nigeria, each of which provided for a distinct mechanism of filling a vacancy in the office of Vice President through presidential nomination and legislative confirmation. The Attorney General submitted that as H.E. Kindiki was nominated by the President within 14 days after the vacancy arose, and the National Assembly voted on the nomination within 60 days, there had been no infringement of either the text or the spirit of the Constitution. Moving to the 9th respondent's case, the Honorable Mutuse responded to the consolidated petitions through a replying affidavit sworn on 22nd October 2024. He deposed that on 1st October 2024, pursuant to Article 150B, read with 145 of the Constitution and the Standing Order 64 and 65, he gave a notice of a special motion for the removal from office by impeachment of H.E. Gachagua. He was aware that the special motion was a time-bound exercise pursuant to the Standing Order 64.2 and 65, which required that it be disposed of within 7 days of the notice being given, failure to which it would be deemed as withdrawn. Honorable Mutuse averred that while Articles 145 and 150 of the Constitution and Standing Orders did not expressly require public participation in a special motion, Article 118(1)(b) of the Constitution imposed on the Speaker of Parliament the obligation to facilitate public participation in legislative and other business of Parliament and its committees. He deposed that it was in that spirit that the National Assembly, with a view to facilitate public participation, invited members of the public to submit their views, and public hearings were thereby conducted across all the 290 constituencies on 4th October 2024. A notice dated 4th October 2024 by the Clerk of the National Assembly extended the period of public participation to 5th October 2024. Honorable Mutuse confirmed that on 8th October 2024, Honorable Millie Odhiambo MP tabled the public participation report before the National Assembly. Honorable Mutuse further deposed that on the 3rd of October 2024, the High Court sitting in Kerugoya issued orders directing the National Assembly to organize, facilitate, and conduct further public participation at the constituency level, and that the National Assembly complied with those orders by extending the exercise to the 5th of October 2024. Honorable Mutuse stated that following the tabling of the public participation report, the members of the National Assembly debated the special motion and that H.E. Gachagua appeared in person for the hearing. After debating and hearing both parties, the members of the National Assembly met the threshold set under Article 145(2) by passing and approving all 11 grounds of the special motion. Honorable Mutuse affirmed that the entire impeachment process, from the tabling of the special motion dated 26 September 2024 at the National Assembly to the Senate's resolution, had fully complied with all legal procedure provided in the Constitution and relevant laws. Honorable Mutuse emphasized that this court had a judicial and not a political mandate, and that its function was to certify whether all procedural provisions of law had complied with constitutional principles, which was a judicial function. He averred that the issues raised by the petitions raised a political question, a principle of law that referred to cases that courts could not resolve because they involved questions about the judgment of actors in the executive or legislative branches and not the authority of those actors. Honorable Mutuse also cited the position taken by courts in Paraguay, India, Lithuania, and the Philippines to demonstrate that jurisdiction practicing a presidential system of government had been appreciative of the political question doctrine in impeachment matters. He tabulated comparative examples of impeachment proceedings of USA presidents to show that in those jurisdictions, the fate of impeachment was left to political devices as opposed to judicial determination. Honorable Mutuse further deposed that under Article 94(2) of the Constitution, the National Assembly and Senate manifested the diversity of the nation and represented the will of their people and exercised their sovereignty. In conclusion, he urged the court to appreciate the prudential standing principle of self-restraint as a jurisdictional limitation on its power and prayed that the petitions be dismissed. Honorable Mutuse filed written submissions. Those were dated the 15th of February 2026 and were supplemented on 5th of May 2026. They were anchored on two issues: whether H.E. Gachagua was validly impeached, and secondly, whether the impeachment process was procedural. He submitted that H.E. Gachagua was impeached on grounds on various grounds under the Constitution, violation of national laws, and gross misconduct arising from his conduct. It was Honorable Mutuse's submission that the question for the court was not the political wisdom of the impeachment, but whether the grounds for removal had met the constitutional threshold under Article 145(1). Honorable Mutuse further reiterated his position that public participation was not expressly required under Article 145 and 150 or the standing orders, and relied on the case of BAT, submitting that even if there were allegations of lack of public participation, the same would not automatically vitiate the process. He further submitted that the petitioner's demand for public participation in the Senate was legally untenable, as the Senate acted as a quasi-judicial forum during impeachment processes. He submitted that the duty of Senate was to ensure a fair hearing for the accused, not to solicit public opinion on the charges. Honorable Mutuse further relied on the mandatory constitutional timelines governing impeachment proceedings and relied on the Supreme Court's decision in Mate, which held that constitutionally prescribed timelines were of mandatory character and binding on governance processes. In his supplementary submissions, he expounded on the six-part Baker test to Kenya's constitutional framework. On the first formulation, on textual commitment to a coordinate political department, he submitted that Article 150 expressly delegated impeachment to the National Assembly and Senate, satisfying the first condition. He relied on the Supreme Court statement in Sonko that where the Constitution required Parliament to determine a matter in the first place, the courts would be slow to interfere. On the second formulation, on the lack of judicially discoverable and manageable standards, he submitted that Article 145(7) envisaged the finality of the Senate's determination with no provision for judicial appeal or standard or review. On the third formulation, on the impossibility of deciding without an initial policy determination, he submitted that assessments of gross misconduct incompatible with the high calling and dignified status of the office and serious reasons to believe crimes had been committed were inherently political and policy-laden beyond the competence of courts. On the fourth formulation, on the impossibility of independent resolution without expressing lack of respect for coordinate branches, Honorable Mutuse submitted that a merit review of the Senate's determination would substitute the court's judgment for that of elected representatives, constituting a profound expression of disrespect for a coordinate branch. On the fifth formulation, that is the unusual need for adherence to political decision already made, Honorable Mutuse submitted that the vacancy created by the Senate's resolution had already been filled through the nomination, approval, and swearing-in of His Excellency Kindiki as Deputy President. He submitted that to reopen the impeachment question at that stage would create constitutional chaos, cast doubt on the legitimacy of the current office holder, undermine executive suitability, expose the political life of the country to prolonged chaos, as cautioned in Nixon. On the sixth formulation, on the potentiality of embarrassment from multifarious pronouncements, Honorable Mutuse submitted that if the court entertained a merit review and reached a different conclusion from the Senate, conflicting pronouncements from different arms of government would undermine public confidence in all institutions and weaken the constitutional order. Honorable Mutuse therefore urged the court to appreciate the prudential principle of judicial self-restraint as a jurisdictional limitation on its power to hear and determine consolidated petitions on the basis that they raised a purely political question whose determination would be tantamount to subverting the will of the Kenyan people. He accordingly prayed that the consolidated petitions be dismissed with costs. The 10th respondent's case, the 10th respondent was the United Democratic Alliance, UDA, who challenged the petitions through grounds of opposition dated 6th October 2025. UDA claimed that the petition is untenable since it irregularly and craftily sought to convert political grievances into constitutional disputes, contrary to the Supreme Court decision in Sonko. Pursuant to the Supreme Court's advisory opinion in Speaker of the Senate versus the Attorney General, UDA urged this court to exercise restraint and avoid interfering with the proceedings of Parliament, except in the clearest cases of constitutional violations. The 10th respondent filed written submissions dated the 24th of August 2026, which were highlighted by Counsel Dr. Adrian Kemotho. On the procedure for impeachment, UDA submitted that Article 151 provided for the grounds of impeachment of a deputy president being gross violation of a provision in the Constitution or any other law, serious reasons to believe that the deputy president had committed a crime under national or international law or gross misconduct. It's admitted that Article 152 applied the provisions of 144 and 145 with necessary modifications to the removal of the deputy president. The UDA submitted that having been accorded a right to be heard both at the National Assembly as well as the Senate stage and to be represented in the proceedings, His Excellency Gachagua was found culpable of publicly attacking and undermining the work of the NIS and its officials, undermining the institutional, functional, and decisional independence of judges, and persistently making inflammatory, reckless, and insightful public utterances threatening to discriminate against and exclude sections of the people of Kenya from public service appointments and allocation of public resources amounting to gross violation of the Constitution. It was submitted that the charges were proven to the requisite standard and that the procedure of impeachment under Article 145, 1 and 2 of the Constitution, as well as the applicable standing orders, was followed to the required standards. On the nomination and approval of H.E. Kindiki, UDA submitted that Article 149(1) of the Constitution required the President to nominate a person within 14 days of a vacancy arising and the National Assembly to vote on the nomination. It was submitted the article did not contemplate an appointment, approval of an appointment, nomination by a political party, or the holding of an election as erroneously alleged by the petitioners. UDA submitted that His Excellency Kindiki was nominated within the 14-day period. The National Assembly voted in support of the nomination on 18th October, which was within the 60-day period, and the Speaker of the National Assembly published the resolution via Gazette Notice 13401. It was submitted that the nomination, approval, and swearing in of His Excellency Kindiki were all done in accordance with the law and without any violation of Article 149 of the Constitution. UDA concluded by submitting that the people of Kenya, through their duly elected representatives in the National Assembly and the Senate, had impeached His Excellency Gachagua in order to safeguard integrity in leadership in accordance with the Constitution, the National Assembly and Senate standing orders, and all applicable laws. It was submitted that the decision to impeach His Excellency Gachagua reflected the will of the people of Kenya, which the court should uphold, and that the consolidated petitions were without merit and ought to be dismissed. I look at the 16th respondent's case. That was the IEBC. Responded to the consolidated petitions through the replying affidavit of Marjan Hussein Marjan, the then Chief and Commission Secretary, deposed to on the 25th of October 2024. IEBC refuted the petitioner's claims that it was legally incapacitated deposed to on the 25th of October 2024. Its case primarily addressed two distinct legal issues raised by the petitioners, namely the constitutional validity and capability of IEBC as currently constituted, and the purported role of the IEBC in clearing or approving a deputy president appointed under Article 149 of the Constitution. IEBC refuted the petitioner's claims that it was legally incapacitated due to the vacancies of the commissioners and that it is an independent commission with perpetual existence established under Articles 88(1) and 253 of the Constitution, as read with Section 13 of the IEBC Act. Specifically, it relied on Section 7(3) of the IEBC Act, which states that the IEBC shall be properly constituted, notwithstanding any vacancy in its membership. It was its deposition that Sections 11A and 11(2) of the IEBC Act structurally divide IEBC into commissioners who are responsible for policy and strategy and a fully staffed secretariat which is responsible for day-to-day administration and implementation. It was further its deposition that under Articles 145 and 150, the Constitution dictated the actors, the timelines, the procedures involved, which exclusively empower the legislature and exclude the IEBC. Similarly, it was the IEBC position that Article 149(1) of the Constitution mandates the President to nominate a replacement deputy president within 14 days of a vacancy for parliamentary approval. Flowing from the foregoing, the IEBC deposed that the omission of the IEBC in the process signified that the framers of the Constitution did not intend for an electoral body to validate executive midterm appointments. Finally, the IEBC addressed the petitioners' flawed reliance on sections 99 and 137 of the Constitution. It clarified that the articles relate strictly and unequivocally to the qualifications of individuals seeking election as a member of parliament or president, respectively. The IEBC claimed that because a midterm vacancy under Article 145 and 150 trigger a nomination rather than a by-election, the clearance protocols under Articles 99 and 137 were not activated. The IEBC stated that while the IEBC maintains the voter register under Article 88(4)(a) of the Constitution and the IEBC Act and provides public information as required by Section 35 of the Constitution and the Access to Information Act, it is not mandated to vet a nominee's educational, moral, or criminal background, as those duties belong to other state agencies like the EACC and the DCI, and as such, IEBC urged the court to dismiss the consolidated petitions. The IEBC filed submissions dated 27 October 2024, reiterating the deposition of Marjan Hussein Marjan. It was its case that it has no constitutional or statutory role in filling a vacancy in the office of the Deputy President. It maintained the position that Article 149 is a self-executing mechanism requiring only a presidential nomination and parliamentary approval with no mandate for elections, referenda, or IEBC intervention. To that end, it relied on the Supreme Court's decision in Attorney General versus two others versus D and 79 others, which is a Supreme Court decision which established that constitutional and statutory bodies must operate strictly within the four corners of their mandate and cannot extend their powers through implication or interpretive craft. It submitted that compelling it to participate in the deputy presidential appointment process would validate the doctrine of separation of powers, violate the doctrine of separation of powers by encroaching on the explicit functions of the President and the National Assembly. It called to its aid the Supreme Court's holding in the matter of interim Independent Electoral Commission, which underscored the mutually countervailing roles of different government organs. It also cited the South African constitutional case of Affordable Medicine Trust and others versus Minister of Health and others. Lastly, the IEBC reiterated that it enjoys perpetual succession and corporate legal personality under Article 253 of the Constitution and Section 13(1) of the IEBC Act, and it was its submission that despite temporary vacancies in its membership, it remained properly constituted. The IEBC therefore invited the court to dismiss the petitions against it as unmerited. The case presented by His Excellency Kithure Kindiki, who was the second interested party in the consolidated petition, His Excellency Kindiki challenged the petition through his replying affidavit and further affidavit deposed on 20th February 2025 and 8th May 2026, respectively. At the outset, he defended the swift timeline of his nomination and approval and clarified that the Constitution mandates the filling of the Deputy President vacancy within a maximum of 74 days, which were not a minimum, thereby making the expedited process entirely legal. Regarding public participation, it was his case that the National Assembly conducted extensive and adequate public engagement that met the legal thresholds. To that end, he deposed that there were newspaper advertisement, public hearings, and comprehensive reports. It was his position that the Senate acted as a trial forum rather than a legislative body during the impeachment hearings, meaning it was not constitutionally required to conduct public participation. In addressing the allegations regarding his eligibility, he maintained that the IEBC Secretariat had the administrative capacity to confirm his voter registration status without requiring a fully constituted commission. He also dismissed claims that he was ineligible for failing to hold a 3-month political party membership, explaining that this requirement applied strictly to general elections, not to the filling of an unforeseen vacancy. Further to the foregoing, it was his case that he provided Gazette notices proving that he had resigned from his position as Cabinet Secretary prior to his appointment. He clarified that the law permitted Cabinet Secretaries to hold ordinary political party membership. As regards the Senate refusal to grant His Excellency Gachagua an adjournment after he allegedly fell ill during the trial, His Excellency Kindiki observed that His Excellency Gachagua was granted an opportunity to appear in person and be represented by advocates of his choice before both houses of parliament. He deposed that he made both oral and written representation at both houses of parliament, challenged the inculpatory evidence before houses of parliament, and through cross-examination of all adverse witnesses in the trial held at the Senate. Further, he deposed that H.E. Gachagua appeared healthy during his initial testimony and found it highly suspicious that he failed to present any formal medical diagnosis or report to the Senate to substantiate the sudden illness. He argued that granting the requested 3-day adjournment would have violated strict constitutional timelines under Article 145(4) of the Constitution that required the Senate to conclude impeachment proceedings within 10 days, failure to which would have potentially plunged the country into a constitutional crisis. In his supplementary affidavit, His Excellency Kindiki opposed the late introduction of medical records by Dr. Daniel Gikonyo. He faulted the affidavit for having been sworn a year and a half after the impeachment events and was introduced only after the primary petitioner had already closed their case. He highlighted material inconsistencies regarding the timing, preparation, and late disclosure of the medical records. Specifically, he highlighted that they were never presented to the Senate, the primary constitutional forum. His Excellency Kindiki urged his case further through written submissions dated the 1st of October 2025, which were highlighted by Learned Counsel Dr. Muthomi Thiankolu, Senior Counsel, and Mr. Kenson Muteithia. They structured it to symmetrically address both the substantive and procedural validity of the impeachment process in the National Assembly and the Senate, as well as the constitutional legality of His Excellency's nomination and election. Regarding the substantive validity of the impeachment, Dr. Thiankolu, Senior Counsel, submitted that His Excellency Kindiki was lawfully Apologies, there's a mistake here. That His Excellency Gachagua was lawfully removed from office on 5 distinct counts, which included making persistent inflammatory public statements, undermining the decisional independence of the judiciary, and publicly attacking the NIS. To support the argument that the judiciary should not substitute its own judgment for that of Parliament, it was his case that the Supreme Court, in the case of Sonko, and the High Court decision in Wambora, held that the courts exercised only supervisory jurisdiction over impeachment disputes and could not act as a super legislature to review the sufficiency of the evidence presented to Parliament. In defense of the procedural mechanisms employed, His Excellency Kindiki urged that the National Assembly fulfilled its mandate by adequately informing the public and facilitating public participation, referring to the BAT case. He further implored the court to find that the strict 12-line impeachment timeline was a rigid constitutional framework, and to fortify its position, he referred to the Supreme Court's decision in Mate, where it was observed that timelines were not subject to alteration. In challenging the claim of denial of the right to fair hearing, His Excellency Kindiki asserted that the Senate's refusal to grant a 3-day adjournment was In challenging the claim of denial of the right to a fair hearing, His Excellency Kindiki asserted that the Senate's refusal to grant a 3-day adjournment was an attempt to sabotage the proceedings and trigger a constitutional crisis. It was his position that His Excellency Gachagua had failed to produce medical evidence to substantiate his sudden illness. He reiterated that granting the adjournment would have blatantly violated the strict, non-modifiable constitutional timelines. Turning to the validity of His Excellency Kindiki's assumption of office, Dr. Thiankolu submitted that his speedy nomination, electoral clearance, and political party membership was justified. He drew support from the court's decision on 31st October 2024, which established that the critical functions of the Deputy President's office abhorred a vacuum and demanded expeditious action. Finally, His Excellency Kindiki contended that the statutory laws governing appointive state offices, such as the Public Appointments Parliamentary Approval Act, did not apply to the elective office of the Deputy President.
We now come to issues for determination. Upon careful consideration of the petitions, the responses thereto, the written and oral submissions of all parties, we have distilled the following issues for dissemination. For clarity and issue of reference, the principal issues and their attendant sub-issues are set out below. Issue number 1, jurisdiction, and under jurisdiction, the issue is the justiciability of the petitions filed in light of the doctrine of separation of powers and the political question doctrine. Issue number 2, predetermination and bias. Whether there was predetermination and bias by the mover of the motion, the Speaker of the National Assembly, and the Senate during the proceedings. And 2, whether the first to the 11th respondents conspired or schemed to remove Honorable Gachagua from office in violation of Articles 1, 27, and 38 of the Constitution. Issue number 3, public participation. Whether there was adequate public participation at the National Assembly. 2, whether the Senate was obligated to conduct public participation, and if so, to what extent. 3, whether public participation was required at the point of nomination and appointment of His Excellency Kindiki. Issue number 4, constitutionality and legality of the standing orders. 1, whether standing order number 64, sub-order 2, and 65 of the National Assembly are unconstitutional. 2, whether standing order number 75, 78, 79, and 80 of the Senate are unconstitutional. Issue number 5, composition of the National Assembly and the IEBC and the nomination of the Deputy President. 1, whether the National Assembly was properly constituted to consider the impeachment motion in light of the 2/3 gender rule. 2, whether the nomination of a Deputy President can be legally finalized or approved in the absence of fully constituted commissioners of the IEBC under Articles 82 and 88 of the Constitution. 3, whether the nomination of Hon Kindiki while serving as a Cabinet Secretary is constitutionally infirm for violating the eligibility criteria under Article 148 as read with Article 137. Issue number 6, constitutional processes. Whether the Senate was obligated under Article 150 sub-Article 2 to apply Articles 144 and Article 145 with the necessary modifications to the Deputy President, and whether its failure to do so rendered the process invalid and unconstitutional ab initio. We'll also look at relevant standing orders and doctrine of immunity. 2, whether Parliament was obligated to consider and exhaust alternative accountability mechanisms, that is, criminal, civil proceedings, EACC, DCI, etc., and whether the lack of legislation to operationalize Article 150 of the Constitution vitiates the impeachment. 3, whether the Senate ought to have established a special committee under Article 145 sub-Article 3 of the Constitution. 4, whether the speed of the gazettement of the Senate resolution, the nomination of His Excellency Kindiki by His Excellency President Ruto, and the voting by the National Assembly on His Excellency Kindiki as the DP nominee contravened the Constitution and the law. And issue number 7, fair trial, whether the trial conducted by the Senate in respect of His Excellency Gachagua was lawful, fair, and in conformity with the constitutional guarantees of fair administrative action and fair hearing under Article 47 and Article 50 of the Constitution, respectively. We shall now turn to the analysis of each issue and its attendant sub-issues in the order set out above. Jurisdiction. The position in owners of the motor vehicle vessel Lydian S versus Caltex Oil Kenya Limited 1989 KLR1 remains as instructive today as it was when it was first pronounced, that jurisdiction is everything and a court that proceeds without it does so in vain. It is therefore necessary, before turning to the substantive grievances raised in these petitions, to resolve the threshold jurisdictional question that permeated the pleadings and submissions of almost all parties on whether the impeachment of a deputy president is amenable to judicial scrutiny or whether it falls exclusively within the political domain of Parliament and is therefore beyond the reach of courts. The respondents urge this court to exercise restraint, contending that impeachment is a political accountability mechanism constitutionally entrusted to Parliament, and that courts ought not to transform themselves into appellate chambers reviewing parliamentary decisions. The petitioners maintained that while impeachment is undoubtedly political in context and consequence, it remains a constitutionally regulated process subject to constitutional supremacy, the Bill of Rights, and judicial oversight. The resolution of these competing positions requires an examination of the constitutional architecture established under the Constitution of Kenya 2010. The starting point is the supremacy and delegated authority provisions found in the Constitution. Article 1 vests all sovereign power in the people of Kenya to be exercised either directly or through democratically elected representatives. Parliament, the executive, and the judiciary are therefore not sovereign institutions in themselves. They are repositories of delegated sovereign authority, deriving their legitimacy from and remaining accountable to the people. Article 2 declares the Constitution to be the supreme law of the Republic, binding all persons and all state organs at both levels of government. The inevitable consequence is that no state organ, including Parliament, enjoys immunity from constitutional scrutiny. The Constitution of Kenya does not recognize parliamentary supremacy. It entrenches constitutional supremacy, and that supremacy is absolute and admitting of no exception. The Supreme Court gave authoritative expression to this principle in Justice Kariuki Mate and another versus Martin Nyaga Wambora and another 2017 EKLR, where it emphasized that no arm of government is above the law, that this being a constitutional democracy, the Constitution is the guiding light for the operations of all state organs. It further determined that the court's mandate, where it applies, is for the purpose of averting any real danger of constitutional violation. It follows, as a matter of necessary constitutional logic, that whenever Parliament exercises authority under Articles 145 and Article 150 of the Constitution, it does so not as a sovereign body wielding unreviewable discretion, but as a constitutional organ exercising delegated authority within and subject to the limitations that the Constitution prescribes. The jurisdiction of this court to entertain these petitions is firmly grounded in Articles 22, 23, and 165 of the Constitution. Article 165, sub-article 3D, expressly empowers the High Court to determine questions of constitutional interpretation, including whether anything done under the authority of the Constitution or any law is inconsistent with or in contravention thereof, and it is precisely that question that lies at the heart of these proceedings. Article 23 vests in this court jurisdiction to enforce the Bill of Rights and to grant appropriate relief where constitutional rights and freedoms have been violated, are threatened, or are likely to be infringed. The breadth of that jurisdiction is a deliberate constitutional design that reflects the transformative aspirations of the Constitution of Kenya 2010 and the indispensable role assigned to the judiciary as the ultimate guardian of constitutional supremacy and the protector of the rights of every person within the Republic. This court does not approach the jurisdictional question as one of first impression. In its ruling delivered on 31st of October 2024, this bench considered and conclusively determined the self-same jurisdictional challenge that the respondents now seek to resurrect. The court held that the broad jurisdiction vested in the High Court under Articles 23, 22, and 165 extends to determining whether the powers exercised by the National Assembly and the Senate in impeachment proceedings conformed to constitutional requirements. Had the framers of the Constitution intended to exclude the High Court's jurisdiction in matters arising under Article 145, they would have done so in express terms, as they demonstrably did in relation to certain proceedings under Article 144. The argument that impeachment proceedings are beyond judicial scrutiny sits uneasily with the constitutional text. The Constitution contains no provision excluding impeachment from judicial review, and no clause creating islands of authority immune from constitutional control. Where allegations are made that constitutional procedures are violated, rights infringed, or constitutional standards disregarded, as in the present case, this court would itself violate the Constitution were it to decline jurisdiction merely because the dispute arises in a politically sensitive context. As Chief Justice Marshall observed in Cohens versus Virginia, 19 U.S. 6 feet 264, in the year 1821, the court said, "It is most true that this court will not take jurisdiction if it should not, but it is equally true that it must take jurisdiction if it should. We have no more right to decline exercise of jurisdiction which is given than to usurp that which is not given. The one on the other or the other would be treason to the Constitution," close quote. That observation resonates fully within Kenya's constitutional order. The presence of political implications does not extinguish this court's constitutional duty to interpret, protect, and enforce the Constitution. Even within the argument on separation of powers, this court accepts that impeachment is principally a parliamentary function under Articles 145 and 150. However, separation of powers does not mean separation from the Constitution. As the Supreme Court held in the matter of the Speaker of the Senate and another 2013 KLR, none of the arms of government can claim an exclusive preserve free from constitutional scrutiny, and it is the responsibility of the courts to ensure that the exercise of power by state organs remains within constitutional bounds. The Court of Appeal affirmed in Mumo Matemu versus Trusted Society of Human Rights Alliance and 5 others, that was in 2013, that the Constitution establishes not a rigid wall of separation, but a system of separation of powers tempered by checks and balances within which no arm of government is superior to another. The doctrine therefore requires mutual respect among constitutional institutions, not mutual exclusion, and Parliament cannot invoke it as a shield against constitutional accountability. Within the realm of impeachment proceedings, specifically the Supreme Court in Justice Karaoke Mate and another versus Martin Nyaga Wambura of 2017, the Supreme Court signaled that it would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the courts is restricted by the doctrine of separation of powers to deciding on matters of individual rights and fundamental freedoms, and not to inquire into how the county assembly and the Senate perform duties in which they alone have discretion, nor to review the merits of the decision to impeach. We are therefore satisfied that this court is being correctly called upon to scrutinize and pronounce itself on the constitutional regularity of the impeachment process. To do so neither impinges upon nor offends the doctrine of separation of powers. As the Constitutional Court of South Africa observed in Doctors for Life International versus Speaker of the National Assembly and others, in quote, while the doctrine of separation of powers is an important one in our constitutional democracy, it cannot be used to avoid the obligation of a court to prevent the violation of the Constitution. The right and the duty of this court to protect the Constitution are derived from the Constitution, and this court cannot shirk from that duty, close quote. That proposition applies with equal, if not greater force within Kenya's constitutional order. To decline the obligation of constitutional adjudication in deference to the political character of impeachment proceedings would not be an act of judicial restraint, but an act of judicial abdication. On the political question doctrine, the respondents placed reliance on Nixon versus United States 506 USA 224 1993, where Walter Nixon, a federal district court judge removed from office by the Senate, challenged the procedure by which his impeachment trial had been conducted. The United States Supreme Court held that the manner in which the Senate conducts impeachment trials is a non-justiciable political question, the conduct of such trials having been textually committed by the Constitution exclusively to the Senate. While Nixon offers useful guidance on the need for political restraint in matters constitutionally committed to other branches, A clear distinction must be drawn when transplanting that decision into the Kenyan constitutional context. The Constitution of Kenya contains an expansive Bill of Rights enforceable under Article 23, broad and explicit judicial review powers under Articles 165, sub-Article 3D, and a constitutional supremacy clause under Article 2 that expressly subjects every excess of power or public power without exception to constitutional scrutiny and accountability. Unlike the United States Constitution, the Constitution of Kenya does not textually commit impeachment proceedings to Parliament in terms of exclusive of judicial oversight. The place of the political question doctrine within Kenya's constitutional order has been authoritatively addressed by the domestic courts at the highest levels. The Supreme Court elaborated upon this position with specific reference to impeachment proceedings in Mike Mbuvi Sonko versus County Assembly of Nairobi 2022. The court held that courts are permitted to intervene where matters of constitutional violations arise in impeachment processes, reasoning that although impeachment is a political process sanctioned by the Constitution, neither the County Assembly nor the Senate can act outside the confines of the Constitution and the law, for to do so would invariably invite the court's intervention. The Supreme Court clarified that the mandate of the courts was to determine whether the individual's rights, dignity, and fundamental freedoms had been preserved and protected in the process without usurping the powers and functions of the legislative branch of government. Those principles were further articulated in a 5-judge bench decision of this court in Ramogi and 3 others versus Attorney General 2020, where the court held that the critical constitutional inquiry is not whether a dispute is political in character, but whether it raises constitutional or legal questions capable of judicial determination. Where constitutional standards exist against which the impugned conduct may be measured, a court is not at liberty to decline jurisdiction on grounds of political contentiousness alone. The court observed that were courts to decline jurisdiction whenever a dispute bore political implications, constitutional violations committed within political processes would be left entirely without remedy, an outcome fundamentally irreconcilable with Articles 2 and 3 of the Constitution. Taken together, these authorities establish that the political question doctrine in Kenya is not a doctrine of abdication, but one of restraint. It requires courts to distinguish between political choices entrusted to the political branches of government and questions of constitutional compliance entrusted to the judiciary. The former ordinarily lie beyond judicial competence. The latter falls squarely within the judicial function. In light of the foregoing, we reiterate that the court is not a political arbiter, but a constitutional one. We agree in principle with the submission that it is not the function of this court to determine whether the charges against His Excellency Gachagua were of sufficient gravity to warrant his removal from office. Those are quintessentially parliamentary judgments, constitutionally entrusted to the National Assembly and the Senate. We decline any invitation to venture into the merits of the charges upon which the impeachment was founded. The court's obligation is to ensure that the impeachment process, however political its character and however significant its consequences, was conducted in accordance with the Constitution, the rule of law, and the procedural and substantive safeguards the Constitution prescribes. Where that standard was met, we will say so. Where it was not, we are equally bound to say so. For it is in the faithful discharge of that obligation and not in deference to political outcomes that the legitimacy of this court's intervention ultimately rests. Accordingly, we find that the impeachment proceedings challenged in these petitions are justiciable and that this court possesses jurisdiction under Articles 23, 22, and 165 of the Constitution to determine whether the National Assembly and the Senate acted within constitutional bounds, complied with constitutional procedures, respected constitutional rights, and remained faithful to the constitutional safeguards governing the impeachment of a deputy president. Second sub-issue, predetermination and bias. The petitioners contended that the impeachment proceedings against His Excellency Rigathi Gachagua was tainted by actual bias, apparent bias, conflict of interest, and predetermination on the part of the speakers of the National Assembly and the Senate, members of Parliament, senators, and other constitutional actors involved in the impeachment process. It was their case that various public statements, political conduct, and procedural decisions demonstrated that the outcome of the impeachment had effectively been determined before the proceedings commenced, and that the constitutional actors involved had failed to approach the process with the impartiality and openness required under Articles 27, 47, and 50 of the Constitution. The constitutional foundation of the petitioner's claim lies principally in Article 27, 47, and 50 of the Constitution. Article 27 guarantees equality before the law and the equal protection and equal benefit of the law. Article 47 guarantees every person the right to administrative action that is lawful, reasonable, and procedurally fair. Article 50, sub-article 1 guarantees every person the right to have any dispute that can be resolved by the application of law determined in a fair and public hearing before a court, or where appropriate and independent and impartial tribunal or body. The constitutional requirement of impartiality is not confined to court of law. Whenever a constitutional body exercises adjudicative, disciplinary, investigative, or quasi-judicial authority affecting rights, interests, status, or public office, the process must comply with constitutional standards of fairness, impartiality, and procedural propriety. This principle was affirmed by the Court of Appeal in Sholei versus Judicial Service Commission and 3 others in 2013, and the Judicial Service Commission versus Mbalu Mutava and another civil appeal number 52 of 2014. Where the court emphasized that constitutional and administrative decision-making processes are subject to the requirements of procedural fairness and natural justice. In Mbalu Mutava, which I have mentioned above, the Court of Appeal observed that Article 47 transformed the common law principles of natural justice into constitutional imperatives, such that whenever public power is exercised in a manner affecting legal rights, status, or legitimate expectations, constitutional standards of fairness become directly applicable. In Sholei case, the Court of Appeal reaffirmed that public bodies exercising disciplinary or quasi-judicial authority must act fairly and impartially, and that public confidence in constitutional institutions depends not only on actual fairness, but equally upon its appearance. The rule against bias is one of the oldest and most fundamental principles of natural justice, embodied in the maxim Nemo Judex in Causa Sua, that no person shall be a judge in their own case. Historically directed at preventing decision makers from participating in matters in which they held a personal, financial, or proprietary interest, the doctrine has over time expanded to encompass circumstances giving rise to a reasonable apprehension that a decision maker may not approach a matter with the requisite impartiality, even in the absence of any direct personal interest. The modern test for apparent bias was authoritatively stated by the Supreme Court in Rai and 3 others versus Rai and 4 others, 2013, KLR, where the court adopted the objective test and held that the inquiry must be conducted from the perspective of a fair-minded and informed observer. The court emphasized that allegations of bias cannot be founded upon speculation, conjecture, suspicion, or dissatisfaction with the outcome of proceedings. There must exist objective circumstances capable of giving rise to a reasonable apprehension that the decision maker may not bring an impartial mind to bear on the subject. The Supreme Court reaffirmed and elaborated upon these principles in Kaplana, Rawal, and 2 others versus Judicial Service Commission in 2016, observing that the question is not whether a party genuinely believes that a tribunal is biased, but whether a reasonable and informed observer, having considered all relevant facts, would conclude that there exists a real possibility of bias. The court further recognized that constitutional institutions must be protected from unsubstantiated allegations capable of paralyzing their functioning, and accordingly insisted upon an objective evidentiary foundation before
Ege Nensoko TV Uboroso Bumugusi Onye kubwatari ibolyo obosemia gusekero kende gyonsiguro yemirobiri yaitu y'Ensoko TV twakeresimi ase namba 0788666663 gose tulikiriri uko email ensokotv.ke@gmail.com boigo nabugo tutarira service itego tukasamaga hazina towers egoroba ya gatanu narimo asumucyo munene Nairobi. Ensoko TV uboroso w'umuguse. Ege Nensoko TV uboroso w'umuguse.
And critically, there must exist objective circumstances capable of giving rise to a reasonable apprehension that the decision maker did not or could not approach the matter impartially. Jurisprudence further establishes that bias and predetermination, though related in concept, are legally distinct. Bias concerns the existence of actual or apparent partiality or on the part of the decision maker. Predetermination concerns a state of mind in which the decision maker has effectively closed their mind to the evidence and argument and reached a final conclusion before the process has run its course. The distinction was illuminated by the English Court of Appeal in Lewis versus Redder and Cleveland Borough Council in 2008, where the court drew a clear line between predisposition and predetermination. Decision makers may legitimately hold predispositions, inclinations, or preliminary views on matters before them. That is the inevitable consequence of experience and engagement in public affairs. What the law prohibits is predetermination, which is a state of mind so close to persuasion that no amount of evidence or argument is capable of altering the ultimate outcome. In light of the authorities that we have cited, we hold the view that the mere fact that members of parliament or senators publicly supported or opposed the impeachment of His Excellency Gachagua cannot, standing alone, establish constitutional bias. To hold otherwise would render impeachment proceedings practically unworkable and would be inconsistent with inherently political character that the Constitution itself recognizes in such proceedings. Legislators are not expected to approach impeachment as blank slates devoid of political opinion or prior knowledge. What the Constitution requires is that they remain genuinely open to considering the evidence, listening to argument, and discharging their constitutional responsibilities in good faith and within constitutional limits. We are accordingly not persuaded by the proposition that bias may automatically
Buya kegemo mwancho muligari bw'Ensoko TV asoko igoro murangu na gutwanchira goswa enka yawe mambi yabono.
Buya kegemo inde aso twanchira ko bari yogiritanga ni kwegure nyumba mwago emambiye.
Ensoko bwa kiro mwancho muligari inche nino Sentio Nyango.
Diana Ndem.
Togenda se gazeti ya The Daily Nation aswago tebanga ikiama gyo DM gyo kwamba kororekananga gatigati yayo mwatikano nororo ikiama gitamanyika ntigo sekere serikali kubwatira serikali asomo secretary general asokirinda kugikiria serikali ngichwera kwa nigorengani
Raila puppet or ODM lepo matoyo Edwin Sifuna ole secretary general ya ODM secretary general ya rogo saini kuru binto kuru mekitapa kerege lakini ngoira ni maega kego omuntu maito gukurageria sese ya ukagari egere koge butuko
magega ya televishoni ya Nsoko gwikasero yao kwanyoribaga ligi yaliokuralia asegete sena mbeyemo imena isiko yeliroba liagusi onye kubwa tokuralia bokwenyoria ogokwa gose okubonchuria bono na bokonyoribaga lyabene liokuralia asegete senieke aseriguri liakibusani tolikere gose twakere simigwetire namba yaito yobonchuria 0788 666662 amoreni gagendrete gotose mwana boire bukia tari yesu sera ekegonko esukari lisabeso ukurasa kwa manyinga yan blood pressure ninki turakore wetanga kuri wasare nyorali chibu asomroberyo bubugima nobo chenu asora bego kumani wanabanyegitari bamarwire ao nabo yabamanyi bande bayatunge tyobo chenu kumurikira marwire nobo wenia nyoro muroberyo bubugima nobo chenu na Caroline Mausa kirali tukule Jumatatu chinsa ibiri chabutuko ime Yensoko TV oboroso umugusi obulimira bwesiro yobunda bwense kolene tali nchirende onsura krobulimi obiyoke enyoreri bagalia bene kwaegwa megerio chisemi nobosemia igiri obulimi bwekerero nechikolinga
asobolemi bochete skuru nobotigi bokumerwa mate
tebone ng'ombe bune yengiya
gale konyana eyisimegete ndera ngetia maraba ekonete konya gukina yo kamaraba konya kuyana nganya kwama buya
beka chibuti imokio bokombe to semogondo bweli nebisumwime na pathway machine
Kristo kuri Jumaine chinsa ni bere chamorogoba wika chinsa isoto asomorobere oberemi nobotugi ekeroture semia mange kura saberemi chini gongoro kwa pathway machine
asomorobere boberemi nobotugi ime Yensoko TV oboroso bwumugusi
kama tingatara ndaiketa ni ya nyamira na rena shauri sangwe ngararombo ijana umuntu bataya mabwari
Muligari bwa Nsoko TV oyo no moroberio bwo kongoria mareko na inje mwana mboka Edwin Yang'au turabe to kuumira na kira litukulie iki guchakera chinsa 11 chamogoroba wikenseyemo yabotuko kugwakorire mirimo yawo yerituko kwabokire orosete uikaransitero ya ubuyanda chitasekeruko orambulete merondo kunyagosibero ngoli nari ase screen ne chingero chikoleto na mwanambuka Edwin Yang'au ano to konyora chingero chionsi echiegita na chobenga kwano ubukano echiembegetere ndo gesongengo to amereria
bakaliya omoto yakabwatwa bakaliya omoto yakabwatwa amatukemeronge na gaika kabwatwa.
My name is Albert Omariba. I'm the principal of Gitwebe Technical Training Institute. Gitwebe Technical Training Institute is a government institution situated in Nyamira County. We admit our students as from Standard 8 to Form 4 across all departments. Our students receive help and capitation from the government, therefore there is no worry of the fee payment. And our students pass very well in all departments, and we are able to achieve 90% pass.
Nikwe Eye Nsoko TV oboroso bumugusi Eye Nsoko TV oboroso bumugusi
Buya kegimo mwancho muligari bwa Nsoko TV asoko igoro murangu na gutwanchira goswa enka yawe mambia bono.
Buya kegimana inde aso twanchira kobari yogiritanga ni kwegure nyumba mwago emambie.
Ensoko bwa kiro mwancho muligari incheni Innocent Onyango.
Diana Ndem.
Togenda se gazeti ya The Daily Nation aswago tebanga ikiama gyo DM ge kwamba kororekananga gatigati yayo mwatikano nororo ikiama gitamanyikana tigo sekere serikali kubwatirere serikali asomo
Eye Nsoko TV Oboroso Bumugusi
is reasonable and fully compliant to the constitutional requirements. They argued that notices were disseminated through the Gazette, through newspapers, through Parliament website and social media, and that multiple channels of participation were available. They defended the 2 to 3 day notice period as reasonable given the strict timelines under Article 145. They further justified the tick box template as a deliberate design to structure responses and prevent manipulation, noting that citizens could still submit their memoranda or oral views. They argued that participation by over 223,000 citizens was characterized as unprecedented civic engagement, and they dismissed the isolated disruptions as immaterial. They argued that there was no obligation to share His Excellency Gachagua's report with response with the public, since the public's role was to express views, not to adjudicate. On the Senate stage, the respondents in summary, contended that the public participation was not required as the Senate seats as a quasi-judicial capacity during impeachment and not as a legislature. That Article 118 applied only to legislative business and not impeachment. That impeachment was a single continuous exercise with the public participation required only at the initiation stage. Regarding the nomination and approval of His Excellency Kindiki, they submitted that public participation was not required, that Article 149(1) established a unique self-executing process where the National Assembly voted as an electoral college exercising delegated sovereignty rather than conducting legislative business, that the Constitution's silence on participation in this context was very deliberate, and that elected MPs themselves embody public representation, that the debate was open, televised and recorded, and they concluded that the nomination, approval, and appointment of His Excellency Kindiki were fully compliant with the Constitution. We have considered the cases advanced by both parties and take the following position on this issue. It is common ground among the parties, and this court affirms that public participation is not merely a procedural formality, but a foundational constitutional value, one deeply woven into the democratic fabric of this nation. It is an expression of the sovereign will of the people, who, by virtue of Article 1, Sub-Article 1 of the Constitution, are the ultimate repository of all sovereign power. That sovereignty, though delegated to state organs under Article 1(3), is not thereby surrendered. It is retained by the people and continuously exercised through, amongst other mechanisms, active and meaningful participation in the process of governance. Public participation is therefore not a gift of the state to the citizen, but a constitutional right that the state is obligated to facilitate, to protect, and to give full effect to. Under Article 10(2)(a) of the Constitution, public participation is expressly enumerated as one of the national values and principles of governance. Article 10(1) makes clear that the national values and principles of governance bind all persons, state organs, state officers, and public officers whenever they make or implement public policy decisions, apply or interpret the Constitution or any law. The imperative of public participation finds further and specific expression in the context of Parliament in Article 118 of the Constitution, which reads as follows: Parliament shall A. Conduct its business in an open manner, and its sittings and those of its committees shall be open to the public, and B. Facilitate public participation and involvement in the legislative and other business of Parliament and its committees. At its core, public participation refers to an active process of interaction and engagement among various stakeholders who have an interest in or are affected by a particular decision or course of action. The word active is of constitutional significance. It signals that the Constitution does not contemplate a passive, cosmetic, or performative exercise in which the exercise is merely notified of a decision, in which the public is merely notified of a decision already made. It demands instead a genuine and substantive process which the people are afforded a real and meaningful opportunity to shape the decisions that affect their lives. In essence, public participation is the mechanism through which the governed speak to those who govern and through which the exercise of public power is continuously tethered to the will, values, and interests of the sovereign people. The robust jurisprudence on this subject in Kenya supports this position. The Supreme Court, in the matter of National Land Commission, this is an advisory opinion application number 2 of 2014, placed the principle of public participation at the very core of the concept of checks and balances in governance, recognizing it as integral to the manner in which various arms of government discharge their constitutional functions. Subsequently, in the British American Tobacco Kenya PLC versus Cabinet Secretary for Ministry of Health, commonly referred to as the BAT case, the Supreme Court delimited the following binding framework for public participation. The principles are that, as a constitutional principle under Article 10.2 of the Constitution, public participation applies to all aspects of governance, that the public officer and or entity charged with the performance of a particular duty bears the honors of ensuring and facilitating public participation, that the lack of a prescribed legal framework for public participation is no excuse for not conducting public participation, and the onus is on the public entity to give effect to this constitutional principle using reasonable means. That public participation must be real and not illusory. It is not a cosmetic or a public relations act. It is not a mere formality to be undertaken as a matter of course just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. That public participation is not an abstract notion, it must be purposeful and meaningful. That public participation must be accompanied by reasonable notice and reasonable opportunity. Reasonableness will be determined on a case-to-case basis. That public participation is not necessarily a process consisting of oral hearings. Written submissions can also be made. The fact that someone was not heard is not enough to annul the process. That allegations of lack of public participation does not automatically vitiate the process. The allegations must be considered within the peculiar circumstance of each case, including the mode, the degree, the scope, the extent of public participation is to be determined on a case-to-case basis. Additionally, in Cabinet Secretary for National Treasury and Planning and 4 others versus Okiya Mtata, the Supreme Court held that the constitutional threshold for public participation is one of reasonableness, that the process must afford the public a genuine and meaningful opportunity to be heard, and that Parliament must take reasonable measures to ensure the proposal, views, and suggestions received. The court spoke as follows. In the BAT case, this court established the standard that duty bearers must meet and the threshold courts should use to determine whether duty bearers have fulfilled their obligations with respect to public participation. This threshold is set at a reasonableness standard. In its guiding principles on public participation, this court defined this threshold as follows: that public participation must be accompanied by reasonable notice and reasonable opportunity. Reasonableness will be determined on a case-to-case basis, close of quote. This and the broader corpus of jurisprudence firmly established that when the Constitution, the Constitution demands is not necessarily the most intensive form of participation in every case, but always a form that is meaningful, purposeful, and proportionate to the nature and gravity of the decision being made. This principle finds its clearest expression in the decision of the Constitutional Court of South Africa in Doctors for Life International versus the Speaker of National Assembly and others, where the court held that the degree and nature of participation must be calibrated to the subject matter and the potential impact of the decision on affected persons. The proposition has been consistently adopted by our courts in Mui Col Basin Local Community and 15 others versus the Permanent Secretary, Ministry of Energy. The Court of Appeal affirmed that decisions of greater consequence demand more robust and substantive engagement, and that public participation ought to be meaningful rather than a tick box exercise. The High Court reinforced this position in Robert Gakuru versus Governor Kiambu County and Institute for Social Accountability versus the National Assembly, where it held that the standard of participation required is directly informed by the gravity and reach of the decision in question. We believe that it is within this rich conceptual context that the courts must approach questions about the adequacy of public participation in any given case, whether arising from the legislative process or from any other exercise of public power in which the Constitution demands the people's involvement. The focus ought to be on whether the participation that occurred was real, substantive, and meaningful. As we now turn to apply these principles to the specific facts of this matter, we do so bearing in mind that the constitutional standard is not one of perfection, but equally, it is not one of mere tokenism. The standard is meaningful participation, and that standard must be assessed with rigor, sensitivity to context, and fidelity to the constitutional vision of a government that is truly of, by, and for the people. Certainly, the impeachment of a deputy president is not an ordinary legislative act. It is amongst the most consequential, solemn, and irreversible decisions that any parliament can make. It involves the removal from office of a person who holds the second highest constitutional office in the republic, and an office to which the holder was elected by the sovereign will of the people through a general election. The gravity of that decision cannot be overstated. It affects not only the individual whose tenure is at stake, but the constitutional architecture of the executive, the stability of government, and the democratic expectations of millions of citizens who cast their vote in the 2022 general election. It is precisely because of this gravity that the public participation required in connection with an impeachment process must be held to a standard that is both qualitatively and quantitatively meaningful. It is equally against this exacting standard that we assess the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua. On the question of notice, the National Assembly adduced evidence that notices of the public participation exercise were published in multiple newspapers of wide national circulation, including the Daily Nation, the Standard, the Star, and Taifa Leo on the 2nd, the 3rd, the 4th, and the 5th of October 2024. We recognize that the publication of the notices in both English and Kiswahili was a deliberate effort to reach citizens across the linguistic divide and to ensure that the exercise was not confined to the English-speaking, urban, and formally educated segment of the population. Notice was additionally published in the Parliament's official website and on social media platform, therefore extending the reach of the process to citizens who access information through digital means. On the question of accessibility and channels of engagement, a public views template was provided in both English and Kiswahili, further reinforcing the inclusive character of the exercise. Constituency offices and county women representative offices, altogether totaling 337 access points spread across every corner of the country, were directed to remain open, including on the 5th of October 2024, to receive public submissions. Citizens were further afforded the option of submitting their views by email, by post, hand delivery, and online submissions could be made through Parliament's website, which further meant that participation was not contingent on physical presence or geographic proximity to a hearing venue. On the question of numbers, the evidence shows that just over 223,000 members of the public participated in the exercise. We are mindful that the significance of a participation number cannot be assessed in a vacuum. It must be considered in the context of the time available, the channels provided, the nature of the decision being made, and the standards previously endorsed by the courts. The Supreme Court in the BAT case affirmed that both quantitative and qualitative components are relevant to such an assessment. Equally, in Robert Gakuru, the Court of Appeal affirmed the principle that the quantitative component of public participation is a relevant but not determinative consideration, and that the adequacy of participation must be assessed in light of all the circumstances. Viewed against these standards, a participation figure of 223 citizens achieved within the constrained timeline represents a considerable level of civic engagement in a single parliamentary process. We say so further considering the relationship between the state's obligation to facilitate public participation and the public's exercise of the right to participate. These are two distinct constitutional responsibilities, and the law does not conflate them. The constitutional obligation that falls upon Parliament and upon all state organs charged with facilitating public participation is an obligation of facilitation, not an obligation of outcome. Parliament is constitutionally required to provide adequate notice, accessible channels, sufficient information, and a genuine opportunity for the public to engage. That obligation, once discharged, exhausts the constitutional duty of the facilitating organ. At least that is our understanding of the Supreme Court's pronouncement in Cabinet Secretary for National Treasury and Planning that, I quote, based on the textual markers herein, Parliament's duty is to facilitate public participation and involvement in the legislative and other business of Parliament and its committees. As is plain from its wording, this provision only imposes a duty to facilitate public participation and involvement in the legislative process, end of quote. We hold the view that what the public chooses to do with the opportunity is a matter of individual and collective civic agency, and that agency belongs to the people and not to Parliament. To hold Parliament responsible for the volume of public participation and to judge the constitutional adequacy of a public participation exercise by the number of citizens who choose to avail themselves of it would be to conflate the duty to provide an opportunity with the duty to compel its uptake. We take the position that a process that was accessible to all but availed by a few is not, by reason of low turnout alone, constitutionally deficient, provided that the low turnout was not the product of inadequate notice, inaccessible venues, suppression of participation, or any other failure on the facilitating organ. This principle finds support in comparative jurisprudence. The Constitutional Court of South Africa in Doctors for Life International case was emphatic that Parliament bears a duty to facilitate public participation and that the standard against which that duty is measured is one of reasonable facilitation. It therefore follows that the adequacy of the exercise ought not to be measured by the number of members of the public who ultimately chose to engage or by whether any particular outcome was achieved. The true measure is whether the state discharged its obligation to create conditions in which meaningful participation was genuinely possible. We are therefore persuaded that the appropriate legal standard against which compliance by the National Assembly must be measured is not one of perfection, but one of reasonable sufficiency in the circumstances. As we have stated, the Constitution does not demand flawless execution of public participation. What it demands is a genuine, accessible, and meaningful opportunity for the public to be heard. Even accepting, as we do, that logistical and operational challenges may have arisen in certain isolated cases, which is not an uncommon occurrence in any large-scale nationally coordinated exercise conducted under time pressure, such localized deficiencies would not invalidate the entire process, as guided by the Supreme Court in the BAT decision. The evidence before this court shows that the door was opened widely, accessibly, and in good faith. Additionally, the fact that His Excellency Gachagua's response to the charges was not availed to the public during the window does not, without more, render the exercise deficient. The purpose of public participation in the impeachment process is substantively and functionally distinct from the adversarial hearing to which the respondent is entitled. The public was called upon to express its views on whether the allegations assessed on their face were of sufficient gravity to warrant a removal of a constitutional office holder. It was not and was never intended to be a mini trial of the charges. The Constitution vests the final decision-making authority in the National Assembly and the Senate, both of which are representative bodies exercising a delegated mandate from the people. These institutions heard, considered, and weighed both the allegations and His Excellency Gachagua's full response before proceeding to vote. On the question of compliance with the court orders of 3rd October 2024, which directed the National Assembly to organize public participation at least at constituency level, we find upon careful evaluation of the evidence placed before us that the National Assembly took demonstrable and timely steps to give effect to those directions. A memo from the Clerk of the National Assembly contained at page 996 of the National Assembly's documents provided as follows. The title of the memo was Collection of Public Views on the Special Motion for Removal from Office by Impeachment of the Deputy President of the Republic of Kenya. And the Clerk of the National Assembly writes, as you are aware, the National Assembly is currently considering a special motion for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya. To facilitate this process, public hearings were scheduled to be held in all 290 constituencies on Friday, October the 4th, 2024 from 8 to 5 p.m. And members of the public were notified to submit their views to the constituency or county. Offices of all members of Parliament of the National Assembly notified to submit their views to the constituency or county offices of all members of Parliament of the National Assembly. By a court order issued on the 3rd of October 2024, the High Court in Kenya sitting at Kerugoya directed that the National Assembly organize similar public hearings closer to the citizens, at least at constituency level, on each constituency in Kenya to enable the constituents of members of Parliament responsible for the impeachment process nationally to engage with and participate on hearings and or any other suitable modes by which citizens at that level can participate and offer their representations. In this regard, you are required to continue facilitating and coordinating the public participation exercise on the special motion within your constituency or county office. Please ensure that you implement the following: availability of forms. Ensure that copies of the public views template are physically available in your offices. In addition to the physical forms availed earlier, additional forms can be downloaded from the Parliament's website. 2. Collection of views. Collate all views, including memoranda, completed public views template, and any other submissions relating to the exercise. Note to transcribe oral submissions into written form using the designated template. 3. Submission of collected views. You are required to submit the collated views arranged per constituency to the collection center, which has been set up in Parliament Building, Nairobi, at the entrance of Bunge Tower. Alternatively, you may hand over the forms to the respective officers designated for your counties or constituencies as per the attached list. All submissions must be received by Sunday, the 6th of October, 2024. Please ensure that your respective offices remain open on Saturday, the 5th of October, 2024, as from 8 a.m. to 5 p.m. to facilitate the exercise. Please utilize the operation facilities and resources available in your offices to print or photocopy the forms and to support any other aspects of this exercise. For seamless coordination, we have shared the contacts of parliamentary officers responsible for each county or constituency. I close the quote. The petitioners allege that no actual hearings were held at the constituency level, contending in effect that the exercise was a procedural facade. The allegation was effectively countered by substantial evidence presented by the National Assembly. This included the report of public participation on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. The report contained a detailed analysis of the aggregated constituency tallies. See table number 4 at page 180 of the report. Supported by photographic documentation of the exercise conducted across multiple constituencies, as well as an official account comprehensively outlining the scope, and substance of the proceedings. It is a well-settled evidentiary principle that a bare denial or unsubstantiated allegation cannot displace positive and particularized evidence to the contrary. The petitioners bore the burden of proving on a balance of probabilities that the public participation was an illusory or ineffective exercise. That burden was not discharged. It was also common ground that the public participation was tabled before the National Assembly on the 8th of October 2024. Members of Parliament had the opportunity to consider it before and during the debate. One of the petitioners mounted a specific and pointed challenge to the integrity of the report's data, contending that the figures recorded for Keio South were statistically impossible in that they purportedly reflected a support rate of 162.78%, a figure that, if accurate, would self-evidently exceed the mathematical ceiling of 100% and thus portray either gross error or deliberate manipulation. We have subjected the report to careful scrutiny. Our analysis shows that in Keio South, of the 820 responses recorded, 807 supported the impeachment, 12 opposed it, and 1 selected other. This translates to 98.41% in favor, 1.46% against, and 0.12% categorized as other. These figures, in our view, are mathematically sound and fall within the permissible range of 0 to 100% and disclose no statistical anomaly of the kind alleged. The petitioner's contention, presented as a statement of fact, is therefore not borne out by the document itself. We further find that even if isolated errors were present in data entry, tabulation, or transcription, if those errors were demonstrated to exist within a report of this scale, such minimal errors would not without more vitiate to the entirety the otherwise lawful and substantially compliant public participation exercise. Therefore, having wholly examined the totality of the evidence produced before us, and having applied the constitutional and jurisprudential standards authoritatively laid down on the nature and quality of public participation required, we are satisfied and hereby find that the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua as Deputy President met the requisite constitutional threshold in all material respects. With regards to the Senate not conducting its own public participation, the petitioners contended that the Senate acted in violation of Article 118 of the Constitution by failing to conduct its own independent public participation exercise prior to deliberating on the impeachment of His Excellency Gachagua. This argument, while not without surface appeal, cannot be sustained upon a careful and purposeful reading of the constitutional architecture governing impeachment proceedings, and we reject it for the following reasons. The starting point is a principle of constitutional specificity. Where the Constitution makes express and particular provision for a specific process, that specific provision governs, and general provisions must yield to it to the extent of any inconsistency or tension. Article 145 of the Constitution prescribes with particularity the role and function of each House of Parliament in the impeachment process. Under that provision, the Senate's designated function is to hear the charges preferred against the Deputy President, to receive and evaluate evidence in respect of those charges, and to decide on whether the Deputy President should cease to hold office. This is, by its very nature, an adjudicative function and one that is quasi-judicial in character, akin to the conduct of a tribunal. It is not a legislative or policy-making function. The Senate, at this stage of the process, sits not as a law-making body, but as a constitutional adjudicator, and the procedural obligations that attend to that role are correspondingly different. Article 118, by contrast, imposes obligations on Parliament in the conduct of its legislative and other business. It provides in material part that Parliament shall conduct its business in an open manner, that its sittings and those of its committees shall be open to the public, and that Parliament shall facilitate public participation and involvement in its legislative and other business. The operative phrase is legislative and other business, and the interpretive question is whether Senate's adjudicative role in impeachment proceedings falls within the scope of that phrase. We find that it does not. The phrase other business must, on a proper application of the Eusdom Generis canon of construction, be read as business of a similar nature to legislative business. That is, business involving the formulation, review, or consideration of policy or law. We respectively associate ourselves with and adopt as correct the position taken by this court in Mwangaza versus County Assembly of Meru, that public participation in impeachment proceedings primarily occurs at the county assembly level rather than at the Senate level, since the county assembly is the initiating body that formulates and debates the impeachment motion before transmitting it to the Senate for final determination. End of the quote. At the Senate stage, the function being discharged, as we have said, is adjudicative rather than consultative. We find that the constitutional principle underlying that holding is not confined to the impeachment of governors. It is a principle of general application that derives its force from the structural logic of the impeachment framework embedded in the Constitution, and it applies with equal force and validity to the impeachment of the Deputy President under Article 145. A second invocation of the same procedure in respect of the same charges, the same allegations, and the same subject matter at the Senate level serves no additional constitutional purpose. We therefore find that the Senate did not violate Article 10 or 118 by failing to conduct its own independent public participation. Finally, the question of whether public participation was constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President calls for a holistic interpretation of Article 149(1) of the Constitution, read in its proper textual, structural, and purposive context. Article 149(1) provides in express and unambiguous terms that within 14 days after a vacancy in the office of Deputy President, the President shall nominate a person to fill that vacancy, and that the National Assembly shall vote on the nomination within 60 days of receiving it. The correct approach to that interpretive exercise is well settled. The Supreme Court affirmed in the matter of the principle of gender representation in the National Assembly and Senate that constitutional interpretation must be holistic and that no provision of the Constitution may be read in isolation, divorced from the broader architecture of the document of which it forms part. The court elaborated the context of that holistic approach in the matter of Kenya National Commission on Human Rights, holding that holistic interpretation requires contextual analysis, which is reading a constitutional provision alongside and against related provisions so as to arrive at a rational and principled understanding of what the Constitution must be taken to mean, having regard to its history, the issues in dispute, and prevailing circumstances. It is this disciplined, context-sensitive methodology that we apply to the question at hand. A holistic reading of Article 149(1) in its contextual context reveals compellingly that this provision is self-executing. It prescribes a complete and self-contained procedure of nomination by the President within 14 days, followed by a vote by the National Assembly within 60 days. It makes no cross-reference to any other article for supplementary procedure. Critically, it makes no mention of public participation, nor of committee vetting, nor of any other consultative mechanism. The framers of the Constitution were not silent on public participation by inadvertence. When they intended to require it, they said so in express terms. Article 118(1)(b) expressly mandates Parliament to facilitate public participation in its legislative and other business. The deliberate omission of any equivalent requirement from Article 149(1) is itself a constitutional signal that must be given interpretive effect. To read a public participation requirement into Article 149(1), where none appears in the text, would be to engage in precisely the kind of unbridled extrapolation that the Supreme Court cautioned against in Kenya National Commission on Human Rights. The constitutional text of 149(1) is further instructive in its precise choice of language. The provision directs that the National Assembly shall, and in quotes, vote on the nomination. This is a deliberate linguistic choice by the constitutional drafters, and it is not open to a court to substitute its own preferred terminology for that which the Constitution has expressly employed. As the Speaker of the National Assembly correctly ruled, the phrase vote on connotes an electoral determination, so that the National Assembly was in constitutional substance electing the Deputy President from among the nominee presented by the President and not approving an executive appointee in the manner of a parliamentary vetting process. That interpretation is faithful to the constitutional text and is consistent with the structural design of that provision. This understanding is further reinforced by Articles 1, 2, and 1, 3 of the Constitution, which vest sovereign power in the people and provide for its delegation to, among other organs, Parliament. When the National Assembly votes on a nominee for Deputy President under Article 149(1), it is not acting as a conduit for public opinion, but exercising delegated sovereign authority on behalf of the people. The Constitution makes a deliberate structural choice not to provide for a by-election to fill a mid-term vacancy in the office of the Deputy President, electing instead to vest that determination in the National Assembly as the people's primary representative institution. That choice reflects a conscious constitutional calibration of the respective roles of participatory and representative democracy, a calibration that this court is bound to respect. To accept the petitioner's contention that public participation is a constitutional prerequisite for every decision of constitutional importance would be to obliterate the distinction between participatory and representative democracy, and to impose an obligation on the National Assembly to conduct public participation before every significant vote, including the election of the Speaker, the Deputy Speaker, and appointment of committee chairs. That is plainly not what the Constitution requires. As this court confirmed in Ogotegererwa and 6 others versus Cabinet Secretary for National Treasury and Planning, where it was held that the representative democracy as a complement to participatory democracy is independently and fully constitutionally recognized. The Supreme Court stated as follows, that Article 1.1 declares that the sovereign power belongs to the people of Kenya, and that power can be exercised only in accordance with the Constitution. Article 1.2 further proclaims that the people may exercise their sovereign power either directly or indirectly through their democratically elected representatives. It is this direct democracy aspect the Constitution provides for citizens to participate in referenda on certain constitutional amendments as outlined in Article 255. Additionally, it promotes a participatory approach to governance with Article 10.2a identifying democracy and participation of the people as national values and principles of governance. This is reinforced by specific constitutional obligations such as the duty imposed on Parliament under Article 118 1B to facilitate public participation and involvement in its legislative and other business. Conversely, the Constitution also provides for indirect democracy. In that regard, Article 1.3 states that sovereign power is delegated to specified organs, state organs, including Parliament and the legislative assemblies of county governments. Moreover, Article 94.1 of the Constitution provides that the legislative authority of the Republic is derived from the people and at national level is vested in and exercised by Parliament. This speaks to the representative aspect of democracy, which grants elected representatives the discretion to make legislative decisions on behalf of the people they represent, with the legislative discretion being balanced by the Constitution's commitment to participatory governance. End of quote. While it is unquestionably correct that Articles 110 and 118 of the Constitution apply to all state organs and to all public business, it does not follow that every discrete act of Parliament is intended or is attended by a mandatory public participation obligation. The vote contemplated by Article 149.1 is a discrete, constitutionally prescribed electoral act. It is not the making of a law, it is not the formulation of a policy, it is not the implementation of a public program. It is a binary determination of acceptance or rejection of a single presidential nominee in which there is no middle ground, no policy choice to be made, no legislative text to be drafted, and no program to be designed. Public participation, the purpose of which is to inform deliberative and policy-oriented public decision-making, would add nothing of constitutional value to a binary vote of this character. Furthermore, even where one to extend the concept of public participation to encompass public observation and accountability, we do find that the proceedings of the National Assembly on the nomination of His Excellency Kindiki were conducted in a fully open and transparent manner. The debate was televised, the proceedings were recorded in Hansard, the press was free to report, and members of Parliament were directly accountable to their constituents for the manner in which they exercised their votes. We are therefore satisfied that this openness and transparency, which is the constitutional core of Article 118.1a's requirement that public conducts its business in an open manner, was amply satisfied. For the foregoing reasons, we hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149(1). Next, I will look at the main issue on constitutionality and legality of the standing orders. The petitioners asked this court to consider and pronounce itself on the National Assembly's Standing Orders number 64-2 and 65, as well as Senate Standing Orders 75, 78, 79, and 80. Beginning with the National Assembly, some of the petitioners assailed the constitutionality of Standing Order number 64-2, contending that the provision imposed an impermissibly truncated 7-day timeline for the disposal of impeachment proceedings. They argued that such compressed timelines undermined meaningful public participation and curtailed the rights to a fair hearing guaranteed under the Constitution. They thus prayed for a declaration that Standing Order 64-2 is unconstitutional, null and void to the extent that it prescribes a timeline that is incompatible with constitutional requirements for public participation, fair hearing, and compliance with court orders, and an order of certiorari to quash Standing Order number 64 and 65 of the National Assembly Standing Orders to the extent that they apply to the Deputy President. The respondents in answer defended the constitutional validity of Standing Order 64-2 and 5, contending that they are necessary for the expeditious conduct of impeachment proceedings. They pointed to the Constitution itself as a source of the condensed timelines, including Article 145(2)(a), which requires the Speaker to notify the Senate within 2 days, Article 145(3), which requires the Senate to convene within 7 days, and Article 145(4), which requires a special committee to report within 10 days, and submitted that it would be illogical to impugn a standing order that prescribes a 7 to 12-day time frame when the Constitution itself operates within a similarly compressed time frame. The respondents further submitted that Article 124(1) expressly empowered each House of Parliament to make standing orders for the orderly conduct of its proceedings, and that Standing Order 64(2) is a legitimate and necessary operationalization of that constitutional framework. They urged the court to exercise restraint in accordance with the separation of powers on the issue. Having carefully considered the rival contentions of all the parties, we now pronounce ourselves as follows. It is trite that standing orders are subordinate legislation deriving their authority not from Parliament itself, but from the Constitution. Article 124(1) of the Constitution expressly empowers each House of Parliament to make standing orders for the orderly conduct of its proceedings, including those of its committees. Article 124(2) further entrenches the role of parliamentary committees within this framework. Being creatures of the Constitution, we agree with the submission that standing orders must at all times conform to the spirit of the Constitution, its values and animating principles. They cannot rise above the instrument that gives them life. Standing Order 64 prescribes the procedure for removal of the Deputy President under Article 145 of the Constitution. Standing Order 65(2) extends this procedure with necessary modifications to the impeachment of a Deputy President under Article 151(b) of the Constitution. Standing Order 64(1) requires that a member seeking to initiate such a motion must submit it in writing to the clerk, clearly stating the grounds of removal supported by at least 1/3 of all members. The motion must particularize the alleged gross violation of the Constitution or other written law, cite the precise provisions alleged to have been violated and be accompanied by evidence sufficient to substantiate the allegations. The specifically impugned provision, Standing Order 64-2,
Eye Nensoko TV, Oboroso Bumugusi.
Days of notice. Should the Assembly fail to act within that period, the motion is deemed withdrawn and may not be revived in the same session save with the leave of the Speaker. The combined effect is that once an impeachment motion is properly filed, it is subject to strict and unforgiving timelines. 3 days for the Speaker's action and 7 days for the Assembly's disposal, failing which the motion lapses in its entirety. It is these rigid timeframes that the petitioners impugned as unconstitutional. Now, the constitutional provisions engaged by the challenge are uncontested. Article 2(4) of the Constitution, which provides in terms that admit of no ambiguity that any law, including subordinate legislation that is inconsistent with the legislation with the Constitution, is void to the extent of the inconsistency, and any act or omission in contravention of the Constitution is invalid. Article 50, which guarantees the right to a fair hearing, and Article 10 and 118, which further enshrine public participation as a constitutional obligation binding on all state organs, including Parliament, in the exercise of their functions. We have examined at length the constitutional requirements and parameters that govern public participation in impeachment proceedings, and we have set out the applicable principles in detail in the preceding sections of this judgment. In determining whether the timelines in the impugned standing orders contravene these constitutional imperatives, it is not lost on us that Parliament is not a resource-constrained institution. It possesses the institutional capacity, the administrative infrastructure, and the constitutional mandate to reach every part of the Republic through its structures at both the county and national levels. If Parliament genuinely considered 7 days to be a sufficient window for public participation, it bore a corresponding constitutional obligation to deploy its resources adequately to ensure that the process was not merely open in form, but accessible in fact, and that it met the participation threshold authoritatively settled in the BAT decision. A compressed timeline, standing alone, is therefore not necessarily a constitutional infirmity. A compressed timeline, accompanied by an under-resourced and inadequately facilitated process, is an altogether different matter. Still, the question that this court is required to answer is whether 7 days, encompassing the logistical demands of public notification, the organization of participatory forums across a diverse and geographically expansive republic, the receipt and meaningful consideration of public input, and the Assembly's own deliberation on a matter of this constitutional gravity is structurally adequate to meet that threshold. We draw from the Supreme Court of Canada's holding in Hyde Nation versus British Columbia, Minister of Forests, a 2004 decision, that the adequacy of any participatory process must be measured against the gravity, as we have said, of the decision that is being made, and that the more consequential decision, the more robust the participation exercise must correspondently be. At the same time, we are mindful of the importance of according appropriate deference to Parliament in the regulation of its internal proceedings as required under Article 124(1) of the Constitution. In the Supreme Court decision in the Speaker of National Assembly versus the Attorney General, the Supreme Court stated that the court would be averse to questioning parliamentary procedures formulated to regulate internal workings, and the court would not do so as long as the same do not breach the Constitution. Having regard to all the foregoing, we do not consider it warranted to declare Standing Order 64-2 unconstitutional. A declaration of unconstitutionality is a remedy of last resort and a judicial act of the gravest constitutional consequence, not to be visited against upon rather a legislative provision where the provision is capable of a constitutional interpretation or application. We are further guided by the principle of constitutional avoidance that where a provision of subordinate legislation can be read and where it can be applied in conformity with the Constitution, the court ought not to strike it down when a less drastic remedy is available. This principle was affirmed by this court in IEBC versus Minor Kiai and 5 others, where it was held that interpretive generosity must extend where reason permits to the provisions whose constitutionality is challenged. We are not persuaded that the mere existence of a 7-day timeline taken in isolation and on its face renders Standing Order 64-2 void. A provision is not unconstitutional simply because it is capable of being applied unconstitutionally. The vice lies not in the number of days prescribed, but in what Parliament does or fails to do within those days. The timeline, considered as an abstract legislative proposition, is therefore not in itself the source of any constitutional infirmity. The infirmity, where it arises, lies in the manner of implementation, and in whatever Parliament operating within that compressed window deploys, Parliament operating within that compressed window deploys adequate resources, establishes genuinely accessible structures, and puts in place meaningful mechanisms sufficient to discharge its constitutional obligations of public participation under Articles 10, 50, and 118 in substance and not merely in form. The distinction we draw is between a provision that is unconstitutional on its face and void in all its applications, regardless of how it is applied, and one that is conditionally constitutional, as in valid in law, but only where its application is accompanied by the institutional effort and constitutional seriousness that the gravity of impeachment proceedings demands. Standing Order 64-2 falls, in our judgment, in the latter category. In declining to strike down Standing Order 64-2, we instead note that the timeline prescribed in that standing order is not constitutionally mandated. Unlike certain procedural requirements that derive their specific content from express constitutional text, the 7-day window is a creature of parliamentary regulation alone. Parliament was free to prescribe a longer period and still remains free to do so. The experience of the first impeachment of a deputy president to come before the National Assembly under the Constitution of Kenya 2010 might have been a sobering constitutional experience. It may have exposed in real time the structural tensions that compressed timelines have the potential to create when applied to proceedings of national consequence. We commend to Parliament for its serious consideration in the exercise of its sovereign authority to regulate its own proceedings, the question of whether the timelines prescribed in Standing Order 64-2 remain adequate in light of this experience, and whether a timeline that builds in more time for public participation and for the Assembly to deliberate with the gravity that removal from constitutional office demands would not be more befitting of the constitutional moment that the impeachment invariably represents. As it stands, however, we find nothing unconstitutional about the standing order. With respect to the Senate standing orders, the petitioners assailed the constitutionality of Standing Orders 75, 78, 79, and 80 to the extent that they apply to the Deputy President, advancing their challenge on 3 grounds. First, that Standing Order 79 was a mechanical importation of the presidential impeachment framework to the Deputy President's distinct constitutional position without any effort to modify the required identify the required modifications as required by Article 150 to 152. Second, that the appointment of a special committee was mandatory under Article 145(3)(b, and that Standing Order 79 did not mirror this requirement. Third, that the 14-day timeline under Standing Order 75 was structurally incompatible with Articles 47, 50, and 145(5), and was grossly inadequate for proceedings involving 11 complex constitutional allegations. The respondents maintain that Article 145(3)(b uses the word may, which confers a discretion and not a mandatory obligation, that the fact that Standing Order 80 expressly provided for a plenary alternative, while Standing Order 79 did not, was constitutionally significant, as the discretion was conferred by the Constitution itself. They further submitted that Article 152 did not require a formal or recorded exercise of identifying modifications, and that the modifications were implicit in the different constitutional status of the Deputy President. They relied on Speaker of the Senate and another versus Attorney General and another for the proposition that courts should not read into the Constitution obligations that its framers deliberately chose not to include. We have considered the submissions put forward by the parties, and for the avoidance of doubt, standing orders, we provide verbatim what the Standing Order 75, 78, 79, and 80 all provide. Allow me not to go through that. The principle that standing orders must conform to the Constitution applies with equal force to the Senate as it does to the National Assembly, for the reasons we have already set out in the preceding section of this judgment. Our jurisdiction to examine that conformity is equally settled, and will rely on the case of Orange Democratic Party versus Speaker of National Assembly, and Ombogi and 9 others versus County Assembly of Nyamira. We note that Standing Order 78 largely mirrors the impeachment procedure provided for under Article 145. As such, the question of whether the special committee contemplated under standing orders is mandatory or discretionary, and the constitutionality of those standing orders is in the context of Article 145(3)(b is addressed separately in the next ground. On the specific challenge to the absence of a formal recorded modification process under Article 150 Sub-Article 2, some petitioners argue that the phrase "with necessary modification" in Article 150 Sub-Article 2 of the Constitution is a mandatory constitutional directive requiring Parliament to enact a substantive legislative framework tailored to the distinct office of the Deputy President. They emphasize that unlike the President, the Deputy President enjoys no civil or criminal immunity under Article 143, and therefore impeachment must be treated as a mechanism of last resort. In their view, a mere transposition of the presidential framework through standing orders is inadequate and constitutionally insufficient. The respondents countered that with necessary modification is nothing more than a drafting device requiring only the mechanical substitution of president with deputy president. They maintain that the obligation was discharged through the National Assembly Standing Order 65-2 and Standing Order 79, and that the Parliament's procedural autonomy under Article 124(1) shields its internal arrangements from judicial scrutiny. We are unable to accept the respondent's construction. Taken to its logical conclusion, it renders the phrase superfluous. If the Constitution intended mere substitution, it would not have qualified the incorporation of Article 145 at all. The deliberate insertion of those words signals that the drafters anticipated substantive adaptation as opposed to a mechanical production or drafting convenience. This conclusion is reinforced by the structural asymmetry between the two offices, partly under Article 143. We do agree with the submission that a framework that ignores this distinction has not applied Article 145 with necessary modification. It has applied it without modification at all. The standing orders relied upon by the respondents do not cure this deficiency. National Assembly Standing Order 65-2 and Senate Standing Order 79 merely echo the constitutional command without discharging it. They reproduce the obligation verbatim, but provide no substantive modification at all. The county experience is instructive in this procedural questions that a comprehensive statutory framework ought to have addressed in advance. The subsequent county government's state officers' removal from office procedure bill of 2024 was Parliament's legislative acknowledgement of that inadequacy. That bill codifies due process protection, imposes timelines, mandates public participation, establishes a hierarchy between statute and standing orders, and resolves ambiguities such as the role of Senate in voting on charges regardless of committee findings. By contrast, the national framework for removal of the deputy president contains none of such safeguards. The very issues agitated in the petitions before us, including the inadequacy of public participation, the role of the special committee, procedural rights of the deputy president, timelines, and neutrality of presiding officers, are precisely the questions a dedicated legislative framework would have foreclosed. Equally, the question on judicial intervention before an impeached president or deputy president is replaced would also be addressed in the legislation. Their resolution through litigation rather than legislation, and the challenges that the impeachment proceedings have brought forth is itself evidence of that lacuna. Courts do not legislate, but it is within the proper constitutional role of the courts to identify legislative gaps and invite Parliament to address them, particularly where those gaps carry the potential for constitutional crisis. We therefore find that the existing framework under Article 150 is structurally inadequate. The absence of a comprehensive structural framework does not preserve parliamentary autonomy. It transfers the resolution of fundamental procedural questions to the courts at considerable cost to institutional certainty and public confidence. We therefore hold that Parliament ought urgently to enact a dedicated statutory framework for the removal of the Deputy President under Article 150. We do observe, however, that the absence of such legislation does not invalidate the impeachment process already undertaken. This is because the Constitution itself, at Articles 144 and 145, sets out the minimum threshold for conducting such proceedings. It is upon this constitutional framework that Parliament relied, ensuring that the process was carried out in a manner designed to safeguard the Deputy President's protections. On timelines, we note that Standing Order 78-2 imposes a 10-day timeline in respect of a special committee investigation. Neither the standing orders nor the Constitution prescribes a timeline for plenary proceedings. The Senate's adoption of a 10-day deadline for its plenary hearing was therefore a self-imposed procedural choice and not a requirement of the standing orders or the Constitution. The Senate was not obligated by any applicable rule to impose that timeline when it elected to proceed by way of plenary. And the petitioners have not demonstrated that the choice to do so was in itself a constitutional violation.
I will now deal with two issues, that is the composition of the National Assembly and IBC, and the issue of the constitutional processes. I'll start with the issue of composition of the National Assembly and the IEBC. Three other issues were raised under the heading, including whether the National Assembly was properly constituted to consider the impeachment motion, whether the nomination of His Excellency Kindiki could take place in the absence of fully constituted IEBC, and whether his nomination as Deputy President was infirm. We shall address these issues in turn. The third petitioner, Honorable Jane Njeri Maina, invited this court to declare that the National Assembly, as presently constituted, was not legally constituted for failure to comply with the constitutionally two-thirds gender principle under Articles 27, 81B, 100, and 261 of the Constitution. She submitted that, as a consequence, the National Assembly is incapable of entertaining or deliberating on the impeachment motion against the Deputy President. She therefore sought declarations impugning both the legality of the National Assembly and the validity of the proceedings arising from its resolution. The respondents opposed that contention. The National Assembly and its clerk maintained that the constitutional requirements concerning the composition of Parliament under Articles 97 and 98 of the Constitution had been satisfied. They admitted that they submitted that the two-thirds gender principle did not render Parliament unlawfully constituted or incapable of functioning, and that Article 261 itself establishes the constitutional mechanism for securing compliance where legislation or implementation has lagged. They warned that acceptance of the petitioner's proposition would invalidate all parliamentary business undertaken since 2013, an outcome they described as constitutionally untenable and absurd. The Speaker of the Senate and the Senate associated themselves with that position and further urged judicial restraint, submitting that despite that the dispute concerning implementation of the two-thirds gender principle remains actively before a duly constituted 5-judge bench in Conchela and others. There can be no controversy that the two-thirds gender principle is a constitutional imperative. Article 81B decrees that not more than two-thirds of the members of elective bodies shall be of the same gender. Article 27 and Article 100 reinforce the constitutional commitment to equality, inclusiveness, and equitable representation. The courts of this country have consistently affirmed that gender principle is not ornamental constitutional rhetoric, but a binding constitutional stance that demands implementation. Equally, however, constitutional adjudication must be undertaken within the framework of the Constitution and the dispute resolution mechanisms it establishes. The question before us is not whether the two-thirds gender principle is obligatory. It undoubtedly is. Rather, the narrower and the more immediate question is whether the alleged non-compliance with that constitutional principle rendered the National Assembly illegally constituted as to deprive it of authority to entertain and determine an impeachment motion under Articles 145 and 150 of the Constitution. Article 261 of the Constitution speaks to the timelines within which legislation ought to be passed by Parliament. It also provides for the consequences of failure to pass legislation. On such a failure, a petition may be filed in the High Court, and the court may grant a declaratory order directing Parliament and the Attorney General to take steps to ensure that the required legislation is enacted within the period specified in the order and to report the progress to the Chief Justice. In the event Parliament fails to enact the legislation in accordance with the court order, the Chief Justice shall advise the President to dissolve Parliament, and the President shall so dissolve Parliament. The new Parliament shall then enact legislation within the timelines contained in the court order, lest it faces similar consequences. The issue of failure by Parliament to enact the legislation on the gender rule has been litigated in courts for relatively long. Further, in an advisory opinion filed in the Supreme Court, other petitions under Article 261 have been filed in the High Court and declarations made. The Honorable Chief Justice even advised the President to dissolve Parliament. It was that advice that elicited the institution of Conchela and others versus Chief Justice Supra. The matter was recently determined by an expanded bench of this court via the judgment delivered on the 5th of June 2026, that is last Friday, where the advice to dissolve Parliament by the Honorable Chief Justice to the President was declared unconstitutional and subsequently quashed for failure to comply with some fundamental procedural steps. The court, however, clarified that the parties were still at liberty to comply with the requisite procedural steps, and that which the law will then follow its course. Therefore, as long as the redress in Article 261 is yet to be fully realized, it will be premature for this court to declare that the National Assembly was not properly constituted to consider the impeachment motion. To that end, the contention fails. The challenge to the IBC was advanced on two related grounds. First, that IBC was constitutionally incapacitated by the absence of commissioners at the material time, such that any verification of His Excellency Kindiki's qualifications being a substantive commission-led function under Article 250, Sub-Article 1, could not lawfully be performed by the Secretariat alone. And second, that the clearance process was consequently a nullity that fatally infected the nomination. The respondents, however, maintained that the midterm replacement mechanism under Article 149, Sub-Article 1, was a sui generis self-executing constitutional process that did not engage the IBC electoral mandate under Article 88, Sub-Article 4, and that the strict eligibility and clearance protocols under Articles 99 and 137 applied exclusively to general elections and not to midterm nomination vetted directly by the National Assembly. Our reading of Article 149, Sub-Article 1, confirms that it is unambiguous, express, and self-contained. It establishes a strict executive legislative process where the president nominates and the National Assembly votes on the deputy president nominee. It makes no reference to IEBC. That omission is not an oversight. It is a deliberate constitutional choice which this court must give full effect. Were it the intention of the drafters to impose a more stringent requirement, nothing would have been easier than to say so expressly, as they did in Articles 99 and 137 in respect to candidates for elective office at a general election. The absence of any equivalent requirement in Article 149, Sub-Article 1 is therefore a considered constitutional choice to be respected. For ease of reference, Article 149, Sub-Article 1 provides as follows, and I quote, vacancy in the office of Deputy President. Within 14 days after a vacancy in the office of Deputy President arises, the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. From a plain reading of the above, we are convinced that no clearance was required by the Deputy President, and that the vote by the National Assembly was an expression of representative authority by the sovereign's elected representative, precisely the constitutional mechanism that Article 149, Sub-Article 1 contemplates. Under Article 1 of the Constitution, sovereign power belongs to the people of Kenya and may be exercised either directly or through their democratically elected representatives. When the National Assembly voted on His Excellency Kindiki's nomination, it did so as the constitutional repository of delegated sovereign authority acting on behalf of the people in accordance with the specific mechanism the Constitution provides for filling in a midterm vacancy in the office of the Deputy President. We equally accept the respondent's submissions that on the deliberate use of the word vote in Article 149(1 as opposed to the words approve or vet that the Constitution employs in other contexts. That distinction is constitutionally significant. Across the Constitution, we note that the word approve is used where Parliament exercises a confirmatory function in relation to executive appointments, as in the approval under Article 132, Sub-Article 2 of Cabinet Secretaries, the Attorney General, the Secretary to the Cabinet, the Principal Secretary, the High Commissioners, Ambassadors, and diplomatic consular representatives, as well as any other state or public officer whom the Constitution requires or empowers the President to appoint or dismiss. The same applies to the approval of the candidates for constitutional offices such as the Chief Justice under Article 166 of the Constitution. In those contexts, approval connotes a deliberate and structured vetting exercise in which Parliament assesses the suitability of the nominee against a prescribed criterion, and in which the IBC or other constitutional bodies may have a role to play in verifying qualifications. The word vet carries similar connotations of structured scrutiny against defined standards. The word vote, by contrast, denotes a direct and immediate exercise of collective democratic will. It is the language of elections and of sovereign determination. Its use in Article 149, Sub-Article 1, signals that the National Assembly's function in the midterm replacement process is not to sit in the judgment of the nominee's suitability, but to exercise on behalf of the people a direct democratic determination on whether the president nominee should fill the vacancy. That determination is political and representative in character, and it is expressed through the ballot of elected members of Parliament, each of whom is accountable to their constituents for the vote they cast. It consequently follows that no input or intervention by the IBC was constitutionally required in the midterm replacement process under Article 149(1). The absence of any IBC involvement would not have rendered the nomination or the filling of the vacancy unconstitutional. The informational input by the IEBC Secretariat did provide was, in those circumstances, entirely voluntary in character. It was not a condition precedent to the validity of the process, and its presence or absence was constitutionally irrelevant to the outcome. That being so, the fact that the input was provided by the Secretariat in the absence of commissioners is equally irrelevant. If the input was not required at all, the question of whom within the IBC provided it simply does not arise. For completeness, however, and to the extent that any residual question remains about the lawfulness of the Secretariat's involvement, we are satisfied that the informational verification performed by the Secretariat could not have constituted a clearance in the electoral sense, but rather a routine administrative task, and as such not constitutional or policy-driven. The same was legally permissible and procedurally valid and fell squarely within the Secretariat's lawful administrative mandate. We draw from the advisory opinion number 4 of 2024 IBC and the Honorable AG, where the Supreme Court gave guidance on the dichotomy that exists between the role of the commissioners and that of the Secretariat in the following words. And I quote, "The Secretariat, under the leadership of the Commission, Secretary and the CEO, is empowered to undertake routine administrative and operational tasks essential for the day-to-day functioning of the Commission. In the same vein, it is necessary to clarify that the absence of commissioners does not of itself vitiate or invalidate administrative actions taken by the Secretariat within the scope of its lawful mandate, including the execution of contracts, management of personnel, procurement, and other functions necessary for institutional continuity. Such acts remain valid and binding, and provided they fall within these bounds of statutory delegation and do not purport to usurp the constitutional function of the Commission as a corporate body," end of quote. To guard against institutional overreach, the Supreme Court carefully delineated where IBC's administrative mandate ends as follows, and I quote once again, "Having concluded as above, a clear distinction must be drawn between administrative continuity by the Secretariat and the exercise of constitutional authority vested in the Commission as a collegial entity. It is our considered view that the exercise of constitutional function expressly reserved for Commission, such as those enumerated under Article 88, Sub-Article 4 of the Constitution, cannot be lawfully discharged in the absence of a properly constituted Commission with the requisite quorum as contemplated under Article 250, Sub-Article 1 and Sub-Article 2 of the Constitution," end of quote. This differentiation of responsibility in Section 11A of the Independent Electoral and Boundaries Commission Act and exposed by the Supreme Court in the Muruli versus Oparanya and 3 others case. For all these reasons, it is our finding that the Secretariat did not travel beyond its mandate. It simply functioned as an information repository. Having so found, we now move to the last sub-issue concerning the constitutional validity of His Excellency Kindiki's nomination. The petitioners anchored the ground on Article 148, Sub-Article 1, read with Article 137, contending that His Excellency Kindiki was serving as Cabinet Secretary for Internal and National Administration, a state office under Article 260, at the time of his nomination and parliamentary approval on the 18th of October 2024. He was disqualified from nomination by dint of Article 137, Sub-Article 2B, rendering the entire process null and void ab initio. In contrast, the respondents who responded to this ground argued that the appointment process was completely legal and procedurally sound. They maintained that the filling of midterm vacancy under Article 149, Sub-Article 1 was an independent sui generis executive-led process, and that was distinct from traditional election or appointment. Further, it was the case that the restrictive disqualification in Article 137, such as the recruitment to the requirement to resign 6 months prior to or to secure multi-county voter endorsement, were tailored exclusively for general elections, not sudden midterm vacancies that demanded swift action to prevent a leadership vacuum. They contended that the initial formation of a presidential joint ticket under Article 148 could not apply to midterm emergency transitions. In addition, His Excellency Kindiki and the IBC specifically disputed the factual basis of the petitions, arguing that His Excellency Kindiki had in fact provided official gazette notices proving he had formally resigned from his cabinet position prior to his appointment as Deputy President. In considering the arguments of both parties, we turn to the relevant constitutional provisions, to wit Articles 137, 148, and 149. Article 137, Subarticle 2b, bars any person who is a public officer or is acting in any state or other public office from nomination as a presidential candidate. Article 137, Subarticle b, carves out exemptions for the sitting president, the deputy president, and members of parliament. Cabinet secretaries are not included in that exception. Article 148, Subarticle 1 also locks the qualifications of a deputy president candidate to those of a presidential candidate under Article 137. And Article 148, Subarticle 2 provides that there shall be no separate nomination process for the deputy president at a general election. Article 149, Subarticle 1, however, creates an entirely distinct pathway of filling a mid-term vacancy, as we have already observed, through a direct presidential nomination followed by a National Assembly vote. It makes no cross-reference to the electoral machinery or disqualification timelines that apply under Articles 137 and 148 in the general election context. A strict textual reading of Article 148, Subarticle 1, and Article 137, Subarticle 2b together would, if applied without contextual qualifications, bar an active cabinet secretary from nomination unless a timely resignation had occurred. However, we are satisfied that Article 149, Subarticle 1, creates a sui generis process that cannot be evaluated by mechanical application of the general election framework. Article 149, Subarticle 1, omits the standard electoral requirements, including the signature collection requirement, and Article 137, Subarticle 1d, which signals the framers' intention that this provision operates independently of the general election machinery. To apply the strict disqualification timelines of the electoral context to a sudden or unforeseen midterm vacancy would risk creating an executive leadership vacuum of precisely the kind that Article 149, Subarticle 1 was designed to prevent. In any event, we are satisfied that the factual premise of the petitioner's challenge is not established on the evidence. The primary constitutional mischief targeted by Article 137, Subarticle 2b, is the prevention of active public servants from deploying state resources or conflicting institutional mandates to influence an election or appointment. The evidence before this court establishes that despite the unique circumstances of his nomination, His Excellency Kindiki formally resigned from the cabinet and gazetted his exit prior to taking oath of office as Deputy President. By severing his ties to the cabinet before assuming the deputy presidential office, the potential conflict of interest under Article 137, Subarticle 2b is designed to address was lawfully cured. The core integrity parameters of Chapter 6 and Article 137 of the Constitution were accordingly satisfied. This ground of challenge therefore fails. Before concluding on this issue, we must address whether the speed with which the state resolution with which the Senate resolution was gazetted, the President nominated Professor His Excellency Kindiki, and the National Assembly approved the nominee contravened the Constitution and the law. The petitioners argued that the extraordinary haste following the Senate's resolution of 17th of October 2024 revealed a predetermined impeachment process. In their view, the immediate gazettement, swift presidential nomination, and expedited parliamentary approval were evidence of a pre-arranged outcome. They contended that such speed undermined constitutional values of transparency, accountability, public participation, fairness, and constitutionalism. The respondents, including His Excellency Kindiki, took the opposite position. They maintained that the Constitution itself anticipates expedition in matters concerning high constitutional office. Once a vacancy arose in the office of the Deputy President, they argued the President was constitutionally bound to act under Article 149. Prompt compliance with such a duty, they insisted, cannot be itself amount to constitutional impropriety. Turning to the Constitution, Article 149(1), we have already reproduced that section, that article. I don't need to go through it again. Proceed. This provision leaves no doubt that the framers of our Constitution deliberately contemplated speed in filling in a vacancy of the Deputy President's office. The rationale is evident, and it is to safeguard continuity and the stability in the national executive by requiring prompt action. Judicial President reinforces this principle. In Ali Hassan Joho and another versus Suleiman Said Shabal and others, this is a Supreme Court petition number 10 of 2013, the court held that constitutional timelines are substantive requirements, not procedural conveniences, and cannot be extended by legislation or judicial discretion. Similarly, in the Mankin Aramat versus Harun Meitamei, Lenpaka, and two others, the Supreme Court, it's a Supreme Court matter petition, the court emphasized that constitutional timelines are binding commands, cautioning against reliance on Article 159 to circumvent them. The same principle was affirmed in Moses Masika Wetangula versus Muskari Kombo, Muskari Nazi Kombo, and two others, and in Harun Meitamei Lempaka versus Lempakian Aramat, where the Court of Appeal underscored the constitutional significance of timelines. Collectively, these authorities highlight that timelines serve vital public interests, including certainty, legitimacy, and orderly governance. The Supreme Court's decision in Raila Odinga and five others versus Independent Electoral and Boundaries Commission and three others, this is presidential petition number 5 of 2013, is also instructive. Addressing timelines under Article 140, the court had the following to say, and I quote, according to Article 140 of the Constitution, it is clear that in the resolution of presidential election disputes, I repeat that. According to Article 140 of the Constitution, it is clear that expedition in the resolution of presidential election disputes is of essence, end of quote. The court warned that prolonged uncertainty regarding the presidency undermines public interest. This reasoning reflects a broader constitutional philosophy that uncertainty in the occupants of high office is detrimental, and the Constitution deliberately establishes mechanisms to ensure continuity. Applying these principles, we are not persuaded that the prompt gazettement of the Senate's resolution was unconstitutional. Once the Senate concluded its process, the Deputy President ceased to hold office, and nothing in the Constitution required a waiting period before gazettement. Likewise, the President cannot be faulted for acting swiftly under Article 149. He was constitutionally obligated to nominate a replacement within 14 days. Compliance with this duty cannot be construed as wrongdoing. To hold otherwise would penalize constitutional actors for fulfilling their obligations. The same reasoning applies to the National Assembly. Article 149 allows up to 60 days to vote on a nomination, but it does not require Parliament to exhaust that period. Acting sooner than the deadline is not evidence of illegality. Speed alone does not establish predetermination. The law requires objective proof that a decision maker had closed their minds before exercising power. Mere expedition does not meet that threshold. We therefore find that the gazettement of the Senate resolution, the President nomination of His Excellency Kindiki, and the nomination National Assembly's approval did not contravene the Constitution simply because they were undertaken expeditiously. I will now turn to the constitutional processes. Under this heading, this court is called upon to interpret Articles 144 and 145 of the Constitution to determine whether the Senate was obligated to establish a special committee to investigate the charges against the Deputy President, or whether the formation of such a committee was discretionary. The court is equally invited to examine the procedures applied in the impeachment process, with particular focus on Article 150, sub-Article 2, and the extent to which, if at all, the Senate ran afoul the Constitution in that respect. Starting with the first issue, the dispute before us brings into sharp focus the jurisprudential tension embedded in Article 145 of the Constitution, and more particularly, Article 145, sub-Article 3b of the Constitution. Article 145, sub-Article 2 and sub-Article 3 detail the provision of removal in the following terms. I do not need to read those ones, those provisions. I proceed. The true import of Clause 3b cannot be discerned in isolation. It demands a historiographical examination and a forensic appreciation of historical continuum just a minute. Yes, I proceed. The true import of Clause 3b cannot be discerned in isolation. It demands a historiographical examination and a forensic appreciation of the historical continuum of Kenya's constitutional reform. Constitutional interpretation, particularly in matters touching on the architecture of the governance, must be informed by history, for history illuminates the intent of the framers, constitutionalizes the text, and guards against distortion that arise from reading provisions in a vacuum. As the courts have consistently held, Constitution is not merely a legal, instrument, but a living charter whose meaning is enriched by the struggles, compromises, and aspirations that birthed it. Accordingly, this inquiry necessitates tracing the evolution of impeachment clause through the Bomas draft, the Wako draft, and the harmonized draft to appreciate the context of Article 145, sub-Article 3b was ultimately incorporated into the Constitution. Article 164 of the Bomas draft outlined the procedure for impeachment, vesting the Senate with ultimate authority. It provided that upon receipt of a resolution from the National Assembly, the Speaker of the Senate would convene the Senate, and if the motion was passed, a special committee of the 13-member will be appointed to investigate the matter. The language of the Bomas draft was rigid and prescriptive. The investigatory phrase was mandatory, and the committee route was the inescapable mechanism for digesting evidentiary complexities prior to a final vote. If the committee found the allegations unsubstantiated, no further proceedings will ensue. For avoidance of doubt, it provided as follows. The Speaker of the Senate shall, if Senate is then sitting or has been summoned to bring the motion to the notice of the Senate for the consideration within 7 days, or if Senate is not then sitting, will summon it to meet within 21 days of the motion, 21 days of the notice to consider the motion. If a motion is passed under Clause 3, the Senate shall appoint 13 of its members as a special committee in accordance with its standing orders of the Senate to investigate the matter. If the special committee shall investigate the matter and shall, within 10 days, report to the Senate whether it finds the particulars of the allegations against the President to have been substantiated. End of quote. Similarly, Article 155 of the WACO draft mandated the formation of a special committee of 13 members of Parliament to investigate allegations once an impeachment motion was initiated. The provision was explicit and inflexible, leaving Parliament with no discretion. The committee route was compulsory, and the President retained the right to appear and be represented before the committee. For clarity, we have reproduced that one as well, but I will not go through it. I proceed. The harmonious draft of 2009 and its subsequent revision in 2010 represents the constitutional settlement now embodied in Article 145, which is the subject of contestation before us. To our mind, there appears to have been a deliberate harmony in the manner the previous drafts treated the committee stage of the impeachment proceedings. We are convinced that the framers intended to preserve this consistency across the drafts rather than to depart from it. This conclusion is fortified by a wholesome reading of the Constitution, which we explain in detail. Interpreting the text before us requires a careful and nuanced exercise in constitutional interpretation. Fortunately, the Constitution itself provides guidance on how it should be read. Articles 20, subarticle 4, and Articles 259, subarticle 1 establish the interpretive framework. Article 20, subarticle 4 directs courts when interpreting the Bill of Rights to promote the values of an open and democratic society founded on human dignity, equality, equity, and freedom, while giving effect to the spirit and the objects of the Bill of Rights. Article 259, subarticle 1 further commands courts to interpret the Constitution in a manner that advances its purpose, values, and principles, threatens the rule of law, protects human rights and fundamental freedoms, permits development of the law, and contributes to good governance. Over time, our courts have consistently emphasized that the 2010 Constitution demands a transformative approach to interpretation. Recognizing its highly progressive nature, courts have articulated several interpretive canons. In David D. and others, as AG, the High Court, that is the BBI case, the High Court identified 4 guiding principles: that the Constitution must be interpreted holistically, that it should not be approached with rigid formalities or treated as a mere statute, that its own theory of interpretation must be applied to safeguard its values, objects, and purpose, and that non-legal considerations are essential to uncover the true meaning and values. The Supreme Court, in the matter of Kenya National Commission on Human Rights 2014, clarified that a holistic interpretation requires contextual analysis, which means reading provisions alongside and against each other, informed by history, disputes, and prevailing circumstances. Similarly, in the Tunyefuza versus AG case, this is a Ugandan court, stressed that a constitution must be read as an integrated whole with each provision sustaining rather than undermining the others. The principle that the constitution must not be interpreted through rigid formalism was also emphasized by the Supreme Court in Interim Independent Electoral Commission 2011 and the Communication Commission of Kenya versus Royal Media Services 2015. The court observed that constitutional interpretation requires more than positivistic approaches. The court noted that Articles 20, Subarticle 4 and Articles 259, Subarticle 1 incorporate non-legal considerations such as historical, social, cultural, and political realities that must inform judicial reasoning. The court highlighted that Kenya's modern Bill of Rights envisages a human-based approach and social justice-oriented society, and judicial authority derived from the people under Article 159, Subarticle 1 must reflect these values in court decisions. The former Chief Justice Emeritus Mutunga, in his concurring opinion in the Speaker of the Senate and another versus the AG, this is 2013 reported, also underscored the constitution making was an ongoing process, and acknowledged that compromises in drafting often create vagueness, and it is the court's responsibility to resolve contradictions and clarify gaps. In his words, I quote, "Constitution making does not end with the promulgation. It continues with the interpretation." Finally, the Court of Appeal in Center for Rights, Education and Awareness, and another versus John Harun Mwau, 2012 reported, linked constitutional interpretation with the statutory interpretation principles. It reiterated that courts must avoid absurd, unpracticable, illogical, and artificial results, and must always strive to serve the public interest. Fidelity to both the letter and the spirit of the Constitution requires interpretations that advance justice, rationality, and the common good. Guided by the interpretive principles discussed above, we now turn to examine the purpose and the intent of Article 145, Subarticle 3 of the Constitution. We do so with full appreciation of the demands of judicial humility and the doctrine of stare decisis, which binds inferior courts to the pronouncements of superior ones and is the bedrock of coherent and predictable legal order. Our analysis is therefore offered within that framework, not as a departure from it. We are aware that the Supreme Court has determined the question in the Sonko decision, and we are mindful that the suggestion we are advancing in this discussion will build upon the existing jurisprudence and contribute to the broader legal discourse on this question. It is in that spirit and with deference owed to the Supreme Court that we nonetheless set out the following reasoning. Having already traced the historical development of this provision, a comparison of the earlier drafts with the current text reveals a consistent approach to the introduction of a removal motion from the National Assembly. In every instance, the motion was to be formally tabled for consideration. The draft made clear that once introduced, the motion would be debated and, if passed, the special committee constituted. This framework is now embedded in Article 145(3)(a) of the 2010 Constitution, which expressly obligates the Senate to convene and or hear the charges against the President. These charges are the charges as contained in the removal motion transmitted from the National Assembly pursuant to Article 145, sub-article 2. It is only after the Senate has heard the charges that Article 145, sub-article 3b comes into play. It is important to note that the motion was never intended to be passed or dismissed as a mere formality. The House was called upon to consider, debate, and to resolve whether the motion should proceed or fail. If the motion failed, that marks the end of the matter, and no further proceedings will follow. Conversely, if Parliament determined that the matter warranted investigation, it passed a resolution allowing the impeachment motion to proceed, and a special committee is then formed. Returning to Article 145, sub-article 3A, upon receipt of the removal motion, the Senate is required to hear the charges. While this hearing may not necessarily connote a formal trial, it provides an opportunity for the House to be appraised of the charges, the supporting evidence, and any accompanying documentation. At this stage, the Senate must decide by resolution whether the charges merit investigation. It is also at this point that the House considers whether the other preliminary requirements, such as the constitutional threshold, were properly satisfied by the National Assembly in the first place. We have examined the Hansard record of the Senate sitting on Wednesday, the 9th of October 2024, convened pursuant to Kenya Gazette Notice number 13170. The record shows that the Honorable Speaker of the Senate duly appointed the session for the purpose of hearing the charges against the then Deputy President. During the sitting, the Speaker read out all 11 charges and formally laid before the Senate the documents conveying the resolution of the National Assembly. These materials included the notice of special motion, affidavit of Honorable Ekoman Mwengi Mutuse, MP, electronic evidence relating to the motion, order papers, communications from the chair, certified Hansard record, votes and proceedings, public participation notices, correspondences from the advocates, press statements, court orders, and other supporting documentation. The Honorable Speaker proceeded to draw the attention of the House to the special and the unique nature of the business before it. It reminded senators that impeachment is a fundamental tool of legislative oversight and a critical component of the constitutional framework of checks and balances, noting further that the matter had attracted immense public interest. The Speaker then outlined the way forward, informing the House that by its resolution, it had two options of handling the motion, either through a special committee or in plenary. Significantly, the procedure adopted by the Speaker reveals that once the charges and supporting evidence were laid before the House, there was no opportunity for senators to deliberate on whether further investigations were necessary. In particular, the House was not afforded the chance to engage in a substantive inquiry into the propriety of the process undertaken by the National Assembly or the validity of the charges themselves. The question that now arises is whether it was necessary for the Senate, in the first instance, to address itself to the need for investigations before proceeding to the actual hearing of the motion. It must be emphasized that the Senate is not a mere conveyor belt for the matters originating from the National Assembly or any other entity. Rather, it is a revered house vested with autonomy and empowered to make decisions by way of resolution. The Senate, therefore, retains discretion to determine whether to accept any motion, petition, or request for further deliberation, save in circumstances where the Constitution or statute expressly removes such discretion. This explains why the earlier drafts of the Constitution stipulated that a motion had to be passed before a special committee could be formed. The design was deliberate the design was deliberate. The House was first required to decide whether the motion should pass or fail, and only upon passage will the question of constituting a special committee arise. A useful instruction of this principle is found in the legislative process. Not all legislation automatically passes to the Senate. Article 114, for example, requires the Senate to consider whether a bill transmitted from the National Assembly falls within its jurisdiction and warrants deliberation in the House. Article 145, subarticle 3b, is therefore not unique in this regard. It was intended to give the Senate an opportunity to hear the charges, examine the evidence, and satisfy itself that at least the bare minimum constitutional and statutory requirements had been met on a prima facie basis. In doing so, the Senate would address fundamental preliminary issues, such as whether the grounds of the special motion fall within those provided for in the Constitution or law, whether the jurisdiction had been properly invoked, whether the president was previously tried on the same charges, whether prima facie evidence supports the charges, and whether the requisite threshold was attained in the National Assembly. It is only after the Senate has addressed these preliminary issues that it proceeds to take a vote by way of a resolution on whether to admit the motion for a full hearing or to defeat it. This explains the deliberate use of the word may in Article 145, subarticle 3b. The term may signifies discretion on the part of the Senate to determine whether the motion, as presented, satisfies the minimum constitutional and statutory requirements and therefore warrants further consideration. Once such a resolution is made and the Senate decides to proceed, the House then turns to the procedure governing the hearing. Conversely, if the Senate is not satisfied that the motion merits further interrogation, the matter ends there. There is therefore no ambiguity in the use of the word may in Article 145 3b. It clearly connotes discretion and cannot be equated with the mandatory term shall. The true meaning and intent of Article 143b can only be appreciated in light of that historical context. To interpret the provision in isolation would risk stripping the Senate its discretion to determine what matters it can lawfully consider. This position finds support in the commentary of legal scholars Louis Franceschi and Piero Lumumba in the book Constitution of Kenya, a documentary, second edition 2019, where they stated as follows, and I quote, "In order to avoid abuse of Parliament's power to impeach a president, the Constitution appropriately provides for 2/3 majority threshold of the total number in both houses of Parliament. Furthermore, the Senate is called to constitute a special committee to investigate the charges against the president and present a report as opposed to just voting at the National Assembly. In order to ensure fairness of the Senate's committee proceedings, the president has the right to appear and be represented before the special committee during its investigation," end of quote. Upon careful perusal of the Senate Hansard, however, we did not find any debate or proceedings or resolution indicating that the House interrogated the motion as presented from National Assembly or resolved on the way forward. The record shows that once the motion was laid before the House, the charges were read out and the supporting evidence tendered. That was all. No resolution admitting the motion to a full hearing was made. The Senate instead proceeded to address, directly to address itself on the issue of the charges to be had. In our view, going by our rendition, we will not have approved this way forward. Having so established, we take the position that once Senate resolves to admit and proceed with the hearing of the motion, its discretion is spent. The only cause available is to appoint the special committee to investigate the matter. This conclusion flows naturally from the foregoing discussion and from the deliberate manner in which sub-articles 145, sub-article 4, 5, and 7 are structured. These provisions build upon the process once the special committee is constituted, setting out the subsequent stages of investigation and the right of the Deputy President to appear and be represented before the committee, the tabling of the committee's report before the plenary, a second opportunity to the Deputy President to be heard, and finally, the Senate's vote. We ask ourselves, if the intention had been to follow a direct plenary route, why would the drafters not have said so? Why would they have crafted such a detailed provision for the committee process, only to mention the Senate at the tail end of that process? The deliberate sequencing of sub-articles 145, 4, 5, 6, and 7 leaves no doubt in our minds that the committee mechanism was intended to be the exclusive path once the Senate resolved to proceed. The plenary option was never envisaged as a substitute for the committee process, but rather as the forum for receiving and debating the committee report. To hold otherwise, according to us, will create an absurdity in which the Senate as a house would investigate and then present to itself the investigative report for voting. At the risk of repetition, but for emphasis, we observe that the removal of the president by way of impeachment was not provided for in the retired 1963 Constitution, save for this superficial vote of no confidence. Kenyans were therefore deliberate in crafting a detailed procedure for the hearing of an impeachment motion under the 2010 Constitution. This procedure is well captured in the sub-articles to Article 145, which specify the number of members to be appointed to the special committee, the committee's role in investigating the charges, and the strict timeline of 10 days within which the committee must act. Sub-article 145.5 further commands the observance of the two distinct rights of the president. First, the right to appear before the committee personally, and second, the right to be represented. These rights are not synonymous. The right to appear is exercised by the president as an individual, whereas the right to be represented allows the president to appear alongside counsel or to have counsel appear on his or her behalf. These two rights must be juxtaposed with the right provided for in sub-article 145.6b, which grants the president an opportunity to be heard at the plenary once the committee finds any of the charges substantiated. This right is again distinct, as an opportunity to be heard is not limited to physical or oral hearing, but encompasses the broader ability to present a defense in whatever form the Senate deems appropriate. This interpretation ensures a generous reading of the rights of the president, who is afforded representation and opportunity to be heard both at the committee stage and again before the plenary. Such a generous interpretation is precisely what the Constitution commands. For all the foregoing reasons, we do find that just a minute. Having expressed our view, we again differ unreservedly and with the deepest respect to the binding authority of the Supreme Court as settled in Soko versus County Assembly of Nairobi, where the court pronounced itself as follows. I quote, "In the previous ground 2 above, we categorized the process of removing a governor into 2 stages. This is the second stage. From subsection 3 of Section 33 of the County Government Act, the process moves to the Senate from the County Assembly. Within 7 days after receiving notice of a resolution from the Speaker of the County Assembly confirming the passage of the impeachment motion, the Speaker of the Senate must convene the meeting of the Senate to hear the charge against the governor. The charges can be heard in the Senate plenary or in a forum of a special committee of the Senate that reports to the full Senate. In either case, the governor is entitled to attend and to be represented by counsel during the investigations. It is only when sufficient evidence is presented to substantiate the claims that the Senate will according the governor an opportunity to be heard, vote on each of the charges. If a majority of all the members of the Senate vote to uphold any of the charges, then the governor shall cease to hold office. We reiterate that proof of even a single charge will be sufficient for purposes of Article 181 of the Constitution. But should the vote for removal fail, that brings the proceedings to an end. End of quote. That pronouncement represents that settled and binding position of law. We are constitutionally obliged to follow it, and we do so without reservation, notwithstanding the views which we express above. We observe in passing that although the Supreme Court pronouncement in Sonko was referred in the context of interpreting the County Government Act, the provisions of the Act mirror the virtual identical terms, the language of the Article 145 of the Constitution. That correspondence reinforces its application to the present matter.
We now move to the final issue that we considered, and that is the issue of a fair trial. The gist of this issue turns on whether His Excellency Gachagua was subjected to a lawful and fair trial process within the meaning of Articles 47 and 50 of the Constitution. The petitioners contended that the Senate's conduct of the impeachment trial was fundamentally and irreparably flawed, falling far short of the constitutional standards of fairness, legality, and procedural propriety granted to His Excellency Gachagua under the stated provisions. Their challenge on this ground was advanced on several distinct and cumulative bases. They argued that His Excellency Gachagua was denied his right to a fair trial when, having fallen ill and being hospitalized on the 17th of October 2024, the Senate refused adjournment request and proceeded in his absence, ultimately voting on 5 of the impeachment charges. That the Senate was constitutionally bound under Article 145(3)(b) and 145(4)(6) to appoint a special committee of 11 members to investigate the charges. By defeating the motion to establish such a committee and proceeding by plenary, the Senate deprived him of his right under Article 145(5) to appear and be represented before an independent investigative body. Insulated from political pressure, and that the time afforded to H.E. Gachagua was grossly inadequate, only a few days to respond to 11 complex allegations and just 2 hours to present his defense compared to the extensive time given to the National Assembly. The respondents in defense maintained that the Senate had accorded His Excellency Gachagua a lawful and fair trial consistent with Articles 47 and 50 of the Constitution, that the Senate acted reasonably by granting a short adjournment and offering a further extension to 19th October 2024, and when the formal motion was defeated, they submitted that discretion had been properly exercised, especially since no medical evidence was produced. They maintained that the Constitution conferred discretion to proceed by way of a special committee or plenary under Article 145(3)(b), and denied that new evidence or witnesses were introduced at the Senate stage as alleged by H.E. Gachagua. We have carefully considered the forcefully and ably argued positions advanced by both sides. The constitutional standard which the fairness of the Senate conduct falls to be measured is clearly and comprehensively set out in Article 50 of the Constitution. Of particular relevance to the present inquiry are the following guarantees which Article 50 confers on every accused person as components of the right to a fair trial. Under 50C is the right to have adequate time and facilities to prepare a defense. F, to be present when being tried, unless the conduct of the accused person makes it impossible for the trial to proceed. And K, to adduce and challenge evidence. These guarantees do not stand alone. They are reinforced and complemented in the specific context of impeachment proceedings by the procedural rights expressly conferred by Article 145.5 and 145.6b of the Constitution, which provide as follows. 5. The President shall have the right to appear and be represented before the special committee during its investigations. And in 6b, that Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. To the foregoing must be added Article 47 of the Constitution, which guarantees every person the right to fair administrative action that is lawful, reasonable, and procedurally fair. That right is not confined to purely judicial proceedings. It attaches to any exercise of public power that affects a person's rights, interests, or legitimate expectations, and it applies with full force to the impeachment process before a decision to remove is taken. The Supreme Court in Sonko reaffirmed this position, holding that during the process of removal, both the right to fair administrative action under Article 47 and the right to a fair hearing under Article 50 accrue to the office holder whose removal is sought. This court reads that holding as applying with equal force to His Excellency Gachagua in the present proceedings. The Supreme Court further held that while impeachment is a political process, it is equally subject to constitutional discipline and the principles of natural justice, and that courts will not interfere with the merits of Parliament's decision unless a violation of fair hearing rights or procedural improprieties established. These two propositions together define both the standard the Senate was required to meet and the scope of this court's supervisory jurisdiction in assessing whether it did so. Against that framework, we turn to the specific circumstances of the present case. It is clear that during the proceedings, the National Assembly, as the prosecuting party in the Senate proceedings, presented its case through witnesses who were examined in chief and subjected to cross-examination in the full and formal sense of adversarial proceedings. There is no controversy about this fact. The petitioners contend that the Senate's refusal of the adjournment application denied His Excellency Gachagua equality of arms and equal protection of the law by preventing him from participating in the oral proceedings at the precise stage when his own evidence was to be led. The constitutional right to equality of arms has been expressly affirmed by the Court of Appeal in Olo versus Kisumu County Assembly Service Board and another, when the court cited with approval the following passage from Pinnacle Project Limited versus Presbyterian Church of East Africa, Gong Parish, and another. I quote, "Fair trial in civil cases includes the right of access to a court, the right to be heard by a competent, independent, and impartial tribunal the right to equality of arms, the right to adduce and challenge evidence, the right to legal representation, the right to be informed of the claim in advance before the suit is led, the right to a public hearing, and the right to be heard within a reasonable time. The question in the present case is not whether H.E. Gachagua was given any opportunity to be heard. From the evidence before us, he was. The precise and constitutionally significant question is whether, having been partially heard, the remainder of his participation was unlawfully curtailed at the point when the opposing party had already completed a full adversarial presentation. The National Assembly had presented its case in its entirety, its witnesses had testified, been examined, and cross-examined. His Excellency Gachagua had not completed his. It was at that precise point of procedural imbalance, with the scales of participation tilted irrevocably in favor of one party, that the Senate refused the adjournment and proceeded to vote. That is not a case of a party who was heard and then outvoted. It is a case of a party who was prevented from completing his hearing after his opponent had completed his. What we heard the petitioners to be saying is that His Excellency Gachagua critically was not merely a respondent who had filed documentary evidence. He was, on the uncontroverted evidence before this court, his own sole witness. He was the only person who could speak to the facts from his own personal knowledge, give a first-hand account of the allegations before him, and submit himself to cross-examination in a manner that would have allowed the Senate to assess his credibility directly. The respondents relied on the Court of Appeal's decision in Kenya Revenue Authority versus Murgani, a 2010 decision, for the proposition that fairness does not always require an oral hearing, and that provided a body achieves the degree of fairness appropriate to its task, the manner in which it proceeds was a matter for its own institutional judgment. Drawing on local government vote versus Aldridge, as well as the case of Selvarajan versus Race Relations Board and R versus Immigration Appeal Tribunal, the Court of Appeal in the Murgani case concluded that a hearing conducted by way of written exchange may, in appropriate circumstances, constitute a fair hearing. We do accept that general principle as binding on us. However, Murgani is plainly distinguishable on the facts and context that are both material and decisive. That case concerned an administrative determination in which no oral proceedings had been conducted at all. Both parties were in a position of formal procedural equality. The written process was the established mechanism, and the question was simply whether the absence of an oral hearing was fatal to fairness. The present case is fundamentally different. The Senate did not choose at the outset to proceed by way of written submissions alone. It had agreed to a fully adversarial oral hearing with witnesses, examination in chief, and cross-examination. Having adopted that mode of proceeding, the Senate could not, at the moment His Excellency Gachagua was to take the stand as his own sole witness, abandon the adversarial framework it had established for itself without satisfactory reason. To do so was to apply different procedural standards to the two parties. That disparity is the antithesis of equality of arms and is irreconcilable with the constitutional guarantees of Article 47 and Article 50. The Hansard record of the Senate proceedings of 17 October 2024 confirms that following the confirmation by Paul Mwita Senior Counsel to the House that His Excellency Gachagua had been taken ill, several senators who rose to comment explicitly acknowledged on the floor of the Senate that H.E. Gachagua was unwell. Not one of these senators disputed the illness. They acknowledged it and then proceeded, notwithstanding that acknowledgement, to oppose the adjournment application. The circumstances must also be taken within the directions issued by the Speaker of Senate at the time. The Honorable Speaker stated in part as follows, I quote, "As this process is time-bound by the Constitution to be concluded in not more than 10 days pursuant to Article 145 as read together with Article 150 of the Constitution, and noting that the period provided for ends on Saturday the 19th of October 2024, the only window open to the Senate, if it is so obliged, the requests for adjournment sought by counsel for the Deputy President would be to gazette Saturday the 19th of October 2024 as a further and final day for hearing of this matter. Honorable Senators, ladies and gentlemen, such a request is not made to the Speaker but to the Senate and is accordingly a matter for the Senate to determine. To facilitate this decision, I direct the Clerk of the Senate to circulate a supplementary order paper incorporating a notice of motion and a motion for adjournment sought. This being a procedural matter, the motion, if carried, will result in the Speaker gazetting Saturday the 19th of October 2024 as a sitting day to conclude the hearing and determination of this matter. This being the last day allowed by the Constitution of Kenya for these proceedings to conclude. I close the quote. The Speaker's communication meant that it was in fact open to Senate to adjourn the sitting up to Saturday. The significance of that course of conduct cannot be overstated. The Senate, despite having the option to adjourn and having expressly acknowledged the incapacity of the party before it, nonetheless proceeded to determine his fate in his absence. That was not a proper exercise of constitutional discretion. It was a negation. We are convinced that had the Senate exercised its discretion genuinely, open-mindedly, and with a conscientious regard for the constitutional rights of His Excellency Gachagua, and had it directed its mind to the miscarriage of justice that its refusal was plainly going to occasion, this was a case in which the circumstances unambiguously called for an adjournment to be granted at least to the next day. That conclusion is firmly supported by the Court of Appeal's pronouncement in Kariuki versus Attorney General, a 2014 decision, where the court held as follows, again I quote, while bearing in mind that whether to grant an adjournment or not is discretionary, and appellate courts are loath to readily question the exercise of discretion by the trial court, nevertheless, it must never be forgotten that the right to an adjournment to enable a party to adequately prepare his or her case in a criminal trial is underpinned by no less an instrument than the Constitution. The authorities cited above relate to exercise of discretion to grant or refuse an adjournment in a civil dispute. We are of the opinion that although the same principles are relevant in respect of applications for adjournment of criminal trials, nevertheless, Because of the constitutional basis of that right and the potential impact on a citizen's liberty, the court is obliged to be more circumspect in rejecting an application for adjournment and to specifically consider whether denial of such a right guaranteed by the Constitution would result in miscarriage of justice. In denying the appellant's application for adjournment, the court-martial in that particular case also did not address its mind to the critical question of whether denial of the adjournment would occasion a miscarriage of justice. In Job Obanda versus Stage Court International Services Limited and another, this court, that is the Court of Appeal, was emphatic that where, amongst others, a judge fails to apply his mind to the question whether a miscarriage of justice might be occasioned to a party who is refused an adjournment, that would constitute sufficient basis upon which an appellate court would be entitled to interfere with the exercise of jurisdiction, close of quote. We say so with a full appreciation of the non-derogable nature of the right to a fair trial. It is not a right that yields to constitutional timelines or political exigencies. It is an absolute constitutional guarantee, and its violation cannot be justified by reference to any competing constitutional interest, however weighty or pressing that interest may be. This finding becomes even more compelling when one considers the Senate's misdirection in its interpretation of Article 145(4)(b). Senate appeared to imagine that it had 10 days within which to dispense the impeachment hearing itself. Yet, the text and structure of that provision, according to us, make it clear that the 10-day period was intended to apply exclusively to the special committee once constituted. We have addressed in detail our understanding of Articles 145(3)(b) and 145, sub-article 4 to 6 in the preceding section of this judgment, and we do not propose to repeat that analysis again here. Finally, we wish to make brief observations on the affidavit of Dr. Daniel Kibuka Gikonyo, sworn on the 28th of April 2026, which was admitted into evidence by leave of this court and tested by cross-examination when Dr. Gikonyo attended to give oral testimony. There is no doubt that the affidavit was not before the Senate on the 17th of October 2024 when the request for adjournment was made. And on that ground, we do agree with Senate's submission that it could not have informed the House's determination at the time. The affidavit was additionally filed almost 2 years after the petitions were instituted, and no explanation was offered to us, including by Dr. Gikonyo himself, for that delay. For those reasons, we do not attribute significant probative value to it. The circumstances, as we have analyzed, were independently and collectively sufficient to warrant a reasonable adjournment. Dr. Gikonyo's evidence neither adds nor detracts from that conclusion.
In conclusion, therefore, upon careful consideration of the consolidated petitions, the responses filed, the submissions of counsel, and following our deliberations and analysis, we now pronounce ourselves on the issues presented. On jurisdiction, we hold that the impeachment proceedings challenged herein are justiciable. This court possesses jurisdiction under Articles 22, 23, and 165 of the Constitution to determine whether the National Assembly and the Senate acted within constitutional bounds, complied with constitutional procedures, respected constitutional rights, and remained faithful to the constitutional safeguards governing the impeachment of a deputy president. On allegations of bias, the allegations of bias, predetermination, and conflict of interest advanced against the speakers, members of parliament, and senators are unsubstantiated. They rest on political inference and suspicion rather than objective evidence capable of satisfying the required threshold. On public participation, we are satisfied that the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua met the constitutional threshold. The Senate did not violate Articles 10 or 118 by failure to conduct its own independent public participation. We further hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149, Sub-Article 1. Constitutionality and legality of standing orders. We find and hold that the impugned standing orders of the Senate and the National Assembly are not unconstitutional. Composition of the National Assembly, role of IEBC, and nomination of the Deputy President. We find that while the failure by Parliament to enact legislation on the gender rule remains a constitutional concern, this court has recently clarified in the Conchella and others decision that the remedy under Article 261 is still available and must be pursued through the proper procedural channels. Consequently, it would be premature to hold that the National Assembly was improperly constituted for purposes of considering the impeachment motion. We find that no input or intervention by the IEBC was constitutionally required in the midterm replacement process under Article 149, Sub-Article 1. The absence of IEBC involvement did therefore not render the nomination or filling of the vacancy unconstitutional. The gazettement of the Senate resolution, the President's nomination of His Excellency Kindiki, and the National Assembly's approval did not contravene the Constitution merely because they were undertaken expeditiously. We therefore affirm that the nomination and appointment of His Excellency Kindiki as Deputy President was valid. Constitutional processes. We find that Parliament ought to urgently enact a dedicated statutory framework for the removal of the Deputy President under Article 150. The phrase, in quote, with the necessary modifications, is a substantive constitutional directive requiring Parliament to adapt the presidential removal framework to the distinct constitutional position of the Deputy President. However, the absence of such legislation does not vitiate the impeachment process already undertaken. We further hold that under Article 145, the Senate was at liberty to conduct the trial either by way of plenary or through special committee. The right to fair trial under Article 47 and Article 50, we find that His Excellency Gachagua's rights were infringed when the Senate declined to allow an adjournment. This violation constitutes both a vindication of his rights and a recognition of the constitutional infirmity in the process, but does not undo the impeachment itself, given the finality of Article 145, Sub-Article 7, and the constitutional absurdity that would arise from dual incumbency. The Constitution is the grundnorm, and where that grundnorm deliberately and unequivocally withholds authority from the court, such limitation must be respected.
I will deal with the aspect of remedies. Before pronouncing our final orders, we deem it necessary to first address the nature of remedies sought and to explain their constitutional foundation. This court has been invited to grant various reliefs arising from the partial success of the consolidated petitions. Our jurisdiction to issue such reliefs is firmly anchored in Article 23 of the Constitution, which empowers the court to grant appropriate remedies for the enforcement of rights and fundamental freedoms. These remedies include declarations of rights, injunctions, conservatory orders, declaration of invalidity of any law that denies, violates, infringes, or threatens a right or fundamental freedom in the Bill of Rights and is not justified under Article 2, Sub-Article 4, orders of compensation and orders of judicial review. The courts have over time provided guidance on the considerations applicable in granting constitutional reliefs. In affirming that a court is not confined to the remedies expressly enumerated under Article 23, the Court of Appeal in Total Kenya Limited versus Kenya Revenue Authority 2013 reported, held that even where specific reliefs are expressly provided, a court is not precluded from issuing any other orders under the inherent jurisdiction, as long as such orders are necessary to ensure that justice is done between the parties. In the same vein, the High Court in Simeon, Kioko, Githeka, and 18 others of the county government of Machakos and others, held that Article 23 of the Constitution does not expressly bar the court from granting conservatory orders where the constitutionality of legislation is challenged. Similarly, in Republic versus Ex parte, Chudasama, the court emphasized that courts retains inherent jurisdiction to fashion appropriate remedies to secure the ends of justice. Speaking to the nature of appropriate reliefs, the Constitutional Court of South Africa in Force versus Minister of Safety and Security said as follows, and I quote, appropriate relief will in essence be relief that is required to protect and enforce the Constitution. Depending on the circumstances of each particular case, the relief may be a declaration of rights, an interdiction, an interdict, a mandamus, or such other relief as may be required to ensure that the rights enshrined in the Constitution are protected and enforced. If it is necessary to do so, the courts may even have to fashion new remedies to secure the protection and enforcement of these all-important rights, end of quote. Regarding declarations and damages for constitutional violations, the Court of Appeal in Gitobo, Imanyara, and others versus Attorney General, report in 2016, emphasized that constitutional remedies are not confined to declarations alone, but may extend to compensatory relief where rights have been infringed. The court observed that damages serve not merely as recompense to injured party, but also as a means of vindicating the Constitution itself, and ensures that violations are met with effective and meaningful redress. In referring to Lord Nichols at paragraph 18 and 19 of that decision, the Court of Appeal affirmed the position that, and I quote, when exercising this constitutional jurisdiction, the court is concerned to uphold and vindicate the constitutional right which has been contravened. A declaration by the court will articulate the fact that the violation, but in many cases, more will be required than words. If the person wronged has suffered damage, the court may award compensation. The comparable common law measures of damages will often be a useful guide in assessing the amount of this compensation. But this measure is no more than a guide, because the award of compensation under Section 14 is discretionary, and moreover, the violation of the constitutional right will not always be conterminous with the cause of action at law. An award of compensation will go some distance towards vindicating the infringed constitutional right. However, how far it goes will depend on the circumstances, but in principle, it will not suffice. It may not suffice. In fact, that the right is violated was a constitutional right adds an extra dimension to the wrong. An additional award, not necessarily of substantial size, may be needed to reflect the sense of public outrage, emphasize the public outrage, emphasize the importance of the constitutional right and the gravity of the breach, and to deter further breaches, end of quote. All these elements have a space in this additional in the additional award. Redress in section 14. Sorry, that's still the quotation which I did not go through it. In this present case, and against this background, and having found that the rights of His Excellency Gachagua, were infringed, it is our considered position that declaratory relief and reasonable damages ought to be granted, not only to address the injuries suffered, but also to vindicate the Constitution and deter future violations. We now turn to examine the efficacy of the other reliefs. The petitioner sought an extensive range of remedies. In total, 49 declarations were prayed for, distributed across several thematic areas. 9 declarations relating to public participation, 15 declarations relating touching on the impeachment, motion, and process, 3 declarations on the fair hearing and due process, 3 declarations concerning the Senate proceedings and committee process, 2 declarations on standing orders, 1 declaration on the National Assembly and the gender representation, 8 declarations on the appointment of His Excellency Kindiki as Deputy President, 5 declarations on the vacancy in the office of the Deputy President and the nomination process, 2 declarations on violation of voters' rights, and 1 declaration regarding the members of the NIS. Beyond declaratory relief, the petitioners also sought 5 orders in the age of certiorari, 2 orders of mandamus, and 2 injunctive orders. They further prayed for reinstatement of His Excellency Gachagua to the office of Deputy President, an order for apology and cause. In addition, there was an elaborate prayer for damages and compensation. In considering the relief sought, it is evident that the two prayers have become moot. The first is the injunction that seeks to restrain the President, National Assembly, and any other state organ from proceeding with or effecting the appointment of any person to the office of the Deputy President pending the hearing and examination of the petitions. The second is the conservatory order restraining the respondents from collecting signatures, lodging any motion, or conducting any proceedings seeking to impeach the Deputy President. For clarity, these prayers are disallowed. Regarding the relief seeking the reinstatement of His Excellency Gachagua as the Deputy President of the Republic of Kenya, we do note that His Excellency Gachagua, through his pleadings and submission by his legal team, expressly abandoned the quest for reinstatement and indicated that he was no longer interested in pursuing it. Nevertheless, since other petitioners continue to press for the said relief, it remains necessary for this court to pronounce itself on the matter. Article 145, subarticle 7 of the Constitution provides as follows, I quote, if at least 2/3 of all the members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office. This provision speaks to the finality of the Senate's resolution once it upholds an impeachment charge. Upon such resolution, the President or Deputy, as the case may be, stands impeached and ceases to hold office. The constitutional text is categorical that the cessation of office is automatic and does not require any further act of implementation. The impeachment resolution, once validly passed by the Senate, is self-executing and a fait accompli. The constitutional design is deliberate in this respect. It does not envisage an instance where the impeached president or deputy president may be reinstated within the framework of the presidency. The vacancy resulting from the impeachment resolution can only be filled through the procedure under Article 149, Subarticle 1. Even in the unlikely event that Parliament and the President wish to return the impeached office bearer, such a cause will still be subject to the availability of the vacancy and the nomination process prescribed by the Constitution. To hold otherwise presents profound constitutional and practical difficulties. The office of the Deputy President is not merely a matter of judicial declaration, but is intertwined with constitutional processes, political accountability, and the functioning of the executive. To order a statement in circumstances where the vacancy has already been filled would amount to the court usurping powers reserved to the people and their representatives under the Constitution. It would upset the delicate balance of separation of powers and create a constitutional absurdity, for the Constitution does not envisage two serving deputy presidents at any one time. The court cannot undo what the Constitution itself declares to be conclusive. Reinstatement, therefore, is not a viable or appropriate relief in the circumstances of this matter. Before leaving this subject, we find it necessary to acknowledge and comment on the doctrine of constitutional dilemma that arises in these proceedings from the tension between the constitutional finality of impeachment and the vindication of rights. This tension is highlighted by the comparative jurisprudence, most notably in the United States, where courts have adopted a principle of total avoidance, treating impeachment as non-justiciable. Yet our own constitutional framework demonstrates that avoidance cannot resolve the question that persists. In view of the recurring tension, a constitutional amendment clarifying the scope of impeachment finality and the role of judicial review may be warranted. At this juncture, we also find it necessary to distinguish the process of removal of a county governor from that of the president and the deputy president. To begin with, Article 181 of the Constitution sets out the grounds upon which the county governor may be removed from office. They are gross violation of the Constitution or any other law, B, serious reasons to believe that the governor has committed a crime under national or international law, C, abuse of office or gross misconduct, and D, physical or mental incapacity to perform the functions of the office. Article 181, subarticle 2, assigns Parliament the responsibility of enacting legislation to provide for the procedure for removal of a county governor. That legislation is the County Government Act, which we'll be referring to as the County Act in this discussion. And Section 33 thereof prescribes the detailed procedure. It provides for initiation of a motion in the County Assembly, transmission of the resolution to the Senate, investigation by a special committee, the governor's rights to be heard, and ultimately a vote by the Senate delegations. If upheld, the governor ceases to hold office. If rejected, the motion may only be reintroduced after 3 months. When this process is juxtaposed with the removal of a president and deputy president, and Article 144 and 145, several key differences emerge. First, whereas the president and the deputy president may be removed either on grounds of incapacity or impeachment, a county governor is removable only on the 4 grounds enumerated in Article 181. Section 33 of the County Act, however, introduces impeachment terminology, thereby expanding the constitutional parameters in a manner that is troubling. Second, the removal of the president and the deputy president is provided for directly in the Constitution, while the removal of a governor is legislated under the County Act. This distinction is critical. Under Article 2, subarticle 4, legislation is subordinate to the Constitution and may be declared unconstitutional by a court, whereas constitutional provisions themselves cannot be impugned. Thus, while the Senate vote under Articles 144, subarticle 10 and 145, subarticle 7 is final and beyond judicial review, the Senate vote under Section 33, subsection 7 of the County Act is susceptible to challenge. Courts may proceed to stay and quash a resolution to remove a governor and even halt the filling in of the vacancy. But such judicial interventions cannot be imagined in the case of a president or the deputy president. Third, the manner of filling in the vacancies also differs. Under Article 149, a vacancy in the office of the deputy president is filled by presidential nomination and voting in the National Assembly, whose vote stands final and is self-executing. By contrast, the Constitution does not prescribe how a vacancy in the office of deputy governor is filled. Section 32D of the County Act provides for nomination by the governor, approval by the county assembly, and appointment thereafter. This statutory process, unlike the constitutional one, is amenable to judicial review and may be stayed or quashed. It is therefore on account of these glaring differences that this court cannot apply mutatis mutandis, the jurisprudence on removal of county governors to the removal of the president or deputy president. We nonetheless affirm that where binding judicial findings on governors' removal are squarely applicable to issues before us, we cannot run away from the same. This includes the pronouncement by the Supreme Court on the second case on the choice between plenary or special committee. In sum, therefore, whereas Article 144 and 145 embodies what may be termed as constitutional finality, the provisions of the County Act represent a form of statutory finality, thereby actuating the distinction between the two. We now turn to His Excellency Gachagua's quest for pension and emoluments under Retirement Benefits Act. The preamble of the Act makes clear that it is an act of Parliament to provide for granting of pension and other emoluments, retirement benefits to persons who hold the office of Deputy President and persons who have served as Prime Minister, Vice President, Speaker, Deputy Chief Justice, or Chief Justice after 1st of January 1993 and for connected purposes. Section 7 of the Act provides for the pension and other benefits of a retired Deputy President or a retired Vice President. Section 2 defines a retired President as a person who, having held the office of Deputy President, has ceased to hold office as such in the manner specified in the Constitution. The interpretive question that arises is whether a Deputy President who ceases to hold office by reason of impeachment can be deemed a retired Deputy President within the meaning of the Act. Whether courts can legitimately interpret impeachment as retirement is a weighty and novel question. None of the parties address us on this issue. We are therefore of the considered position that it is not properly before us to pronounce ourselves on the same, for that will be presumptuous and will amount to stepping beyond the pleadings and the submissions of the parties. Accordingly, we decline to make any findings on this point. The parties are at liberty to pursue the matter further. An order of mandamus was sought to compel the National Assembly and the Senate to promulgate a constitutionally compliant procedure for removal of the Deputy President by impeachment. We find this prayer to be merited. For clarity, the lack of such legislation per se does not, however, impugn the instant impeachment proceedings. Next, having found that the fair trial rights of His Excellency Gachagua were infringed when the Senate declined to allow the adjournment, that is a vindication of His Excellency Gachagua. We, however, hasten to add that the violation does not have the effect of quashing the Senate's resolution to impeach His Excellency Gachagua for precisely the same reasons we have provided with respect to the finality of the impeachment process. If the Senate's resolution were to be quashed or set aside, then by operation of law, the status quo ante will be restored, thereby effectively creating a scenario where there will be two deputy presidents in office at the same time. The impeached deputy president, reinstated by judicial fiat, and the successor duly appointed under Article 149, Sub-Article 1. We have no doubt that Kenyans did not intend such scenario, and the Constitution does not contemplate dual incumbency in the president. Accordingly, while the infringement of fair trial rights is acknowledged and vindicated, it does not undo the impeachment itself. The appropriate remedy lies in declaratory reliefs and damages to vindicate the Constitution, not in quashing the Senate's resolution. In light of the foregoing, that is not to say that His Excellency Gachagua has no constitutional remedies given the violation of his rights. As we said, we are convinced that this is a case where the infractions on the part of His Excellency's right can be adequately vindicated by way of appropriate declarations and damages. Applying Gitobu Manyara's case, it is our position that the violation of His Excellency Gachagua's fair trial rights during the impeachment proceedings calls for a remedy that goes beyond mere acknowledgement. Declaratory relief serves to formally recognize the infringement, while damages will provide redress and underscore the seriousness of the violation. This amount is not intended to compensate for the loss of office, but rather to vindicate the Constitution, restore the dignity of the affected party, and deter similar infractions in future impeachment proceedings. Lastly, we find that since most of the prayers sought in the consolidated petitions have failed, coupled with the public interest nature of this matter, parties herein ought to bear their respective course. Given that the Gitobu case was resolved a decade ago with Mr. Gitobu receiving damages of 15 million, the lapse of time justifies an upward adjustment of the award.
These are now the final orders. Arising from all that we have said, these are the orders that we make. 1, the prayer seeking to quash the resolution of the Senate to impeach His Excellency Gachagua is hereby declined. 2, a declaratory order is hereby issued that His Excellency Gachagua's fair trial rights were infringed when the Senate declined to allow an adjournment in the impeachment proceedings despite his absence. 3, a declaratory order is hereby issued affirming the constitutional necessity for Parliament to enact a dedicated statutory framework governing the impeachment of Deputy President under Article 150 of the Constitution. 4, the court makes no findings on pension and emoluments. The first petitioner is at liberty to pursue the matter before an appropriate forum. 5, the court awards constitutional damages of Kenya shillings 50 million to His Excellency Gachagua payable by the Senate to vindicate the Constitution, restore the dignity of the affected party, and deter future violations. 6, parties shall bear their own costs given the public nature of these proceedings. And lastly, for the avoidance of doubt, any prayer not expressly allowed herein is accordingly disallowed. Before we take leave of this matter, we wish to record our appreciation to all counsel who appeared in these proceedings and all parties for their industry, diligence, and the quality of their submissions. Your collective effort has contributed to the development of constitutional jurisprudence on this subject. We also extend our gratitude to the judiciary staff who worked tirelessly to support the bench in ensuring that this decision, the first of its kind under the Constitution 2010, was rendered in time. Thank you very much.
When her leadership, the Justice Dr. Mugambi was reading part of the judgment, if I heard correctly, she said that the 10th respondent, UDA, filed written submissions on 28th August 2026. If my hearing is correct, then quite manifestly that is a typo that the court might wish to correct. Secondly, the first petitioner applies to have a copy of the judgment, one, and two, typed copies of the proceedings, and three, a complete set of the video recording of the proceedings. We would wish to have those as quickly as possible, of course, upon payment of the necessary court fees. It's a long judgment, and I am sure the first petitioner will want to be advised once we as council understand each of the issues addressed in the judgment. This honorable court has rendered its opinion, so there is nothing to be raised with this honorable court. But once we understand each issue by reading the judgment, the proceedings, and the video recording, we will then be in a position to advise the first petitioner, for example, on whether to pursue his other rights, as this court has indicated. I thank the court.
Thank you.
May it please you, my lords, my lady. Njeri Maina for the third petitioner. I wish to request for the typed certified proceedings, the certified judgment, and my lords, my lady, for the tidiness of the proceedings, I request on behalf of all other petitioners in this matter. The third petitioner has already filed their notice of appeal. We request that you expedite the proceedings and the judgment so that we can take it on from here. Thank you.
My Lord, my name is Dave Anjiru. I have sat here for approximately 10 hours listening to this judgment. I certainly have heard you clearly and the disposition. Equally, despite it being the judgment of the court, I do not agree with some of the issues that the court has deliberated and the conclusion the court has arrived at. And most importantly, my Lord, when we came before you, we only did not just come for judicial recommendations on legislations. We thought that, my Lord, will leave this court with a clear judgment on how a violation ought to be dealt with. When we came before you, my Lord, and we moved you, most importantly, on the issues of constitutionality of the manner in which the proceedings were conducted, we did not come here for a remedy of a legislation. It will not benefit my clients whatsoever. And for that reason, my Lord, and granted the dissatisfaction with your judgment, I have equally advised my clients for the 4th, the 49 petitioners to launch and prefer an appeal. For that reason, my Lord, would wish to be supplied with certified copies of the proceedings, the judgment, and the transcript. And for the reason, my Lord, that we need the transcript is that, my Lord, part of what was delivered by Justice Murima when he was deliberating on the issue of the plenary and the committee, I can tell you, I had never heard what he said and what he concluded. I therefore, my Lord, would wish to have the transcript provided in verbatim, so that, my Lord, we're able to deliberate and internalize them. We are otherwise not dissatisfied. We are otherwise dissatisfied, and we shall not watch when the Constitution is being buried. Thank you.
Your Lordships, my lady, my name is Gachagua Dhuta for the 10th to 41st petitioners. And my Lord, I would like to request for the same materials that Senior Counsel Paul Mwita has requested for. Thank you, my Lord.
My lords, my lady, I do associate myself with the submissions of fellow councils. My lord, there is a new twist into our constitutional declaration that we find a breach has been made, but then no outright remedy to that breach. My lord, if the Constitution has been breached, then clearly it means then the Senate where I sat and I followed the proceedings, it means that it didn't do its duty as required by the Constitution. So we wish to appeal and we wish to be supplied as quickly as possible. We pay. My name is Daniel Manzo for third interested party. We will wish to be supplied with all the necessary proceedings certified so that we could advise our clients appropriately. I thank you, my lord.
My lords and my lady, my name is Sakimpa. I do appear for the 4th to 8th petitioners. Your lordship, we do confirm that we've already received instructions from our clients to appeal, and we have since filed our notice of appeal, and we request for the typed proceedings to be urgently provided. Thank you.
My Lord, I'm equally instructed by Kibe Mungai to make the same application. He has equally instructed me to inform the court that it's important that we don't preside over the funeral of our Constitution.
My lords and my lady, I'm Phyllis Wangui Kamau, appearing for the 43rd petitioner, and I wish to associate myself with the submissions of Senator Manzo because the decision finds us in a constitutional absurdity. And for that reason, we do wish to appeal, and I join my sister, Honorable Njeri, and Senior Counsel Mwite to request for the type proceedings and the judgment. Thank you, my lords and my lady.
If it may please you, my lord, my lords and my lady, I'm Omanyi for the 57th petitioner. I think there was also a mistake with regards to the 57th petitioner. As the court was reading the judgment, it said that we had not filed our submissions and did not appear during the hearing, yet we appeared. So I think that is a mistake that the judgment and the court can correct the same. We also intend to file an appeal against this decision, and we request a copy of the judgment and proceedings, certified copies of the proceedings. Much obliged.
Lord, my lady, I find myself in a very inauspicious position. I commend the proceedings, I close. But my lord, the reason is...
Excuse me, please respect the rights of the parties before the court. You are not before the court. Please sit down. Let's finish this matter or this file. If you have an issue with another file, we'll allow you to talk.
Okay, very well.
On behalf of the respondents, I presume we have no objection to the request for proceedings, and we have no request. We are waiting, my lord, for the appropriate time to respond to the appeals, and so we will wait for them in the Court of Appeal. We are happy to do that. Thank you. Finally, my lords, we just want to thank the court for delivering judgment. I think we've sat here for 9 hours from 12 to now. So we thank you for that, your patience. Thank you.
Mr. Kenyanjui.
Thank you very much, Your Lordship. My Lord and my Lady, I think I prefer them instead of bending.
Are you addressing us on this file or on another file? This file, you are not a party here.
It's because, my Lord, I addressed you.
We cannot mix issues.
Yes, we're not mixing. Because in this file, it is implicated in civil application E291. All these petitions are part of E291. So the proceedings that commence these proceedings are relevant to my client. That's why, my Lord, I was making a similar application when I addressed the court. If I could get an audio transcript, if I cannot get the type, that's okay. I can get an audio. That is necessary for me before the Court of Appeal, so that I can show the Court of Appeal I brought to your lordships and my lady dependency of civil application E291 of 2026. That was limited to only that. Beyond that, I don't want to vex you. It's been a long day. So my request is for the transcript of the commencement of the proceedings up to the point that your lordship then directed that I shouldn't address you any further, because it implicates civil application E291 of 2026. I'm much obliged. Thank you.
So we can hold them within 5 days. 5 days. Thank you very much. The prayers for certified proceedings, certified judgment, copy of judgment, and certified transcripts has been allowed, and you will be given those documents in the shortest time possible. We don't have a problem because all those documents are actually ready. So you should be able to get them within 3 days from now. Thank you very much. I think we can adjourn.
Good night.